Honourable members, good morning, and good morning to our guests, and welcome to Parliament. Some of you are returning, and I suspect we have someone who's coming here for the first time. That would be you, sir. Okay, no, thank you very much. Mr. Letsoalo, Ms. Khumalo, and Ms. Manyasha, welcome. And also happy to see your colleagues at the back who've already been with. They said they came to support the committee, to give moral support to the committee. Yeah. Call a friend. So thank you very much. What I will do is I will ask Ms. Ibrahim to explain the rules of Parliament to all of you and the rules for this committee. But before we do that, because I think it's particularly important, this is actually particularly, it's for both the members. This update I'm going to give is for both the members as well as our witnesses today and in future, because this is important in the context of what Ms. Ibrahim is about to do. So the board of the Road Accident Fund, the interim board, appeared before the Portfolio Committee on Transport. I think it was last week, if I recall, and at that appearance, there are some Road Accident Fund staff who've been placed on precautionary suspension, and I reached out to the chair of the board and just asked for an assurance that particularly in the case, because I think the chief financial officer has appeared before the committee, that it's not because of something that she said before the committee here. That's important, because when people take an oath here, as you will see when Ms. Ibrahim is explaining the rules, one of the things we do say is that what you say here cannot be used against you, either to charge you criminally or whatever the case might be. But Ms. Ibrahim will explain, or that when you get back to work, somebody says, you said the following and therefore, right? I just want to let you know as our witnesses, but also the members, that we take that part of our responsibility very seriously, hence reaching out to the chair. The chair assured me that it's not, but I have nonetheless asked for a written explanation, setting out what happened. We're not reviewing the case, but we just want to be certain that it's not because of something that somebody said here. So I just want to assure all three of you that we take that responsibility seriously, and we will take all reasonable steps to ensure that it does not happen. Hence, I was quick to reach out to the chair to just seek clarity to be certain. So, yes.
Yeah, just on that point, Chair. So did the chair of the just to confirm, you're saying the chair of the board confirmed that the suspension of the CFO had nothing to do with what was said here. That's one. But also, did he then give you anything in writing? Because at the Portfolio Committee of Transport, Chair, and you are correct, because I also sit in that committee, we are seized with this matter. And it's the board that has told us that the suspension was taken, but for a later date. And then when they come to us, something would have happened between their meeting and the Portfolio Committee meeting that would have warranted them to then do the suspension. So if it had nothing to do with what happened here, I would like for you to get that in writing, so that when they come to us and explain that, because they must be able to tell us what then changed their board resolutions. So that we'd like to have in writing, Chair, so that we can follow that matter up. Thank you very much.
Thank you. No, in fact, I have asked for a written explanation. We will share it with the chair of the Portfolio Committee on Transport when we get it. But I just want to assure you that we really take that responsibility seriously, and so please feel free to speak candidly to the committee members. If in future we also suspect we will intervene. So just so that just to provide you with that assurance, because I don't want us to make an undertaking here and then it does not, it is not fulfilled. So Ms. Ibrahim, can I please hand over to you to assist our witnesses with swearing in.
Thank you, Chairperson. Good morning to yourself, Chair, all the honourable members and everybody else present today. Good morning, Ms. Manyasha, Ms. Khumalo, and Mr. Letsoalo. You've been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, read together with National Assembly Rule 168, which affords certain protections to witnesses, to appear before the Standing Committee on Public Accounts in connection with the committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. You will now be required to take an oath. That has been the indication of the preference from the witnesses today, and I'll start. In fact, I'll do it all at once to save time. If I can ask all three of you to please raise your right hand and then repeat after me. If you can please turn on your mics. Thank you. I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth, the whole truth, and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, Chair. The witnesses are now duly sworn in. Chair, we also have present with us today Mr. Phillips and Mr. Baloy, who previously appeared before the committee and were duly sworn in. For purposes of the record, I'm just confirming that they remain sworn in to the extent that they may be required to answer any questions during today's proceedings. Thank you.
Thank you very much, but we won't drag you onto the proceedings without a good reason. We'll try not do that. Okay, so please don't worry. Let me just make some points to our witnesses. So first of all, this is not a trial, so none of you are on trial. We will not make a finding of guilty against anyone. We are trying to understand what happened, what went wrong, how we got to certain outcomes, processes of decision making, the level of due diligence and care taken or not taken, and the impact of those decisions on the financial outcomes of the road accident fund in particular. So that is the first thing. The second thing, which I also need to say, is that to the extent that we get into matters of employee relations, it's not to review any of those cases. We're not dealing with that. Our particular interest in ER matters is the expenditure thereon. So, which also then relates to the financial implications for the road accident fund. So that's important. There may also be other cases where we're dealing with other matters which may be in play still and so on. Our intention is not to say no, those we can't supersede those processes. We're running our own process here, and what is happening elsewhere is happening elsewhere because of separation of powers. But that said, I also want to be clear that we're not reviewing those cases either. We're looking at matters relating to governance and the impact thereon and the financial impact thereof on the road accident fund. I would encourage you not to speculate on anything. If you don't know or you were not there, just say so. Unless you are asked for your opinion, then it's clear that it is your opinion, right? But try and not venture into the area of speculation because we go down a rabbit hole and then we ask for proof and then you don't have it because you were not there and a colleague told you later over lunch that something happened yesterday. That typically does not serve our purposes because it's difficult to reach a conclusion with that kind of information. If there is information that you don't have to hand, like a document that you do not have to hand, you can simply say that, maybe the committee can consult a particular document, or we should ask the Road Accident Fund, or we can assist to make sure what we are interested in is the information itself. Some of the matters we are dealing with happened years ago. I don't think it's possible for any of us to remember details exactly in terms of what happened on a particular day, or whether it was a Tuesday or a Wednesday. What we are interested in is the substance of what happened, and to the extent that you can recall, just say you can recall. If you're not sure, you can say, look, I'm not sure, but I think this is what happened. So by way of guidance, when the members ask questions, all of us, try and keep your answers as concise as possible, because we also, I'm hoping that we can all get through the proceedings for today long before 9 o'clock. Okay, so if we can leave here before sunset, I would be very happy, and I think all of us would be happy, right? So what I will do in the beginning is to just ask some introductory questions of all of you. They will typically be similar, and that is to just orientate the members. They've got a briefing document that says who you are, but it's just additional information that I am going to ask. And then in addition to that, I will then ask on some of the themes that we're going to deal with today, not all of them, not in great detail, but is to introduce each of the subjects that we're going to be talking about. So that's what I will do in the beginning. So with your permission, what I will ask of all of you, each one of you, we'll start with you, Mr. Letsoalo, is to just give us a brief background on yourself, when you joined the Road Accident Fund, the functions you have fulfilled, and what your latest role at the Road Accident Fund is. So I will just ask each of you to just take turns to do that, to introduce yourselves to the committee.
Thank you, Chair, and good morning to you all honorable members of this committee. My name is Letsoalo, as it has been already alluded to. I joined the Road Accident Fund technically on the 1st of January 2019. I think it was a Saturday or Sunday. That's what I'm saying technically.
Move the mic a little bit closer to you.
Okay, yeah. I'm saying technically because I think on the 1st of Jan 2019, that day was a Saturday or Sunday. I was employed as the Senior Manager Employee Relations until September 30, 2024. But I think it is also important for me to state that I left the RAF on the 11th of May 2023 when I was placed on suspension. So technically I would say my last day at work was 11 May 2023, because beyond that I had no dealings with the Road Accident Fund. Insofar as the scope of my work is concerned, I was responsible for the full spectrum of the function employee relations. That would entail your management of discipline grievances, collective bargaining processes, training on ER matters, policy research, review and development, dispute resolution as well at the CCMA, to some extent, the Labour Court. That is in brief, Chairperson.
Thank you very much. Short and sharp. I like it exactly like that. Ms. Khumalo.
Thank you, Chair, and good morning to the honorable members. My name is Khumalo, Khumalo without an H.
We will correct the label. Denzel. Let's make sure it's fixed.
If you go to Rab, you won't get the Khumalo with an H.
Yeah, okay. Yeah. It's Khumalo without an H. Thank you.
Yes, Chair. Thank you. My name is Khumalo, and I'm the Chief Governance, well, I was appointed as the Chief Governance Officer at the Road Accident Fund. We've recently been suspended last week, Friday. So the executives are on suspension. I have, in terms of my qualifications, I've got a BCom from University of Pretoria. I've got various programs. I've got a development program in labor relations from the UNISA School of Leadership, a strategic management and cooperation in governance from UNISA. I've got a women in leadership program from the Yale School of Management, and I've got an MBA from Gibbs. So those are my qualifications, Chair. I've got more than 20 years experience in various senior management roles within government. So I've been purely in government since I started, since fresh from varsity. And I've had a clean record since then, and I hope to keep it like that. Prior to coming to the RAF, Chair, I've worked at the Department of Home Affairs. I've worked at the National Intelligence Coordinating Committee. I've worked at the Road Traffic Management Corporation. And it was during that time, I think a year after I arrived, that Mr. Letsoalo then was appointed as acting CEO. So I started knowing him from the RTMC when he found me there. And I also then subsequently moved and went to Armaments Corporation of South Africa, known as AMSCO. And from AMSCO then I came to the RAF. I started at RAF on the 8th of August, 2022. So 8th of August this year was my third year. At the RAF, I am responsible for 4 units really. That is enterprise risk management, assurance and monitoring, legal services, and well, until recently, until the 22nd of September, I was also responsible for Forensic Investigations Department before the board decided that it will report to the chairperson of the Audit and Risk Committee. So those are the 4 departments that I'm responsible for. And in terms of the approved structure in my department, I've got approved structure is 775 people. Those that I filled is 467. So basically, I have a vacancy rate of 40%. So that's where I am in short. Thank you.
All right, thank you. So later on, as we have the conversation, if it falls within, if a question falls within one of those areas, just explain a little bit where it fits in your own organogram, just to orient it, but you can do it then, so you don't need to worry about it now, so that we can then be orientated in terms of context. Ms. Manyasha?
Good morning. Thank you, Chair. Good morning, Chair and the members. My name is Prudence Manyasha, better known as Mpo. I have joined the Road Accident Fund in 2019 on a secondment basis from the Department of Transport. My qualifications, I've got a bachelor's degree, NQF level 7, obtained in the year 2000. I also have a postgraduate diploma in business administration, NQF level 8, which I obtained in 2019. Other courses that I have is project management from University of Pretoria, strategic management from UNISA, corporate governance from UNISA, monitoring and evaluation from University of Pretoria. In summary, Chair, my career, I'm currently at the department, at the Road Accident Fund as the head in the office of the CEO. It is not an executive position, it's an HOD position. I was recently also, from the 1st of April 2024 up until the end of August this year, appointed as Acting Chief Corporate Support Officer, which is responsible for people management and corporate communication. Before my role at the Road Accident Fund, I was the Deputy Director, Project Management and Financial Administration at the National Department of Transport in the CFO's office. The CFO at the time was Mr. Letsoalo. Before Department of Transport, I was employed by the Office of the Auditor General for a period of 4 months, December 2008 to March 2009. I was the Business Unit Administration Manager in the Corporate Governance Unit at the AGSA. Before that, 2004 to 2008, I was the Office Manager, Legal Governance and Risk Branch in the Department of Public Enterprises. I worked there for 5 years. Before that, I was a personal assistant to a director, financial modeling, at the Department of Public Transport. That is the year I joined government in 2004, as a personal assistant to a Deputy Director, Financial Modeling, under the Restructuring Unit. The director at the time was Mr. Letsoalo. That's the first time I met Mr. Letsoalo at the Department of Public Enterprises. Before that, I worked at a company called Treetops Management Development Consultant. I worked there for 4 years, and before that I worked as a secretary at Kuzaza Investment Holdings, and before I graduated I worked as a receptionist at a company called Phoenix International. Chair, lastly, let me just talk about my secondment roles. In 2010, I was seconded to the Road Traffic Management Corporation. My secondment came as a result of the secondment of the CFO, Mr. Letsoalo. When he was seconded to Road Traffic Management Corporation, he would then request for the secondment of his support office, in the office which was myself and the PA. So we requested to support him in the secondment role. In 2015, I was seconded to driving license car account. Also, the CFO was seconded there, but then I was not seconded immediately. I was only seconded when there was a role that became vacant of the Senior Manager Corporate Services. I was also, when he was seconded to PRASA, he did the same, requested for the secondment of his whole administration support in his office, so I was seconded also to PRASA in that role. My current role in the Office of the CEO, it's executive management support. My role is to manage and facilitate engagements between the CEO as well as internal and external stakeholders, coordinate reporting, manage special projects, and also manage stakeholder relations and corporate social responsibility unit. I think I will end it there, Chair. Thank you.
All right, thank you very much. Can I just ask for clarity? Didn't you, Ms. Khumalo, also play with Chief Corporate Support Officer at all? No? I'm totally mistaken there. Okay, so it's governance and then there's corporate support, two separate roles. Okay. No, thank you very much. Members, you were sent a briefing document. I don't know if you all got it. So we don't have the house this afternoon. So I want to... Do we? We don't have the house this afternoon. So may I propose that in that spirit, but then there will be no injury time, that we allocate each member 30 minutes. Would that be fine? Is that no, you don't have to use it. I'm just saying we should be done by... No. We should be done by 6 if we... So I'm not saying keep asking questions just to run out the 30 minutes. You know, let's do what Honorable Bila does, which is to like stick to time. So that's... Sorry, you want 15?
A proposal, Chair. Can we take 15?
Okay, okay, let's stick to the 20. I see people nodding. So I allocate 20 normally. I say 15 minutes, we always run over. So members always end up with 20 minutes. So
no, Chair, I'm saying we take 15,
right?
You pass, and then you can come back.
Okay. No, that really is fine. So that really is fine. It's a total of 30 minutes. We'll take 15 each, and then you get an opportunity for follow-up. I thought you were complaining, Honorable Maduna, that is too much time. And you want less. Okay, so no, that's fine. I also want to be fair in this. Which way did I start last time? I started there, so I'm now going to start with Honorable Beasley.
Can I come back?
No, you can. Oh, you in another meeting. Honorable Beasley is multitasking. He's fixing the budget at the same time. Okay, no, it's fine. Honorable Nelme, so Denzel is 15 and then the follow-ups are 15. I think that's fair. So I'll start with you, Honorable Nelme. And so to our witnesses again, if we can just keep things concise, no speculation. I think then we'll get through today painlessly. Thank you. Honorable Nelme, please go ahead.
No, thank you. Good morning, Chairperson. Good morning, my colleagues. Good morning to our guests here this morning. No, thank you very much. I think what I'll do is I'll start with Ms. Manyasha and then just one or two questions each as we go through the area. What was the process for recruiting specialists into the office of the CEO? I think that is a question that we have all been curious about. Were qualifications, selection criteria, and approval processes followed? Were there any pre-existing relationships between the former CEO and candidates? And how were potential conflicts of interest managed? I think you did mention in your opening remarks that the recruitment of officials from the previous Department of Transport were sort of recruited. But if you can just give us a little bit of background into the recruiting of specialists. Thank you.
Thank you, Honorable Nelme. My two colleagues that came here, I think in the past 2 weeks, Mr. Barriel and I can't remember who else spoke up on the specialist positions. The positions, as stated, were created and approved in line with the delegations of powers and authority framework as part of the contract positions. All the positions were created for a 3-year fixed-term contract. 7 people were appointed as specialists in those positions, and how they came about was that the CEO, as soon as he arrived at the Road Accident Fund, I think 3 months into the secondment, he identified some gaps in certain areas like finance, supply chain management, ICT. And he then decided that he needed people that can be advisors in his office, liaising with those divisions so that he can quickly get into understanding how the Road Accident Fund works in those areas and get people independently that can advise him in those areas. The positions were created, and there is a submission that I've sent to the committee of the request to establish those positions because they were not in the structure. After the positions were established, the job profiles were then developed, the positions were graded, and then advertised. So initially, I must state, Chair and members, Mr. Letsoalo would have preferred to headhunt those people to be his advisors. However, the Road Accident Fund policy at the time did not have headhunting as a thing that was used. Therefore, the positions had to be advertised, and the people went through interviews and competency assessments, and then they were appointed. Honorable Nelme is asking if Mr. Letsoalo knew the people. As I've stated, he would have preferred to headhunt those people because of the knowledge that he wanted in his office. However, that was not allowed. I can confirm to the committee that some of the people that were appointed in those specialist positions were known by Mr. Letsoalo previously, and some were not known. I think there was 1 or 2 that were not known by Mr. Letsoalo, but I think most of them were known. And in the interviews, we do request candidates to declare if they know somebody in a management position or anyone that works for the Road Accident Fund. And I think those candidates that have worked with Mr. Letsoalo before did declare that they know him and they have worked with him before. I'm not sure if that suffices. Thank you.
No, thank you very much. One other area that I wanted to ask is your secondment from the Department of Transport to the Road Accident Fund. How did that come about?
As I've stated in my introduction, when Mr. Letsoalo was seconded, I was working as an office manager in his office, Deputy Director, Project Management and Financial Administration. That's what the position was called. It's essentially office manager. So when he's seconded to another entity, he would request for the support of his office. So it was for myself and the PA. How secondment works is that he would write to the DG to request for secondment of officials that he would have wanted, and then the DG would then approve the secondment, which was the case in all my secondments, and then the entity that we are seconded to will have to also write to say that we accept the secondment, and then there will be a secondment agreement between the entity and the Department of Transport.
Thank you. So that would have gone for the same recruitment of Mr. Mziza, who informed the committee that he was handpicked for the position, firstly at the Passenger Rail Agency by yourself, and that you were the person who had hunted him for that role. He then further stated that when you later moved to the RAF, you again approached him to join the organization. Can you clarify these circumstances and explain your role in his recruitment at both PRASA and RAF?
So, Honorable Nilme, can I ask, you said Mr. Mziza? Okay, thank you.
Honorable Nilme, you said PRASA and RAF, right? Okay. So at at PRASA, Mr. Mziza was headhunted. It was after there was a security threat on Mr. Letsoalo. Mr. Letsoalo requested that I contact Mr. Mziza because he was still working at RTMC at the time. He requested that I contact Mr. Mziza to find out if he's available to come and assist as a bodyguard. So Mr. Mziza then agreed, and then he was headhunted. A memo was written via HR to approve the headhunting of Mr. Mziza, and that's how he was recruited at PRASA. He was headhunted in the position of bodyguard to Mr. Letsoalo. And at Road Accident Fund, Mr. Mziza was then still with PRASA. Mr. Letsoalo again requested for me to call Mr. Mziza and find out if he's available for assisting at the Road Accident Fund in a specialist position on secondment basis for a period of, I think it was 6 months at the time. Mr. Mziza agreed, and Mr. Letsoalo then contacted this group CEO of PRASA to find out if he'll be willing to release Mr. Mziza to come and assist. They had an agreement. The same process followed, whereby RAF did a memo to the CEO to approve the secondment of Mr. Mziza. Then the CEO wrote a letter to PRASA. PRASA agreed, and then there was a secondment agreement for Mr. Mziza for a period, I think, of, I can't remember if it's 6 months or 1 year. And at the end of that, because the process of finalizing the structure was not done, then there was an extension of the secondment process, again agreed to between PRASA and and RAF, between the CEOs as well as via the HR divisions in both cases. Thank you.
Thank you. The next question is for Ms. Khumalo, and I'd like to ask you, what measures were in place to monitor court proceedings and manage the RAF's legal caseload during your tenure? How do you respond to concerns about the lack of systems in place for this purpose?
Thank you, Chair. Thanks, Honorable Nilme. In terms of monitoring of case loads and court proceedings, what we have is we've got court monitors at certain courts to monitor the court rolls and therefore inform my senior manager to be able to then provide instructions to our state attorneys. We also then, those court monitors are given access to the court online system, so that then they can see the cases that that are applicable to the RAF during those weeks that we have the court rolls. Secondly, in terms of the lack of a system, we've got the LMS system that we are using, where state attorneys are instructed or given instructions to go and represent the RAF. However, we are aware that this LMS system is not as effective as we'd like it to be, and that's why we are busy in the process of procuring a system that will assist us in that regard. But there is a system there, the LMS.
And tell me, what was your role in the litigation against the AGSA? Did you provide internal legal advice on this matter? And how did you address the Transport Ministry's directive to withdraw the case?
Thank you. Honorable Neil May, as I've alluded, or I haven't rather, but in my introduction, I have not said anything around my having an LLB. As a result, that's the reason why I have 3 advocates within the Legal Services Department that assist in providing advice. Further than that, we also have a panel of corporate attorneys that we use for these type of critical litigation to provide us legal advice and legal opinion on these matters. So my role was to then get from what the board wanted us to do, then to be able to then brief counsel or our attorney on record on this matter. But and it must be noted that when I got to the RAF, this matter had already started. I think it started in 2022. I arrived in 2023. And in terms of your question around the minister's direction, I think that the minister had written to the board, and that's within the board's purview as well, to then deal with what the minister says in the letter. So that was cascaded to the board. Thanks.
How much time do I have?
You have 3 minutes, Honorable Nilme.
Okay. No, thank you. I want to carry on with that questioning. And the 3 advocates that you have in the office, would you be kind enough to share their names with us?
Yes, the 2 advocates are behind me. The Advocate Brett Phillips, Advocate Nico, and unfortunately Advocate Peladi Moahid didn't want to come through today. Thanks.
Yes. Just for interest's sake, you do know that there's no state attorneys in the Grahamstown court, and that attorneys that are going to court are there's nobody representing the RAF there. I thought I must just mention that to you. I came across that this weekend. Thank you. I'd like to move my questioning now. I have one question for Mr. Letsoalo. Regarding the email dated 25th of May 2021 from Mr. Walter Ramsby, what was your role in the process of identifying employees to be charged? Can you explain the context and decision-making behind this directive?
Thank you, Honourable Member. Can the email or the part which affects me be read out for record so that I can have a recollection? I have asked for information, Chairperson, before coming here, and I wasn't given the information.
Okay, can we, members, when we refer to a document, just especially correspondence from a long time ago, can we just read so that, because it's in one of our earlier bundles, yes, so please, will you come back to that? Yeah, because I think it would assist Mr. Letsoalo to know exactly what you're referring to.
No, thank you. That is for now. That I'll come back to that. And for this round, thank you, Chair.
Yeah, and I'll come to the issue of the documents just now. So I'm trying to think which. So let me explain what matters we want to traverse. I mean, there might be a reference to a document or two, but the matters we want to discuss with you specifically, so that you have an idea of how the conversation may go, and therefore what you need to try and recollect. One of the things we're concerned about as a committee is the length of time people are on suspension. As we understand, matters are supposed to be concluded within 6 months, or is it 180 days, right? So we have a list of names that's been provided of people that were on suspension since 2021. So that's one. The second issue that we want to get insight on is the process followed generally with the suspension, because at the heart of it, we just want to know why was it taking so long, right? Why did it take so long? So that's the second issue. The third issue that we are concerned with has to do with instances where capacity in critical areas was lost due to labor relations action, where the people then spend a lot of time outside of the RAF without the matter being concluded, right? The last one that we want to deal with, to the extent that you know and you were involved, we've also been told that the Road Accident Fund used lawyers for internal disciplinary matters, for CCMA matters, all the way to the labor court. We have asked for an itemization of how much the Road Accident Fund has spent in the period under review. Granted, some of the period you were not there before, some of it you were not there after, but in the role that you have, you would have insight into how the processes worked, who decided there needs to be a lawyer, why couldn't you use internal staff, presiding officers and so on, and initiating managers and so on, which would then reduce the cost to the Road Accident Fund. I may speak under correction, but I think in the period covered by the terms of reference, the Road Accident Fund has spent well over 100 million on labor relations litigation. I think the number is more than 140 thereabout. I might be wrong, but it's a lot of money. So those are the things we want to traverse with you. What I would like to ask the members is that when we're referring to a specific testimony before, or you give a date, if there's a date, you say this is what this person said to you, or this is what you said to them, and then it will assist the witness, because like I said earlier, some things happened 4 years ago. It wouldn't be possible for someone to remember one of 800 emails they sent that year. Okay, so Mr. Letsoalo, is that helpful to you? Okay, and I will intervene when I need to make sure that you've got, I might even ask the colleagues here to print certain things for you if we need to come back to a question, so please relax, okay? We're going to try and assist as much as possible. Before I come to you, Honorable Skhosana, I just want to ask quickly, Ms. Manyasha, so when Mr. Msiza was here, so because I noticed that you said that Mr. Letsoalo asked to find out if Mr. Msiza is available. So one of the things Mr. Msiza admitted is that he and Mr. Letsoalo were actually business partners at the time that he came to the Road Accident Fund. Were you aware of that? Was there a declaration made, as far as you know, if you are aware of that at all?
Chair, I was not aware that they are business partners. No.
Okay. And then lastly, who dealt with the agency that did the recruitment? This is why I'm asking, so you know, so I'll keep referring to something previously said. So Mr. Barrel, when he appeared before the committee, said that HR, I'll use HR, you guys have got your own internal name, HR would run the process as per expectation. However, the office of the CEO would need to be told which agency is doing the recruitment. So the only thing I want to ask you is that your understanding of what would happen at all? And if so, why was that necessary? That's all. And then I'll hand over to Honorable Skhosana.
No, Chair, there was no need or a request from the Office of the CEO to specifically know which agency. My understanding is that the RAF has about 3 agencies or 2 agencies that they are using at the time when they are doing recruitment. And when there's a recruitment process going on, they will pick one that will deal with a certain recruitment. So it was not a necessity or a requirement to say you must tell the Office of the CEO what recruitment agency you are using.
Okay, so during your tenure as head of the Office of the CEO, you never requested that kind of information. HR would just run their own process.
True.
No, thank you very much. Honorable Skosan, your time starts now.
No, thank you very much, Chair. And good morning to honorable members and Mr. Letsoalo, Ms. Khumalo, and Ms. Manyasha, and all other stakeholders present. Yeah, just few questions from my side for now. One, Ms. Manyasha, can you clarify the rationale behind the instruction to halt the promotion of direct claims?
Thank you, Honorable Skwasana. I think a lot of colleagues spoke about the halting of direct claims. My understanding of that was that previously Road Accident Fund would go out there and, Chair, if you allow me to use the word touting.
So I'm stopping the clock. So I just want to be sure that the question is understood. So, because I noticed your answer and I want you to be aware of the misalignment that would happen immediately. So Honorable Skwasana is asking about the halting of the promotion, the marketing. You are referring to the halting of direct claims. They are not the same thing. You are opening yourself up to a follow-up question. You understand? So let's just try and pay attention to what the member is asking. Otherwise, we do that thing. Okay, thanks.
Thank you, Chair, for that direction. The promotion of direct claims was stopped as a result of a discussion between management and the board to say that we cannot go out there and say people must bring direct claims when we are not going to be able to deal with them. And I think the biggest thing that the board raised at the time was that us asking people to bring direct claims and putting them into the system, whereas the Act says a claim must be prosecuted. It's opening the Road Accident Fund to a problem of sitting with a claim and the claim prescribing in our hands. So it was just that to say, let's not go out there and actively ask for those claims from people. That was the rationale. That is my understanding. Thank you, Chair.
So during the time when you had some employees stationed in some of the hospital assisting claimants, were you unable, were you not managing, were you not coping as an institution to deal with direct claims? Or you were mainly focusing on claims that comes from lawyers?
Honorable Skwasana, I was not actively involved in that, in the claims. My duties do not cover the claims division. So in terms of what the hospital case managers were doing at the time, I can't answer that question.
So, but the directive to halt the promotion of direct claim, was it not coming from your office, from the office of the CEO?
I know that somebody said I gave the directive. I don't remember giving a directive. I may have communicated to the people that I was working with at the time to say we are not promoting direct claims, but it was an executive management directive.
So you don't know whether there was a written directive to that effect?
I'm not aware of a written directive.
Okay. No, thank you very much. Coming to you, Ms. Khumalo, I think if I've heard you correct, you said you have been recently suspended. Is that correct? Can you record?
Pardon?
I said, can you record? Can you use the mic?
Okay. Yes, that's correct, Honorable Member.
What are the reasons for your suspension?
Chair, do I have to talk about the reasons for my suspension?
Yes, at a high level. I mean, you don't need to take us through chapter and verse. It just state at a high level. I think that's Honorable Skosana's expectation.
Chair, it's such a challenge to say at a high level because, I mean, one of the reasons was I took long to fill in the post of head legal services. So there's a number of them. There isn't a high level.
Okay, no, just
summarize on.
Okay,
Yeah.
just summarize, yeah, if that's okay.
Maybe the Honorable Member can assist me further so that I can be able to answer you in terms of where you're going with the question, because
No, I mean-
can't, unfortunately,
okay.
I can't.
No, I mean in terms
Summarize.
of the suspension letter, isn't it that when an organization suspend, they would obviously send a letter to you? What is it that is written on the letter? Not your interpretation or your own view regarding the suspension, whether is it justified or what, but what is written. If they say, Skosana, you are suspended because you did not give members water, that's what is written on the suspension. So that is the basis for the suspension. As to whether I agree with that or not, it's another matter. That's what I want to know.
Sorry, can I provide some guidance here, Honorable Skosana? So sometimes, and you are in that space, at least at an executive level, the letter will say gross insubordination, gross negligence, etc. That's what I meant by high level. Then it would say, in that you did XYZ. You don't need, unless Honorable Skosana asks for that information, you don't need to go into the weeds of the detail, because the letter might be quite long, but you might want to say it's alleged gross negligence, whatever the case is. I don't want to put words in your mouth. So just do it like that. Then Honorable Skosana gets an idea of what it is. You don't need to go into the specific allegation unless he asks you.
Thanks, Chair, for the clarity. Honorable Skosana, it says you committed gross negligence and or dereliction of duty in your capacity as the Chief Governance Officer. Then there's a number of issues.
Okay, no, I'm satisfied. Now, I understand that as in your capacity as the Chief Governance Officer, you signed off the appointment of Media Mix 360 and Zinge production contracts that are worth 500 million each. Is that correct?
I signed off the service providers agreement. So the appointment process is done through SCM processes. I've got the delegation of authority to sign off the service providers agreement.
So you are not involved in the SCM processes at all?
No, I'm part of the BAC members, but I'm not involved in SCM. I've got the delegation to sign service providers agreement as delegated by the CEO. But that is, when I sign that, then it means all processes have been followed through SCM, and legal services in terms of contracts have looked at that contract, because it's basically a contract of saying what they're going to deliver. So that's where I sign, when all the processes have when all the processes have been followed within the RAF.
So you firstly satisfy yourself that all the due processes were followed before you sign those contracts.
Honorable Member, By satisfaction, I'm satisfied because when the memos would come to me to sign the service provider agreement, it would then say that this matter started here, it went through the BAC then approved it or recommended it, and it went to the correct structures within the board or with the board committees or the board, and it was signed by the CFO, and as a result, it also went through legal services contracts. They looked at the contract, that what was on the tender is indeed in line with the contract. That is that service provider agreement that then I sign. So when those things are there in the memo, then I sign the service providers agreement.
So if you see something untowards in a contract, what do you do?
Honorable Member, it would have been flagged through all the processes, the governance processes that I've talked about. It would have been flagged. And that's why the last people to say you may sign will be legal under the contracts units, to say that this contract is indeed aligned to what the terms and conditions of the tender were.
So as things stands, are you happy with the Zinge contract and the Mix 360 contract?
Honorable Member, I don't know what you mean by happy, but what I've signed, the service providers agreement, they were in accordance to what the tender had said. That's what I've signed. And from there, signing the service providers agreement, I don't have sight of what happens. Then the relevant business units then will be able to give directions to those service providers. So that's where my role ends, in signing the service providers agreement. Not in appointments, not in monitoring whether they are delivering as they should.
Yeah, but in terms of when I was saying if there's something untowards after all these SCM processes, and then you realize that it's not you who's appointing. I understand that there would be all these three committees. There would be a bid specification, bid evaluation, and bid adjudication, and then there will be CFO. I mean, CFO, yes, will be involved, and then the CEO. But when you realize that there's something that is not right, what are your powers? What is your responsibility? Are you not able to maybe advise the CEO that as much as this thing is from all the committees, is from the CFO and all that, but I think there's something that is not, that doesn't make sense. Say in terms of the value for money, for instance. If you realize that in this contract there's no value for money, you proceed and do your job and say, my job is to sign off the contracts and then I'm done. Or do you go back and say, CEO, can we talk about this thing? Or CFO, can we talk about this thing? Or whoever, and say, hey, I am picking up this thing. It looks like there's no value for money, or something like that. I just want to find out as to what is your role in relation to that. Are you able to advise, or there's nothing that you can do once all the committees have finalized? Your responsibility is just to sign. You can't even raise a query.
Honorable Member, we've got structures within RAF that will look at these contracts from the business units and from SCM. SCM is heavily involved with, firstly, the issuing of tenders, the criteria, etc. So there's different bodies that look at these contracts before they even get to BAC. Even as BAC as well, we then look at the contract and apply our minds in terms of what is required. Before then it goes to legal, where legal then looks at the contractual elements of the tender. So I won't be able to then respond to you in terms of value for money against what. Value for money, I guess, it will be against what we wanted you to give us vis-a-vis what you're giving us, and that goes back to the business units to say if we have requested for A4 papers of this quality and you're not giving us, it's not. So my role is it's not on that one.
Okay. My last question to you and on this matter, is it usually that when you have set aside a budget like 500 million for a certain tender for a period of 5 years, which is 100 million per year, that you end up appointing somebody who said he can do that job with 5 million per year, when the budget that which the organization has have set aside for that particular project is 500 million for 5 years and 100 million per year. But here is somebody, Media Mix 360, who say, I can do this job for 5 million. Is it usually that your organization would give a contract or appoint such a company? Because I'm asking you as a person who normally signed this contract, was it a usual thing to happen, like in the case of Media Mix, that Media Mix says, no, we can do this job with 5 million, whereas the budget is 100 million per annum, 500 million for 5 years?
Honorable Chair, there's people in SCM that will be able to assist you with that. Mine is to ensure that the contract is in compliance with what has been said in the tender. So the business units will be the ones who will be able to then look at their budget, what was said the value of the contract is, and then look at how that budget will be spread and be able to monitor that. I'm not involved.
Okay, no, thanks, Chair. My next question was going to Mr. Letsoalo. I see that he's out.
Shame. He desperately needed to be in the bathroom, so I allowed him.
Yeah, maybe Honorable Nteja can proceed with.
Yeah, she can proceed. Yeah, you were about to enter injury time, but when he comes back, we'll make sure you complete the.
Okay. Thanks,
Honorable Nteja, over to you.
Thank you, Chair, and good morning to everyone. My question to, what's her name? Ms. Manyasha is, on what basis were the instructions to halt the promotion of direct claims was issued, and whether this directive was done in writing?
Thank you for the question, Honourable Member. I think as I've responded to the previous member, there was no written instruction for halting of the promotion of direct claims. It was a discussion between the board and the executive to say we should not go out actively looking for direct claims. Thank you.
Was this aligned with a rough strategic mandate, or it was just the decision of the then board?
I'm not sure about the alignment to the strategic mandate, but I believe that it is aligned to the Road Accident Fund Act, because as I've stated before, having direct claims that we go out actively to initiate makes us to have a lot of claims that we cannot do anything about. So it was aligned to the Road Accident Fund Act.
What was the nature and extent of your role in facilitating Mr. Msiza's recruitment at PRASA and later at RAF?
Thank you, Honourable Member. As I've stated before, my role was to contact Mr. Msiza to ask him of his availability, firstly at PRASA for headhunting, which he agreed, and at Road Accident Fund also to contact him to check his availability in terms of a secondment. Thank you.
If I may ask, what was the reason for you to be headhunting for him on both entities, PRASA and then again on RAF?
The CEO requested for him. Thank you.
Ms. Khumalo, I would like to check if it is a norm for someone who have no legal background to lead the legal position, head of legal, without the legal background.
Thank you and good morning, Honourable Member. Honourable Member, my position is not head of legal services. The position of head legal services is currently vacant. I am the chief governance officer, and one of the among the 4 units that are under me, it's legal services. So all the business units are headed by heads, people that we call heads of those different units.
Okay, in the absence of the head of legal, as you say, there is no head of legal. Who was playing that role of leading that? Were you playing it without any legal background?
Thanks, Honourable Member, for the question. Yes, I'm heading it without any legal background. And how we have mitigated that risk is that we've got the 3 advocates that are senior managers in their roles that are heading the various units within the legal services department. So those are the ones that then provide advice, and me as the chief governance officer then will guide them in terms of what is the direction of the organization, making sure that whatever we're doing is aligned to our strategy. So I've got advocates that are heading those 3 units within the legal services department. Thank you.
Is it possible that you can give us the number of default judgments which were undefended by the RAF?
I don't have the numbers with me, Honourable Member. Maybe we would need to check if they were not provided under part of the parameters that were requested. I'm not sure.
And maybe you should elaborate by letting us know why they were undefended when you were there to advise the legal to why they were not defended, those cases.
So, Honourable Member, the issue around default judgment has been there for quite a while, as I understand. It has been there while during the time when the RAF had a panel of attorneys, and is still existing currently. And there's a number of issues why we've got matters on the default judgment. As I understand it, and I'm saying as I understand it, Chair, because I was not there when the panel of attorneys was not renewed. As I understand it, is that during that time between when the panel attorneys were supposed to provide files to the RAF so that then the RAF can be able to take over those matters in court, there was chaos in terms of how files were brought to the RAF. As a result, RAF did not have sight of the matters in court, and most of the matters then ended up in the default judgment, default court roll. Secondly, on the issues around why we have default judgment, is that our state attorneys currently are performing administrative functions and those of going to be able to represent us in court. And part of the solutions is for us then to increase our recruitment drive, to assist them, to capacitate them with administrative staff. Another problem that we have in default judgment is around what I call the volatile court directives. We would find that different courts would bring forward the default judgment court role. For example, during recess, you'll find other courts that will say, during recess, we're just going to have courts just purely on default. That then makes us to be, that then means that as the RAF, we would have to then reprioritize and reorganize our state attorneys to be able to deal with those matters. You would find also that the courts would then also then appoint acting judges to be able to deal with these default court roles. And what we had done in that, to be able to assist the courts in dealing with these default judgment matters, is that we have said, can we have a coordinated program whereby we know when are you going to have special default courts, so that then we can be able to then put in place a system for our state attorneys to be able to then represent us accordingly. So there's a number of challenges, and part of those is around the introduction of the RAF 1, where matters that have not been accepted as the RAF find themselves in the default judgment court role. So the non-registered matters. So it's a number of matters that have really increased and caused default judgment, Honorable Member.
Do you perhaps have a time frame for this recruitment to capacitate them?
Yes, Honorable Member, we had put in a plan to be able to then go on a steroid recruitment drive, but apparently, currently, as I understand it, there's been a moratorium on filling of all posts. So that will wait until the moratorium is lifted. Thanks.
Did you start with the RAF? Is it 2022 or 2023?
Excuse me, 2022.
Okay. May I find out why did you then, when you signed for the media mix contract, why was your date a year later, dated the 22nd of February 2023 on your digital signature?
Honorable Member, can I get, when did Media Mix sign the SPA?
The date was supposed to be 22 February 2022, but the date on which you, Ms. Khumalo, used on your stamp was a year later.
Honorable Member, the Media Mix, they signed in Feb 2022, and I signed in which day in 2023? Same, or a year later, 2023.
Yes.
Okay, thank you. So, Honorable Member, what happens is, once all the processes have been in place and a service provider has been appointed, what the service provider does with SCM is that they sign. They get to be given an award letter, and that award letter comes together with what we call the SBD 7.2 form, and that SBD 7.2 is basically saying you may start rendering the services while the RAF and yourselves finalize the service provider agreement. So, for me, signing the service providers agreement a year later does not in any way delay the services that are supposed to be rendered by the contractor. The award letter and the SBD 7.2 are the documents then that says how are you going to render the services to the RAF. So there's nothing unbecoming of me then signing it a year later.
Apparently, this one was cited as anomaly. But I would like to know whether you had the delegated authority to sign.
So Honorable Notenda, can I stop the clock? I'll stop the clock so that you don't run out of time, because would it assist if I showed you the page? Would it help? It might assist, ne? Let me do that, because I don't want us to talk in cross purposes. Okay. So just take your time looking at, I mean, you can scroll up and down, but just take your time. So you will notice that above your digital stamp, the date says 2022. Can you see that? Written by hand. Can you see? And then your actual digital stamp in blue says 2023. Now, there might be a misunderstanding, but just have a look at that whole nyaga there, and then explain to the members what's going on there, if that may help. You can see now, ne? You can see, yeah. So can you then, so that's what Honorable Nontenja is referring to. So can you please then, Honorable Nontenja, you'll come to your last question. I just want to make sure that we deal with the matter properly. Thank you.
Thanks, Chair. Chair, I mean, part of the issues with signing of the service providers agreement is that when I came, there were a number of service providers agreement that were not signed, that I had to, then the CEO then delegated to me to sign, to be able to help him out with the service providers agreement. And you would find there, because the contract was entered in 2022.
Honorable members, please keep it down.
So you'd find, Chair, that the contract was entered into or was signed by the service provider in 2022. But for me, when it was loaded, it was 2023. So what was supposed to happen there was that we are supposed to cancel that 2022 and write 2023 in where it was typed. You see the 2022, the date is typed, and I signed 2023. So that 2022 was supposed to be cancelled to say that I've signed it in 2023. So that's what happened, because then they are hard copies. But for me, then my office would then load them for me to then sign digitally.
Okay, so I've stopped the clock, Honorable Nontenja. So I just want to ask the following. So I just need to know what happened here, whether there is a typo or not. So you will see that the typed out part, not the digital stamp, so you saw it, you had time to look at it, says on the 22nd day of February 2022, right? The contract to Zinge's contract, we were told by Ms. Mate, I think she's one of the signatories further up, I might be mistaken, right? Said that it was awarded late in the year and sort of around November. So the decision was taken around November 2022. And you know what you were explaining then, that to say once a decision has been taken on a certain service provider, some of the exchange of information and so on starts so long, and then the SLA is signed soon thereafter, right? That explanation makes sense if the idea is that the service provider signs first, and I'm assuming that is the case, we should be on the 8th of December 2022. Can you see that? Then I am assuming that once a service provider returned the contract, you then only got to sign it in February of the following year, because it was at the end of the year. Can you see that? Where I have
Chair, yeah, but I'm trying to follow.
But can you see? Can you follow? So and I'm quite happy for you to be looking at this, because and Denzel, if you can please give it to us. So I'm quite happy for you to be looking at this. The difficulty is that the typed out date, right? The one that says February 2022. Can you see that? It predates the entire contract by nearly a year. Can you see that? So I think that what would assist the committee is in understanding the anomaly, because on the version that we've been told, the whole BC, BAC, etc., all of those things happened after February 2022. So it's not possible for the contract to have been intended to be signed in February 2022. Can you see where the confusion arises? Can you see that? So if you
So you are saying Media Mix has signed it on the 8th of December 2022?
No, start with the typed out part first.
Yeah.
Read that date.
22 Feb 2022.
Can you see? So it's the beginning of the year, right?
Yeah.
And then the procurement process took place after that. So that contract wouldn't have been signed in Feb because the procurement process took place after February and was only concluded around October, we were told. And then the service provider signed first, it was returned to the RAF and you could only sign it on that date on your date stamp. What you need to clarify is how does that date of February arise there? Because it takes place long before even the procurement takes place. You understand the process of procurement. That's the confusion that as the committee we had. So we just want you to clarify us on that and then we'll move on.
Okay, I will then need to, during break, check with my CFO and check what's happening. Because
But you can see it.
I hear what you're saying, but I'll have to look at this Zinge contract and say when did it start?
Okay.
Yeah.
No, so the Zinge contract, so the only anomaly there, so Ms. Mate was here. She explained to us that and we've got the procurement document, so her timeline is accurate in the sense that the whole process eventually concludes in late October or thereabouts. It's more towards the end of the year. 2022. Yes, in 2022. Right? And then the service provider appears to then sign it first before someone from the RAF has signed, which is on the 8th of December. Then you then get to sign early the following year, which I don't know what the delays would have been, but you know what I mean? So that timeline makes sense. The only thing that stands out, and we can, during break, maybe you can ask for more information, right? But the only anomaly is the typed up part above your signature is a date that predates the entire SCM process. And that's the problem. Alternately, if there is a mistake with the rest of the process, the difficulty is the service provider then and yourselves would have been a year apart in signing. I can accept delays of, some weeks, maybe whatever, a month, but a year is a long time. So can you just apply yourself to that? Honorable Nondenjo is moving to another. She will come back with another 15 minutes after the break. Just apply yourself to that confusion. That's what she's trying to clear up, and then we can clear it up later if that's okay. Yeah, okay. Honorable Nondenjo. Your last question.
Thank you, Chair. I've got two last questions.
Okay, fine.
Okay. One question is whether you had delegated authority to sign off on contracts, and maybe if you can share that with us. And the last one is not a question, Chair, it's a statement. You just said you were not a head of legal services, but before you became the chief governance officer, you were an acting head legal services. And my point there was to say, how can you be the head while you don't have the qualifications? Thank you.
Thank you, Chair. Chair, I've got the delegation, the DOA from the CEO to sign a service providers agreement. And I think that was also provided to the members as part of the requests. So that was attached, Honourable Member. Secondly, Honourable Member, on the issue of head legal services, yes, because it's vacant, there are things that per structure, roles and responsibilities are required to be done by the head legal services, signing of certain documents, etc. So I have been doing that, and I think I can't stress enough to say that I am not operational. There are specialists within the various 3 units that are assisting me, that have LLBs that are assisting me to do the job. My job is to oversee that legal services indeed does what it needs to do from a managerial position. Thank you.
All right, thank you very much, Honorable Nondenja. Can I just ask Honorable Skosana, when you stepped out, Mr. Letsoalo, he had a very special question just for you. And it appeared as if you were trying to run away, but you had no idea. But I defended you fiercely in your absence, yes. So I'll give Honorable Skosana a chance to ask his question.
No, thank you very much. No, I've got 2 questions for you, Mr. Letsoalo. I'll put both of them at the same time because the chair indicated that I was already on injury time. Yeah, I think you indicated that you left RAF in 2023.
Technically, yes.
Due to suspension.
Yes.
So remove your mic closer to your legs.
Yes, 2023, May 11, I think so, yeah.
So you are still on suspension to this date?
No.
Or you resigned? Or your term your contract expired?
No, I was permanent, but I have entered into a mutual separation agreement.
Oh, okay.
With the organization.
All right. Okay. Ms. Mthethwa gave testimony that there was a period wherein key senior managers were suspended without charges, and some ended up resigning after prolonged suspension. And I think there are also other witnesses who also gave evidence that there were instances where the employee relations unit would initiate disciplinary action against employees despite objections from their line managers. We're told that there was in fact a time where more than 200 employees were suspended, and some line managers would say, no, we don't find any prima facie evidence that can warrant us to agree to the suspension of these people. But we're told that the ER unit would say, no, there's an instruction, these people must go. Please find a way, these people must go. So I just want to find out, was it during your tenure as the ER manager when all these ugly things were happening in RAF?
Thank you, Honorable Skosana. Yes, let me start with the first question regarding management suspending employees without charges. Chairperson, I want to make a declaration before I respond to the question. I'm saying that I want to make a declaration before I respond to the 2 questions asked by Honorable Skosana.
Okay.
Number 1 is that my 2 co-witnesses here have indicated their knowledge of the former CEO of the RAF prior to them and the CEO joining the RAF. I want to inform this committee that me and him may be the same species, but not the same breed. And really frustrated like by a lot of mention being made of Mr. Letsoalo, Mr. Letsoalo.
Yeah. No. Thank you for clarifying.
Thank you. And I also don't have support behind me, like my 2 witnesses.
Don't worry, we are here for you.
I'm an orphan. Yeah,
we are here for you.
Thank you, Chair. Yes, in response to the first question, it is normal process that suspension takes place before the charges are drafted. you have allegations and you investigate the allegations. If the allegations lead you to a position where it is required that you charge an employee, then you will formulate the charges based on the outcome and recommendations of an investigation. That's the first part of your question. The second part, you said ER would initiate disciplinary hearings, even in instances where line management was not in agreement. I want to concede, and I'll give reasons why I'm conceding to what you said. Yes, it happened. But I want us to look at the situation at the RAF in context. Pre the appointment of Mr. Letsoalo and post his appointment. If you go to the ER spreadsheet of the period pre his appointment, you'll realize that we didn't have so many cases. But upon his appointment, then we had a lot of cases coming up. I will explain further. So, the issue about management not agreeing, I can name one of the acting regional general manager who was against the suspension of employees. I think you all know about the 180 days matters. I think Main Lane has had the biggest number. And the RGM, because we were the foot soldiers, we were consulting with him. We were telling him we need to subject these employees to disciplinary hearings. And he questioned us. And we said to him, the directive came from the CEO. All right. I remember at some point I advised him, because he was RGM above me, acting, of course, to directly, if he's not happy with what I'm saying to him, deal with the office of the CEO, which he couldn't do. That is why we had so many cases in that respect. Thank you. I don't know if I have adequately answered your question.
You say who was acting RGM? Who was acting at the time?
At Main Lane was Tsepo Tsepo Moatsi.
The gentleman who came on the first week when we were being orientated and led that delegation that was explaining, he's the acting chief claims guy, and he was explaining the claims process and the rough one form. He was the main speaker. He was sitting where Miss Manyasha is sitting. I think you remember him. That's the gentleman.
And honorable member, not only him, but also managers in that region complained. And the reason why they complained was because when you suspend those claims administrators, then you are incapacitating the region to the extent that there will be more delays in managing claims in the unit. And they even asked for sanctions short of dismissal so that the employees continue doing their work. But that request did not get a favorable response from the CEO. I can go further about this matter of having matters sitting for a long time without being initiated.
Yeah, please go ahead.
All right. We had a meeting, the executives, I don't know if my two executives here were there, but the CEO was there because he's the one who was facilitating with NUMSA, and at the time NUMSA was led by the General Secretary, Ivan Jim. And the purpose of that meeting was precisely to talk about those more than 200 employees who were on suspension for the 180 days matters. And in short, the CEO said that he does not negotiate discipline, because the issue there was to say, we understand, but even if there is misconduct on the part of our members, can we find a way to amicably resolve this so that we do not disenfranchise their families and everybody that is dependent on them financially and otherwise? But he refused. Thank you.
Yeah, last follow-up. So will I be correct to say that the ER acted based on the pressure that was coming from the CEO?
Thank you, Honourable Member. Yes, hence I said we can go to the records pre his appointment and post. you will see a great difference there. Thank you.
No, thanks, Chair.
Thank you very much. I'll come to you, Honorable Bloss. I just want to understand the process matter, so I'm not an HR person. Isn't it that when you are going to suspend an employee, you also, and if this is not compulsory, you must let me know, you also put the allegation to them and say, I'm giving you a day or 2 days to tell me why we must not suspend you. Isn't that part of the normal process? Would that happen at all? I would expect that to occur, because the assumption there is that the employee may provide an explanation to their manager where they get to see or maybe get to see the matter differently. Let's say, okay, no, then we won't suspend you, or whatever the case is. Isn't that part of your procedures at the Road Accident Fund?
Thank you, Chair. It is part of procedure anyway, including the RAF. However, there is case law to the effect that the employer is not required by any law to seek written representation from employee before suspending that employee. But normally, like what happened to us, I don't know them, but to me, I was given that opportunity. But I'm saying it is not precast that the place should go follow that route.
Okay, so it's not something that's prescribed, it's good practice. In other words, it's good practice, but it's not something that is prescribed in legislation.
There is case law to that effect.
To that effect, that it's not a necessity. Yeah.
Yes.
Okay.
Yes.
No. I'm with you. No, I just wanted to clear that matter up.
Thank you.
No, thank you, honorable members. I wanted us to break at 11, but honorable, I'm coming to you though.
No. That's what I want to check, Chair. That if there's something that on the line of questioning that I just need clarity so that we move. I'm checking if it's allowed. Yeah. No. Mr. Letsoalo, thanks. You seem to be giving an impression that you had a problem with articulation of the suspended CEO when he was having a meeting with NOMSA, you said, and he says that he doesn't negotiate ill discipline. It seems as if you have a problem with that approach or that articulation. Maybe clarify that for me, and why would that be a problem for you?
Honorable Bloss, your turn will come. I thought you were asking me for clarification. Your turn is coming.
Oh, that's what I was asking, Chair, in terms of the question. That's what I was asking, if the question arises and we just need to seek the clarity to move. I was asking that. Yeah.
Okay, let me just hear you again.
Chair, I'm saying there was a question that was asked.
Right.
And Mr. Letsoalo responded and he wanted to expand on the issue.
Right.
So I'm saying that on his version of events in terms of that meeting.
Right.
I just wanted to find out, that's the clarity I'm asking, if in that meeting, if my assumption of what he said is correct, so say that he had a problem with how that issue was dealt with at that time. Okay. I think he gets me. But if he doesn't,
no. Because the only thing I'm trying to do is that we will then have this back and forth with people who haven't asked questions, and so I'm not shutting you down. Can we hold that question in abeyance, and then when your turn comes, we will ask it? Okay, so if you can stick around, Mr. Letsoalo, for that. So we're going to break at 11. We've got 4 minutes. So can I just ask that we give our witnesses a break and ourselves, and be back here at 11:15? Would that be okay? Thank you very much. Honorable members, good. Welcome back. I just wanted to ask Honorable Beasley, are you now good to go? You're still not good to go. Okay, Mr. Letsoalo, I just have. No, it's gonna. No, don't leave because I'm asking.
Yeah. It's fine.
Okay, because I just have a question for you because. Oh no, this. Yeah, please. Can we remove that draping there? Yo. I don't know what's going on. I couldn't see Honorable Neil May either. No, Mr. Letsoalo, I just wanted to just ask because, I mean, my interest in these ER matters really is financial, right? I don't want to assume, but I think you've a good lot of experience in ER matters. Don't?
Yes, Chair.
How many?
Experience?
Yeah, years experience.
Around 20 or even more.
Okay, no, you're exactly the kind of experience. I just want to ask, so one of the things we were told, and what is a potential difficulty for us, is the fact that attorneys get used in internal matters. In my experience, and I may be wrong, at the stage of the internal process, usually the manager initiates, etc. There's somebody else who's not conflicted, who's been trained to preside, etc., etc., and that therefore results in an outcome, which then is effected one way or another, whatever the outcome is. There are still organizations that, depending on the complexity of the matter, and most matters aren't, even when it goes to the CCMA, they go and represent the company in the CCMA, right? Also. But we were told that at the RAF, for several reasons, even the internal process and then the external process, and then you've got the employment of counsel and so on. The only thing I just want to ask you is the extent of this practice and what the thinking is behind it. Because if the RAF handled its own internal matters in as many cases as possible, then we would save the cost and use that money for many other things that are needed, such as hiring state attorneys, for instance, and whatever else, right? That's the only thing I just want to understand from you.
Yes, thank you, Chair. I want to say to the committee that in my previous life, before joining the RAF, that what you are mentioning was the practice. But when I joined the RAF in Jan 2019, I asked how DCs were managed. And I was then told by my colleagues that there was a panel of attorneys. So there was this panel that was responsible for initiating disciplinary matters, this panel for chairing, that panel for CCMA matters and labor court disputes. You are quite right. There is a lot of money that went into those cases, money that could have been used elsewhere. But that's how the system was and still is at the Road Accident Fund. I remember, I can't remember whether it's late 2019, I had a discussion with my line manager, who happened to be Mr. Ian Barriel. And my conversation with him was about us seeking assistance from sister organizations, ESCOM, sorry, not ESCOM, Transnet, PRASA, I can't remember the third one that I gave the name to. But then, so that we get initiators and chairpersons, and we are also able to send initiators and chairpersons there to try and avert the exorbitant costs that came with the appointment of attorneys in disciplinary matters. I do agree and understand that as matters culminate into disputes, for instance, at the labor court, you will, most of the time, need an attorney. An attorney at that stage may not brief counsel, depending on how he feels about the matter and depending on the complexity of the matter. And Chair, they say in labor law, for legal representation to be allowed, there has to be motivation. And motivation should cover the following. If in this matter there will be questions of law raised, that's one. 2, if any of the parties will suffer prejudice should legal representation be declined, unreasonably so. 3, comparable abilities of the parties. Meaning, for instance, if I come from an HR environment, I will obviously know better than her coming from ops. I'm making an example. So in that instance, if she does not belong to a union, she can motivate for legal representation based on those facts, prejudice that she may suffer if that is not granted. If the matter has got potential, for instance, to attract public interest, that's where you can bring in lawyers. But at the road accident fund, like I'm explaining, when I got there was already that system, and attorneys would rotate in initiating matters, would rotate in sharing disciplinary inquiries. And when I asked why, the answer I got from my line manager was that because managers were resisting training on these aspects of ER, chairing, managing grievances, initiating in disciplinary matters. That's the reason.
All right, thank you. So I just want to understand. So in a hearing, there would then be at least 2 law firms. One is the law firm of the presiding officer. The second one is the initiator. So there'd be 2 law firms. And then if the employees allowed to bring in lawyers as well in an internal hearing?
Chairperson, they were allowed, but remember, this is employees suffer prejudice financially because the manager charging the employee is not using money from his or her own pocket, but the employee is expected to pay from his or her pocket. And that happens with all of us. I went through that process, for an example. So you find that there are exorbitant costs that you need to deal with. When this man who's charging you or this lady charging me gets money from the RAF to pursue the matter.
Final question. I don't know where Honorable Matuna and Honorable Pega are now. So final question from me. Were there instances where counsel was involved in the internal stage, an advocate, that you are aware of?
Yes, Chair. There was a matter at our Johannesburg regional office involving one of the senior managers. That senior manager was in support on allegations of sexual harassment. We appointed a firm of attorney as per procedure, which was at the time MJS, and they briefed counsel. And the employee also brought counsel to the CCMA and to the hearing as well. That's the one matter that at the top of my head right now I can think of, okay. But I should think there are others as well.
No, that's fine. I am then going to... Honorable Nelme, I'm trying to avert... You remember when I was talking to Honorable... Blosse, I even forget your name, you haven't come here in so long. Honorable Blosse, because then we're going to do this and I was going to move on to the next member.
Chair, it was the email. I was quickly going to read the email.
That email you did not have. Okay, so just read it to him. Yeah, please read it to him.
That, yes. No, thank you. Okay, the email that was sent was from Ian Barrell. I don't know if you can recall that. And it was sent to quite a lot of people. Tapelo Malelule, Princess Shavangu, Richard Machete, Bryson, and yourself. And copies to Jeannie Mamadita. Okay. So it reads as follows.
Can you just say what the date and the subject are?
The date, it is on the 25th of May, 2021.
And the subject?
And the subject was, it was basically I don't have the heading to it, but it says based on it's the finalizing of the charge sheets, Chair. So basically, it's based on the finalizing of the charge sheets. Mr. Barrell has written, based on that, I've indicated that after finalizing the charge sheets for this week, I will be in Joburg on Thursday to identify another 5 people. On Friday, I will be in Mainland to do the same. So may I please be excused from being part of the DC hearings, as I will be preparing for the next round. Chapelo and Jabulani, please start identifying the next 5 employees to be charged. So my question around that was basically from our witness, Ms. Mtetwa. She shared with us that there appeared to have been prior decision to just suspend people without reason and then find the reasons later. And that email, which I've read to you, points to be something like that. So that was what the email was about, is to ask you to start identifying.
So what's the question?
The question is that correct? And why? And what was the whole purpose? What was the strategy behind identifying people at every single branch? And as it was said here, you know, is just identify 5 as you go along.
Chairperson, I'm aware of the email, and I think as I was browsing through the transcripts that I received from Fatima, I saw the email here. But just to correct you, Honourable Member, I think the email comes from Walter Ramaswi. Maybe Ian Barriel could have been copied. So earlier on, we spoke about the 180 days matters. And those matters involved more than 200 employees.
Okay, so let us clarify which 180 days. I suspect there are 280 days we may confuse. Okay. There's 180 days by which, in terms of your ER policy, you must conclude matters. Internal matters. There is 180 days for the claims process. Which 180 days are we talking about here? You remember when the court, there was an agreement with the court to say matters, must be cleaned out within 180 days, etc. So which 180 days? Just give a bit of context so that we can all follow.
There are not 2, it's 1, as far as I know, Chair. So the more than 200 employees are alleged not to have, what is that? I need to be reminded here. It's a claim process which they did not do within that period, 180 days. It was a court order. Now, where this email is coming from, or what it means, was that because there are many, and we were under pressure, and I include myself because I was part of ER, we were under pressure from the office of the CEO that we are not moving on these cases. And remember, we had resistance from management. And I'm glad now to mention that even the man behind me was one of those managers who said, but you can't suspend employees. And we told him and the rest that this is a decision made and coming from the CEO himself. So, and we were told that if you don't do it, then you go. Now, for us to expedite, Walter was reporting to me. And I said, Walter, go to the regions so that you identify these employees that are alleged to have committed this misconduct on the 188-day court issues. And so that when we go to the CEO, we at least show cause that we are moving with this request. So that was the only thing.
All right. So are you answered, Honorable Neil? I don't want to extend your questioning beyond. So there was this one outstanding question. I think he has answered it. You will get your 15 minutes on the way back. You can deal with it. Honorable Maduna, your 15 minutes.
No, thanks, Chair. Indeed, we must greet to you, Chair, our colleagues, honorable members. the excerpts from Ralph and your colleagues. No, thanks. I think my first questions will go to Miss Manyasha. Angazi noba ngisho kahle into, so ngixolele. No, I firstly I want to check, when you were doing the recruitment of the specialists, because I think Honorable Helen would have asked about this. I just want to be sure, did those specialists that were recruited declare their previous pre-existing personal relationships or professional with the CEO or any other executive at DRAF? Are you certain they did declare that in writing?
Thank you, Honorable Maduna. To the best of my knowledge, the specialist where I was involved in the interviews of did declare the knowledge of Mr. Letsoalo.
So how many were they in total?
There were 7 specialist positions that were filled at different stages.
About only 2 did not have a pre-existing personal or professional relationship with the CEO.
I think, yeah, about 2 did not have a personal and professional relationship with Mr. Letsoalo.
I know it might have not been your place, but given that you were involved in the process, did that appear to be okay with you?
Honorable Maduna, as I stated before, the CEO would have preferably wanted to headhunt people that he wanted to work with as his advisors. So my understanding is that in other areas, headhunting is not prohibited. It's just that at the Road Accident Fund at the time, it was not allowed, and therefore the only way you could headhunt, you could still headhunt, but you still needed to interview at least 2 people to a position. So this was a headhunting process, essentially.
Sorry, Honorable Maduna, I just want to ask something. So earlier on, I had said we must not speculate. So I noticed that you are saying the CEO would have. You are not the CEO. What I'd like you to say, if you are going to make that assertion, is that the CEO told me. If that's something that you are supposing, perhaps stay away from it, if you get me. And then just explain what the instruction was, because I noticed it's a second time where you're saying what he would have wanted, and he's not here. Yeah.
Let me clarify, Chair. The CEO wanted to headhunt. However, when we looked at the Road Accident Fund policy, it was not allowing for headhunting.
So I would assume that you continued, by the way, in headhunting, but doing it indirectly.
That was the advice HR gave, to say we don't do headhunting, to say we want Mr. Maduna. But what we do is that we need to go and advertise the position and to get people to apply to a position. At least have options to look at, but essentially it is headhunting.
According to you, Ms. Manyasha, lastly, what is a specialist? According to your knowledge and your experience, just your opinion, what is a specialist?
A specialist is somebody that possesses a certain skill that may not be readily available where a person is sitting, and that person possesses something that the incumbent would be looking for at the time.
According to your opinion, can a person with NQF level 6 in accounting be an accounting specialist?
In accounting?
Yes.
No.
How is it that you recruited Mr. Mziza with NQF level 6 to become be your security specialist?
I did not recruit Mr. Msiza. Mr. Msiza was requested by the CEO on a secondment basis.
So we agree he was not a specialist.
He may be a specialist in his own right.
So someone with NQF level 6 can be a specialist. Is that what you are saying?
I suppose. I'm not a specialist in security, but I can admit that a person at NQF level 6 cannot be a specialist.
No, thanks, Ms. Manyasha. Let me go back. Can someone with an NQF level 6 in accounting be a specialist in accounting?
No.
Can someone with NQF level 6 in security be a specialist in security?
No.
Okay, thank you. So me and you agree, we hold the same view that Mr. Msiza was not a specialist.
True.
Thank you. I wanted to establish that first. So essentially, I wanted us to agree that you are not recruiting specialists.
Okay, we're talking about 2 batches of specialists.
I'm saying out of all that process, because you did it in phases, right? I want us to agree that you were headhunting people that the CEO was comfortable to work with. You were not necessarily recruiting specialists.
Honorable Maduna, the first process that I spoke about was recruiting specialists. Mr. Msiza was not recruited. He was seconded.
Seconded is what?
I believe as a specialist security.
Thank you. I will again repeat, Ms. Manyasha. I want me and you to agree that you were not necessarily recruiting specialists. Okay. You were recruiting people that the CEO was comfortable, or you were headhunting people that the CEO was comfortable to work with.
True.
Thank you. I wanted us to establish that first.
Okay.
Thank you. Secondly, because I know that it was not only your decision making. That's why I'm saying that I just want your opinion, and then we'll pass. These questions will be asked to him. Ms. Khumalo, without an age, angazi noba umzilikazi nabo laba bangena age. Hayi. Siyabonga mashobana. No, I want to check. One, enterprise risk management was ngaphasi kwakho nema. Okay. We received Mr. the chief investment officer. Just pardon me, the surname just slipped off my head.
Mr. Modiba.
Mr. Modiba. Given that the enterprise risk management is under your office, can you, in summary, just short summary, a minute, give me what is its role at a high level, strategic summary?
We ensure that the strategic objectives of the RAF are implemented by various support structures. We also look at what are the emerging risks that we need to mitigate as an organization.
I assume that would include making a strategic assessment in your liabilities, in the management of the organization liabilities, right?
Liabilities as they relate to finances.
Yeah, I'm saying yes, in overall liabilities of the organization. That yes, obviously would
part
have.
Part of the risk will be on the financial system. Like, for example, one of the top risks was around the financial sustainability of the RAF.
Thank you. Mr. Modiba is obviously an executive in chief investment officer. Ne? He's not under office. No. Okay.
We are on the same level.
We are on the same level. I'm asking this because most of what he said it does is what I would deem to be under enterprise risk management. What is your view on that?
That's my personal view, and honorable member. Oh, you want my personal?
You can give your personal view.
No, I don't think it needs to be necessarily under enterprise risk management, because from my understanding, he's the chief investment officer who deals with issues around investment.
No, I'm saying, Mamziligas, I know he's a chief investment officer, but we asked him. That's why I'm saying I must recall. I personally asked him, I repeated for more than 5 minutes, what do you do at RAF? He could not answer me. Because I was asking him, I went further to even ask, do you have investment in RAFs? He said no. Do you do any stratifications of liabilities and so on? Given that RAF's liabilities threw up the roof, it is uncontrolled. We could not correctly answer on that. Now, what he would have, we then asked him, tell us, what do you do? Everything else that he tells us that he does, I'm saying that, in my opinion, is what would necessarily fall under, partially of it, under enterprise risk management, partially of it, under chief audit executive. Now, I'm asking you, in terms of what he was doing at RAF, because you have no investments, your liabilities are not managed properly, according to your opinion. That's why I'm asking in that line.
Honorable member, I think the structure was formulated by experts, and I'm no expert in formulating structures. And PwC had then seen it necessary that as the RAF would therefore require to have this position called the Chief Investment Officer. So those that are specialists, I will leave it to them. Thank you.
No, thanks. You know, the reason why I'm asking her is because I know when executive sits, even on your investment decision, normally if we were supposed to invest anything, it would be decisions of, they usually say, management committee. Yeah. So that's why I'm asking, because I would have just wanted to have your opinion, but it's fine.
Maybe through you, Chair, Honorable Member, what I can say for sure is that there was no duplication of roles or functions between me and him while we were working at RAF.
No, thanks, Chair. Thanks through you, Chair. Thanks. We know we're noting. So, you also had the responsibility of overseeing the legal services unit, right? The head of the unit has been vacant for some time. Ne? Just to confirm.
Yes, Honorable Member.
How long?
Well, when I came in 2023, it was, I think when I came in 2022, sorry, Justice had just left.
Justice Malala.
No, Justice Mudluli. There was a Justice Mudluli who was head of legal services when I just arrived in 2022. And maybe I must wait for you. No. Oh, okay. And during my tenure, we had tried to fill the position twice. Certainly the one that I was involved in, the preferred candidate went through assessment tests, and they were not successful in the assessment test, and it was on matters that we could not compromise on, issues around ethics, values, etc., that we require of the head legal services. So we couldn't get, a candidate on that.
One follow-up that I will have. You are saying you have tried filling the position twice.
why were you not involved on the other process? That's my first question. My second question, I want to check. Usually, I know that when you finalize the appointment, you usually have about 3 candidates where that you obviously take through the process, the clearance and everything, where they all compromised or they all failed the assessments.
Thanks, Honorable Member. The one process that I was not involved in, I was not there yet. I think it just, yeah, I can't remember because, but I'm talking under correction, Chair, so that I don't incriminate myself. I have asked for that information from our HR. I'm hoping that they will also send it to me because I wanted the exact dates of the periods that we wanted to fill in this position. So I can come back to you with those dates, Honourable Member. And the other issue around the candidates, the second one was not suitable for us to appoint. And as a result, we had now started with the shortlisting for the head legal services.
Last question, Honourable Member. You are in injury time, but I'm nice today. Last question.
But it's not 15 minutes.
It's more actually.
Can you check your watch again?
And by the way, I wanted to give members 30 minutes and you put up your hand and you had a different idea. So
no, thanks, Chair. I'm asking this because one, I think it's surprising that in 3 years you only tried to fill in this position only once. 2, as a parting shot, because I will come back, I want to check, do you feel like you, no, the right question would be, you know that you are responsible for legal services at RAF. I will come back with the follow-up to it.
yeah, no, to answer the question, then the follow-up will come. The follow-up will come back at 7 p.m. when he finally gets another chance.
So the question is, do I know that I'm responsible for legal services at RAF? Yes.
All right, thank you very much. I just have a small question for you, Ms. Manyasha. 2, and they are related. So firstly, can you tell me, so you said the former chief executive wanted to headhunt, right? Can you tell us which people he had wanted to headhunt? Sorry, I thought someone was falling. Which of the people he wanted to headhunt? If you can recall.
I can recall Mr. Mudiba. I can recall Mr. Peter Malele. I can recall Ms. Buitumelo Mabusela.
Okay. Was there ever an instance where Mr. Letsoalo wanted to headhunt someone, where the interview process produced someone else, not the person that he had wanted?
I cannot recall that, Chair.
Okay. So here's why this question is important. When, and I listened carefully when you were speaking, it appears that the recruitment process was a pro forma process. The people that were wanted were known. But in order to get around this no headhunting policy, there was a process run in order to identify people that the chief executive wanted, right? And those people ended up at the Road Accident Fund. That's why I'm asking the question. Do you have a comment on that? Because it appears that this process nonetheless failed. Well, let me not say failed. Somehow agreed with his initial intentions anyway, and that the other candidates actually just never stood a chance. That's what it appears on its face.
My comment on that, Chair, is that yes, you are correct. However, I must state that none of those specialists, the contracts were for 3 years, none of those specialists were ever appointed to a permanent position.
No, that's fine. I'm just dealing with the initial recruitment for now, right? I also will just inform you that when Mr. Modiba came here, he said he didn't know Mr. Letsoalo from Adam. Didn't know him. They didn't have a relationship. That he was called by an agency whose name he could not recall. Well, he couldn't recall actually whether he had seen an ad somewhere and applied or an agency had called him. Now, Mr. Modiba says he had been sitting at home for quite some time. And I did say to him, you know, I think I would remember if I'd been sitting at home for so long and then I would at least know I got a call from somebody called Prudence or so. Anyway, that's me. He had no recollection. So he didn't know Mr. Letsoalo and he had no recollection of how he got to know about it. Something we must then canvass with him again. You have just informed us, also under oath, that Mr. Letsoalo wanted him, the guy that he didn't know. That's the outcome of what is now before us. Under oath, sitting on that chair, he said, we don't know each other. That's what Mr. Modiba said. But Mr. Letsoalo wanted him anyway without knowing him. Okay, thank you. Honorable Kupeka.
Thank you, Chair, and greetings to the House. Greetings to the team from the Road Accident Fund. Greetings, honorable members. Ms. Khumalo knows that she's in charge of legal services. So I'll piggyback on that one. And the first question I'll ask is, with all of the issues that are happening with the lawyers and the legal services at the Road Accident Fund, I think, Chair, you'll agree with me that we've been told a whole lot of issues that came up with lawyers at in the courts, lawyers not knowing what to do, lawyers not showing up, lawyers basically not having instructions. So I think the first question to Ms. Khumalo is, what was happening there? Why were there no systems in place to monitor court proceedings so as to try and manage the exorbitant cost of the cases that were being lost by the Road Accident Fund? So the question there is basically, where were you in that whole setup? What was happening there? Why was there such a huge vacuum in as far as RAF showing up for those court proceedings?
Honorable Member, maybe may I request clarity in terms of which periods are you referring to? And if you are saying lawyers, are you referring to state attorneys?
The crux of the question is, when you were there, while you were in charge of legal at the Road Accident Fund, the idea is there were no systems in place to monitor court proceedings for the Road Accident Fund. So that's all court proceedings that included the Road Accident Fund while you were there. So I'm referring to the period you were there. So whether it's with cases within RAF and cases that were going to court to be defended by the Road Accident Fund, I'm talking about everything.
Honorable Member, we do have court monitors that look at the court roll, so that then through the LMS system, we can then provide instructions, or operations would then provide instructions to our state attorneys to go and defend cases. So we've got a system in place that we use for that function. We further, and this is where I'll call Brett as well, to elaborate further in terms of how then does he make sure then that we've got representation of the state attorneys then in court? Because I heard you talking about court proceedings, then you're saying things that are on the court roll or in the court, during the court itself. That's what I'm not getting clear from you.
I'm glad that you want to bring Mr. I've forgotten his name.
Philip.
Yes, because he was here, so he will know exactly what I'm talking about, because we did ask him this as well, and I think that's the reason why you are here when we asked that. With all the court proceedings that were going on, why were they not defended? You are telling us now that no, there was a process to instruct lawyers, but was it Mr. Phillips?
Yeah, but I would actually like Ms. Khumalo to answer the question, because Mr. Philip answered the question.
He answered the question.
He answered the question.
Yes.
You, however, are in an executive role. The reason the question that Honorable Maduna asked is important is because you are also supposed to have a perspective on these matters as a person who manages performance. And that's why I think you must try and indulge Honorable Kubeka with an answer.
Thank you, Chair. Honorable Member, one, we have a system whereby we provide instructions to the state attorneys. However, we still have cases on the default court roll. And it's default court rolls because there are certain things that we had not done as the Road Accident Fund that will end up at the default court roll. And there are also cases...
Why were those things not done?
For example, the way that your state, firstly, it's because our state attorneys are not enough to handle the workload that we have or the amount of cases that goes to court. So the state attorneys are not enough in terms of numbers, physical numbers, warm bodies. They are not enough for the number of court cases that we have.
What did you do about that, not the numbers not being enough?
We are filling in the positions. One of the things that we had done, because we've seen that we have been losing state attorneys because they were on a contract basis, was to say we are then converting all state attorneys from contracts to permanent, because we were losing them as they are on contract basis. When their appointments out there on permanent positions, then they would leave.
When they were leaving, and you would see that they are leaving because their contracts were expiring and whatever else, seeing that you were the person who was in charge of that, what did you do about that?
We have then said, Honorable Member, can we then convert all of them to be permanent? That's what we have done.
Okay, and then the outstanding number, because you were short-staffed?
The outstanding number.
Why not go on a rapid recruitment drive to fill in those posts? Because I think the issue here is the amount of money that the Road Accident Fund was losing was largely due to, or partly due to, the issues that arose from your office. And this is why I'm laboring on this one.
Honorable Member, the amount of money RAF was losing in what? In courts? At the courts? Or
at the courts with default judgments and...
Yeah. You know, I think maybe I need to clarify this. And it's in no way saying that default judgments are good. But we must remember that even when, one, we're saying that the judges, during a default matter in front of the judge, they really look at the case and apply their mind on that matter before them. So they just don't rubber stamp whatever the plaintiff attorney says is due to the claimant. They apply their mind so that then they can then take a decision whether this amount is valid or not, first. Secondly, there is a belief that default judgment are fruitless and wasteful. They are not. They are part of paying claims. They are part of the claims expenditure. And this matter was discussed as well with the Office of the AG during the last financial year's audit, whereby they were saying, there was a query to say, we feel that default judgment are fruitless and wasteful expenditures because they're not defended. We then took through the AG how a default judgment comes about, and where do we put it in terms of our records at RAF, because then a default judgment will be ticked from the RNYP as a claim that has a claim expenditure that has then been paid. The AGSA then removed that query to say, okay, we understand where you're coming from. That is not fruitless and wasteful expenditure. And that is in no means saying that default judgments are good, by the way.
Okay, so are you basically then saying that there's no need for RAF to be defending if then you are saying that the judges must use their own discretion in this matter?
No. And that's why I started to say...
Is that not what you're implying, though?
No, what I'm implying is that judges make up their mind as well when we are not there in the default judgment court roll. And we will not be there because I've just said that because of the amount of people, the warm bodies that we require for those default judgments. And our default judgment have increased since the introduction of the RAF 1 form, because there's been a number of forms that were turned away from operations side that then summonses were issued on them.
Okay, Chair, I think I'll move on from this one because I think we're not going to find each other with Ms. Khumalo on this one. Chair, I think we've been here for a couple of weeks. And in that space, we've got a CEO that was suspended. An acting CEO came in. He too has been suspended. The board has been dissolved. We've got an interim board now at the Road Accident Fund. We've got a suspended head of the office of the chief executive officer. We've got a suspended chief governance officer. We've got a suspended senior HR manager. We've got a suspended CFO. We've got a suspended senior treasury specialist. And a suspended acting chief investment officer. I guess there's also a chief investment officer was suspended. And an acting CEO came in, he too has been suspended. So I would like to ask the team, between Ms. Manyasha, Ms. Khumalo, kwenzakalani RAF bafethu? According to you, just briefly in 1-2 minutes, indulge us, kwenzakalani RAF?
You can also just say KURAF. That suffices in terms of Parliament's rules.
We do have a saying that Raf, and it has been that for a few years we had a saying that working for RAF is an extreme sport. We need extra insurance.
I think we'll have to accept that answer, Chair, because I don't think there's any one correct way to answer that one. Moving on, Chair. There was a contract that we spoke about, that contract with Media Mix, and I think it was Zinge. I wanted to know, Ms. Khumalo, were any services rendered and payments authorized before RAF signed those contracts? So basically, were there any payments paid to the service providers? And were any services rendered before the Road Accident Fund signed those contracts?
Honorable Member, my role as per DOA with regards to these contracts is to sign the service provider agreement. And my role in that is to check that the contracts are legally compliant with what was on the tender. But in terms of whether what was tendered upon or what was awarded is what the service provider is indeed doing and the invoicing thereof, it's up to the various business units. I don't get involved.
So you wouldn't know if any services were rendered and if any monies were paid? Because the next question would have been, how much was paid before the road accident fund signed off? So basically,
No,
you
I
wouldn't be able
wouldn't.
to answer.
No.
Okay, now I think because you were basically doing oversight on the correctness of the paperwork, correct?
Correctness of the service level agreement.
Okay, can you explain to us then why there were no witnesses from the road accident fund who signed the contracts?
I think that question must then go to SCM, because I would sign as a delegated authority on behalf of the CEO. Then it's for SCM then to be able to make sure then the witnesses sign on those contracts.
So when you sign on behalf of the CEO, you are signing at the end, not correct?
At the end.
At the end, when SCM is done with the paperwork, it's gone through bid adjudication, bid evaluation.
Correct.
It comes to the CEO, and you sign on behalf of the CEO.
Correct.
So when that happens, or at that point, were you not aware that no witness is signed on behalf of the road accident fund? So it was just basically signed by you.
The witnesses would usually sign after I have signed. The witnesses, RAF's witnesses will sign after I have signed.
Now, if if they sign after you have signed, the contract still carries on after that. So once you sign, you signed, and you don't know what's going on thereafter.
Remember, honorable member, the service provider agreement. Remember let me start from the beginning. What I said when this issue was discussed was that once the board or the committee approves a contract or awards a contract, what happens is then SCM would then provide an award letter to the service provider, and with that award letter, they would also then sign an SBD 7.2 form. That form says you can start working. So you are basically saying you can start doing the job while we finalize the service provider agreement. And that's when then the service provider agreement, then that's where you'll find that service providers then start the work, and the service provider agreement is signed afterwards while they are busy with the contract. So that's what happens. The award letter and the SBD says, you start giving us the 100 T-shirts and you'll give us 50 T-shirts per month, for example. That's in the award letter and the SBD. For me, I look at it goes through all the processes, and legal looks at the content of the agreement to say it is not outside the objective of the RAF, it's not illegal. So that's what we look at, and then I sign.
Okay.
Last one, Honorable Gogo,
Okay,
injury time.
Injury time. Okay, so, Chair. I think, Chair, maybe we need to figure out who can answer the questions I'm asking here, because these two contracts, I believe, were worth about 1 billion rand. I think we need to know how much was spent before the contracts were signed, and what basically happened there. How much was basically paid before the office of the CEO signed. We need to understand what services were rendered and what do these people do for 1 billion rand. I think I would like to know that. And Chair, if I may, to Ms. Manyasha, in your role as acting chief corporate support officer, that included oversight of security. I wanted to know, what action did you take in response to operational irregularities that were reported by the staff in that space? And I'll make an example. There was an issue, for instance, of a fuel bill of 1.7 million rand in 1 year for one person. I think Honorable Matuna labored that point last week. Did you have any comments there? And then to Mr. Letsoalo, why were so many people on suspension for so long at the Road Accident Fund with your office keeping quiet? Thank you, Chair.
Thank you, Honorable Kubeka. I must state that security services was reporting directly to the CEO. Security Services was only moved to corporate support, where I was acting in November 2024. So I had no sight of the spending in terms of, and the procurement in terms of anything security related up until last year, November.
Mr. Letsoalo.
Thank you, Honorable Kubeka. The reason why we had so many people suspended for such a long time, I have already mentioned that most of the people, in fact more than 200, were claims administrators who were suspended because they couldn't load claims within the 180 days as per the court order. Now, what compounded the whole issue was one, capacity. I've indicated that the RAF uses attorneys to manage discipline. They use attorneys to manage disputes at both the CCMA and the Labour Court. Now, at some point, we ran out of funds, and I had requested for more funds. I think I was advised, if I'm not mistaken, by the CFO, Ms. Bernice Potgieter, to approach the CEO, if not Mr. Peter Malele, to go to the office of the CEO, because the CEO had a budget on special projects, so I could get money from that end. I then prepared a submission as per procedure, but the CEO declined my request. Then I went to other business units, and here and there I would get 2 million, 3 million, and at that time there were lawyers also who were owed money. So basically those are the two major reasons why those people's hearings could not be expedited timelessly. Thank you.
Thank you. You can come back, Honorable Kubeka. So I wanted to remind those of us who voted in '94 that when the World Cup was held in Korea, the coach was Jomoson, and he took somebody called a special projects manager to spray things there on the field so that we can win. We did score against Spain. So now I hear you mentioning special projects there, and I'm wondering.
No, that was what I was told, either by the CFO.
But it's not. It's not those special projects. It's not those special projects.
Chair, I do have a question on special projects coming up later.
Okay.
Because I want to understand what does that mean, special projects.
Please don't direct it to me, Honorable.
So can I just that question around witnessing is important. So. Ms. Khumalo, do you know why witnessing is important on a contract? What is the purpose of witnessing? What's the witness supposed to do?
Chairperson, according to my understanding, is that they are witnessing that you are indeed signing and acknowledging what is in the document that you are signing.
Okay, so in other words, it's you. So if it's got your name there, that they saw you signing the document, and that nobody was pointing a gun at you unless the witness was pointing the gun. But yeah, so basically, I think we are of the same mind, right? The reason that's important, because I noticed that the contract that the Honorable Nondenja was referring to, you remember that difficulty we were dealing with? That contract is not witnessed. It's not witnessed. We wouldn't be having this difficulty now if it was. I'm just stating that. We wouldn't be having this difficulty because the witness would then be able to provide the clarification. There might be nothing to the, and with the, might really be a typo. Maybe they took an agreement from somewhere else that hadn't been signed. Somebody forgot, but now we don't know, and it looks improper at this stage. I'm just saying, I noticed with several significant contracts, this one is for 500 million. It's signed by you, no witness. Then there's another one, it's also signed by yourself, 500 million, no witness. And we'll talk about it later. But now, if somebody had witnessed, we would be having a different conversation here. And I noticed with other contracts that the RAF doesn't appear to do witnessing much. Is it like a practice that the contracts don't get witnessed?
Chairperson, I think what I see is that Mampi indeed signed those contracts is because they are digital signatures that also tells the time that I signed. So my expectation is that then once I sign, because it's digital, then it goes back to SCM. For SCM then to be able to then finalize the witnessing part of it. With regards to the contract that Honorable Matenja was talking about on the dates, during break, I had my legal guys then look into it.
Honorable Non-Danger.
Sorry, and apologies, Honorable Non-Danger. Apologies, ma'am. Apologies. Chair, so what has been said is, this is how things went. The board approved the award 29 October 2022. Then Media Mix signed the contract, the service providers agreement on the 8th of December 2022. I signed the contract 22 February 2023 because I would not have signed it in February 2022 because I was not even at the RAF. So what happens is, apparently, SCM, when they take the contracts to the service provider to sign first, they already pre-populate the year because it was during that 2022. So they had already populated the 2022 year in the contract. That's why it's typed. What should have happened is when it came back from the service provider, the 2022 should have been changed to 2023 and signed accordingly on the side. So the correct date of the signature is my digital signature of the 22nd of Feb 2023.
Okay, I'll come to you, Honorable Matuna. Okay, thank you very much for that clarification, because that's why I was saying it may well be nothing, but we do need to know. Later on, we'll talk about the Tsinge contract, because then your digital signatures also don't look the same. But let's park that. So there are these difficulties where at least we need to clarify some of these things. The last thing that I wanted to ask you, so that we don't forget the point, I do want us to, I'll put a proposition to you because I just want us to cut to the chase. One of the things we've canvassed, I think we did so with Mr. Philip, and I think with Mr. Phillips, and I think we've done so with another witness. Here is what appears to have occurred. Right? And I'd just like you to respond to the comment, and I'm going to put a proposition to you. Mr. Phillips said some of the attorneys have a caseload of 4,000 or more each. Right? In fact, Mr. Baloi was also here. Him and I had a back and forth. Right? And I said my expectation is, and I want to disabuse, at least where I'm concerned, that some of us are fighting for the panel of attorneys. My expectation would be a decision is taken that the panel of attorneys is costing us too much. We need to move away from it. But the RAF has matters at court, I think literally every day or whatever, but there's per week there's any number of matters at court. You don't want those matters to fall between the cracks and for people, as it happens, to be needed at 2-3 different courtrooms at the same time, because they just can't. Some of what we were told is that some of the claims administrators or handlers who ended up falling under that blanket demand that they must be suspended, they also themselves have a massive caseload. Sometimes they've got to appear in court and so on. And so when the manager looked at these cases, like, these people are overwhelmed. They can't, they're battling to touch sides, right? What appears to be a reasonable thing for management to do is to say, we want to move away from the panel of attorneys. It takes time to recruit new people. So we're going to need to do it gradually, so that we don't have these problems. Already the cases, even with the panel of attorneys, are a lot. We need to migrate so that over time, the number of cases that are handled by attorneys declines, and we pick up on the state attorney's side so that you minimize the disruption. Because here is what happens and why this default judgment issue is important. What happens is two things. One, there's now no panel of attorneys. Some of them won't even give you your files back because they're demanding payment or whatever reason. One. Two, 200 claims administrators have to be gotten rid of, or they have to be disciplined. Let me put it like that. They have to be disciplined. So you've got destruction of capacity on the legal side. You have destruction of capacity on the management of claims, which sees an explosion in the number of matters that are undefended, partly because even your capacity to conclude them within the 180 days is gone. And as a result, the Road Accident Fund ends up paying a lot more. That is the observation I am making after listening to everybody speaking here. And I said earlier, our concern here is the money. Am I being unreasonable in this expectation that a prudent management and board would look at things in that way and take decisions and implement them in a way that does not financially prejudice the institution? Am I missing something in that explanation? Because this does not need to be a fight. And I'm not trying to get you or anybody. Just discuss this with me in the committee, because we just want to get to how we can recuse something in that explanation, because this does not need to be a fight. And I'm not trying to get you or anybody. Just discuss this with me in the committee, because we just want to get to how we can recuse.
Chairperson, I agree with you in terms of what needs to be done and as management. And when the panel of attorneys contract came to an end by a fraction of time, and I was not around when the state attorney model was introduced. I was not at RAF yet.
No. We're just having a discussion now as observers. Okay, yeah. No, I'm not trying to get you.
Yeah,
no, please.
No, I'm saying, and I was going to say, Chairperson, that I was not around, but I have read minutes, discussions of what happened, why were certain decisions made around the panel and the state attorneys. I've read the Mambunda judgment, etc. And from the, and I'm quoting from the court, from the Judge Fisher, not Judge Fisher, Judge Davis himself, when he was dealing with this issue around the panel of attorneys when they wanted their contracts to be extended, to say that he showed that the RAF had plans in place to say, how do we phase out the panel and bring in the state attorneys? To an extent that the contract of the panel of attorneys was extended by 6 months. They were given timelines to say the contract, we're extending it by 6 months. They changed some certain terms of reference on the contract and said we are extending it by 6 months, and here is a plan in terms of what files you need to give us by when, so that we must be able to have sight of what is happening at the courts. They even gave them the spreadsheets in terms of saying, give us the files that you have, unfinished business, finished business, etc. Then the RAF also had plans to say, then how are we going to deal with these matters that were held by the panel? And part of the solutions was that's when they then approached the GPF panel to say, please assist us.
Okay, I want us to walk through this slowly together, because I don't want us to confuse. So let me ask this question. So let's leave the court out for now. What we know, you've said it, and Mr. Phillips has said it in his evidence, that you don't have enough attorneys, state attorneys. Mr. Phillips gave us an indication of some of the early challenges. People not having a right to appear. There were certain things that needed. So there were gremlins in the beginning where even though the warm bodies were in the office, they still couldn't go to court because you had to work through certain things, right? You would know what those are. That's number one. Number two, it takes time to recruit people, right? And he explained the process, and I have no fight with that. These are the realities of recruitment, right? All I'm saying is that somebody should have asked questions before the implementation of the decision to say, guys, what's involved in getting this done? I don't have an issue with where the RAF gets his lawyers. I really couldn't care two hoots. If it's the right lawyers, qualified, they show up in court, they deal with the matters, outside, negotiate with the other. I don't care. All I care about is whether there was a plan in place, and it doesn't appear that there would be one, because why else would somebody have a caseload of more than 4,000? And you've got that 180-day thing. You understand? In your reading of internal documents, was there a project plan that spans 2-3 years because of the difficulties Mr. Phillips told us about of recruiting the number of people? He still doesn't have enough people. You are the head of the function. You've got executive responsibility. So I'm not fighting with you. I'm just saying, am I unreasonable in having this expectation that this is what must happen? Because, by the way, John Modise, who sat there and broke down and cried, you remember why he was disciplined, eh? Can you remember? I will remind you, he extended the bid period for the attorneys. He's lost everything. So you can't sit here and tell us it was done when somebody was disciplined for it. So can we walk through? Was there a plan? Have you seen it? Because I want to see it. I've asked for it. We have thousands of pages of documents. It's not there prior to the decision being taken. Have you seen it?
Chairperson, and my initial saying to say I'm referring to Judge Davis' judgment on the Mabuna case is because he's referring to the documents that was before him from RAF to say, how are we preparing?
Okay, so your answer is that document exists.
Chair, I don't know. I looked at the court papers, and that's why I said to you, I did a disclaimer to say I looked at the court papers. That was my first.
Okay, so let me assist you again. You remember in the beginning where I said stay with matters that are within your personal knowledge. You remember that to avoid this exchange. So I'm not fighting with you. Have you seen, since you arrived, you've got executive responsibility for this problem, right? Have you seen somewhere where there was a plan? Because absent of that, I don't understand how so many attorneys are fired at once, and then you realize even the few that you have can't even appear in court. Somebody should have known that. That's all I'm saying. And that's one of the reasons we are here. Because the default judgments happen because nobody is there to represent the RAF, and the members have an anxiety that some chancer who's really good at putting their documents and things together with a smooth, slick-haired lawyer, instead of getting 80,000 rand, gets 2 million because there's nobody there. You understand what we are concerned with here?
Yes, Chair, I agree with you. I mean, in hindsight, the plan was not adequate because it did not deal with these unknowns that have now become the knowns.
Okay, last question from me. Why would it be an unknown? I don't work there. As a manager, I don't even have to be a lawyer. There is a transition plan. There is a project manager appointed. There is a project team. All the cases are logged. There's a spreadsheet. Somebody knows which cases are appearing next week. Okay, these attorneys will give them these 10 cases to conclude. By then, we'll have somebody who takes over their files, etc., etc. It's not rocket science. You can't tell us it's an unknown. It can't be, Ms. Khumalo. It genuinely cannot be. Because I am worried when you say that it is an unknown for executives who manage 50 billion rand of taxpayers' money.
Chair, the unknown part of it is around the number of default judgment that have since spiraled. And part of it is that they've spiraled because of the introductions of directives, blah, 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 blah. So that's the unknown part.
Okay, now you're doing an advocate Dalimbofu now of saying blah blah blah, and blah 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 doesn't have a meaning. Okay, we can canvass this later. I'm delaying Honorable Madlala, but you know, some of these things don't have to be painful for us to talk about. Like I said, we are now having a discussion. We're really trying to get to the bottom of problems, right? So that we know what happened. We can make recommendations that assist the Road Accident Fund and other institutions. So it doesn't need to be, you know, a push and pull like this. Honorable Madonna, you're really going to get beaten up by Honorable Madlala, but let's hear.
No, Chair, I just want to establish from Khumalo. I hear that, and I've been hearing this. Is she trying to say to us it's not necessary for between a service provider and RAF to get into contract, sign before the work resumes? That's what I'm trying to get.
Before the work is implemented. Okay, cool, thanks.
Chairperson, maybe, and I've been thinking about that. I don't know if the service provider agreement have been shared, or an example of it had been shared with the committee.
Yes, we have them, yeah.
You have it, okay. Because I think, and I want to read part of my response that I had to write around signing of the SPA vis-a-vis the award letter and the SBD 7.2 form. Maybe let me read it so that it's clear, Honorable Member. So it was part of my responses on around this issue of signing of SPAs, to say that it must be noted that in the conditions of the SBD 7.2, it says that the service provider agreement, that's the document that I signed, will be drafted, negotiated, and signed by both parties during the contracting. Once the award letter and the SBD 7.2 forms are issued, and the latter was signed by the representative, then the services can therefore start to be rendered. So that's what happens. And I think maybe, Honorable Member, I know the CFO is coming tomorrow with the supply chain management head. Then they will be able to then dwell further into this issue around that provision of an award letter and signing of the SBD form says that you may start with the work while we are busy finalizing the service provider agreement.
What does SBD stand for? What is that SBD letter thing?
It is the standard bidding document, yeah, standard bidding document.
Can you just explain what that does?
Let me see, Chair. I think I had, a copy of that.
No, just describe it. What is its purpose? We just want to see in relation to the work being done. Why does it authorize the work before the service level agreement is signed?
My colleague is saying I think it's an interim agreement.
No, your colleague can answer by the. I just want to understand. Honestly, we just want to understand. So.
And I'm talking under correction. It's an interim agreement to say this is the work that you're going to be doing. I will get it now. I have it in my laptop.
Okay, no, that's fine. We can get it later. Just in the meantime, I'm going to hand over to Honorable Madlala. So in the meantime, if you can assist each other to just pull up a version so you can explain this to us. Honorable Madlala.
Thank you, Chair. And greetings to honorable members and to our witnesses and the members of the public at home.
Let me first start by asking Mr. Letsoalo. In your introduction, you said that part of what you do involves training on ER matters. I just want to understand, what is this training about? In the context that, or in the context of the evidence brought before us, that internal officials do not handle disciplinary processes. They are largely given to attorneys. So what is this training on ER matters that you do?
Honorable Madlala, training in ER matters would entail training managers on chairing disciplinary hearings, grievance hearings, incapacity procedures, as well as training supervisors on how to initiate disciplinary processes. Thank you.
And why would you train them if the work is done by attorneys? Why would you train managers on how to do that?
I don't want to say it's common cause, but I want to say it's part of the ER function to ensure that managers are trained, supervisors are trained. To some degree, you'd also train unions and ordinary employees, because employees lodge grievances. So it's a bottom-up communication process. They need to know how the procedure works.
Okay. Sorry to just disturb you. I understand that to be the normal thing. So I want to just understand, where does then the perspective come from that the attorneys must then deal with that? Because I understand from an organizational point of view that such work is generally handled by the line supervision and line managers and so forth. So you, as responsible for ER, at what point do you then relegate that function or get an instruction that it must be given to attorneys?
To answer your question, remember, in disciplinary processes, or let me say, disciplinary processes take two forms, informal and formal. So obviously, informal would be for minor offenses or transgressions, where you would then sit with an employee, offer counseling and things like those. Now, if you talk formal disciplinary hearings, that's when matters are complex. Matters involve serious transgressions, maybe, for an example, gross dishonesty, fraud, and related.
All right, Mr. Letsoalo, I'm trying to be economic about my own time here. I'm a former human capital manager. I've worked in an organization. I understand exactly what disciplinary processes entail. I want to understand, when you speak about prosecution and chairing disciplinary hearings, that doesn't apply to informal processes. There is a formal process where then there's an appointment of those officials. In an informal process, it's your supervisor doing that. So you're saying your training related to how to prosecute matters and all of those kind of things. Was that my understanding? Maybe I did not understand you well. Or you are saying that your training was on how to provide counseling? Because once you speak of handling disciplinary matters, I understand that we're already on a formal disciplinary process, not an informal one.
I think even in informal matters, Honorable Member, because if you don't offer that kind of training, then you'll have an influx of managers coming to your office for things that they could have resolved amongst themselves, between the manager and the employee involved. So it is important that they know from that background up until when matters go to formal DCs.
All right, let me ask one last question. I'll formulate my own conclusion after it. Maybe you'll take me through the process at RAF. Maybe that's what I need to understand. Because my understanding is that there will be a preliminary investigation to establish if there's a prima facie cause for a case. That will be subjected to or submitted to the person with the delegated authority to make a determination. And that person will say whether there should be an informal or a formal hearing. In an event that they say there should be a formal hearing because of the severity of the offense, they will then, appoint accordingly who becomes the presiding officer and the employer representatives on the matter. Is that my understanding of normal disciplinary process is the same as applicable at RAF.
Correct.
Right. So who then determines that there must be an involvement of an attorney?
Like I've indicated from the beginning, that is a system that I found at the RAF, that there is a panel of attorneys. However, when it comes to a matter that is deemed complex, I would say, ER manager, do you need assistance? If the answer is yes, then we would appoint an attorney to manage the matter. Yes.
Okay, let me ask one last question. I thought I was done with this thing. The reason why I said who is because I assume that there could be someone who says, we need an attorney. You are saying it's a process. So is there a policy in place that regulates? Because you are not answering me in terms of who. So then my other assumption is that then there's a policy in place, or you're saying it's a system, but what informs the system should be regulated by something. If it's not a person who applies his own mind and say, I think this one requires an attorney, I think this one based on the severity of it. So you are not answering me in terms of who. Is there a policy at RAF which then regulates that matters of this level of conduct, of misconduct or alleged misconduct, require an attorney?
I don't know why.
It's fine, thank you. We can move from that. You spoke about my understanding again of disciplinary process, because this one relates to the bulk dismissals of employees. You mentioned some things that were worrying to me. For example, that there were negotiations of lesser sanctions, that the CEO seemed to have been involved in the negotiations, where he said that he doesn't get involved and all of that. But I just need to understand, because once the process has been as started of a disciplinary hearing, it's supposed to be a sort of an independent process, where then the presiding officer makes a determination on the sanction. Where does the CEO get in between, particularly as it comes to the point of determining a sanction? Because then the merits of the case, on a balance of probability in the case of internal disciplinary processes, would be looked into, evidences and all of that brought into play, and then the presiding officer makes a decision. You seem to be bringing in the CEO in somewhere in between the beginning of the process, but right before a sanction is issued. Can you just clarify that for me?
Thank you, Honorable Madlala. What happened with these matters is that from the onset, it was the CEO who issued an instruction. And it went up to a point where the union, which was NUMSA at the time, wanted to engage the RAF, and the CEO said that they must engage him. I was in that meeting where he was engaged.
Sorry, just before you proceed, let's deal with that part. The CEO issued an instruction. What was the instruction, and to who? What was the details of the? Do you have it in writing? What was the details of the instruction, and to who?
Well, the instruction from the CEO I got through my line manager, which was Ian Barriel, that there are employees at the regions who did not. What is the word?
Who were not compliant with 180 days, whatever.
Yes, and those employees needed to be charged, and he did no longer need them at the RAF.
You have that instruction in writing?
No, I don't have.
So your line manager says to you, yes, these employees must be fired, yes, in Samar.
Yes.
And you, as a senior manager, as an ER person, an ethical professional being sitting in that position, what do you then do with that instruction?
Well, I sat with my team and said to them, there has to be an investigation. You can't just fire without getting the facts. But then we were overruled. Hence, I say the national office of the union that was recognized at the time came in. And there was a meeting between that union.
Sorry, you said we were overruled. We don't want to speculate who overruled you. You remember, you said there must be an investigation. We were overruled. Can you just say who overruled?
Okay.
Sorry, maybe just before you answer, please also provide clarity of thought around what you've just said now. You are saying that the instruction came from above you, but you sat with your team and you were overruled. So you did not sit with the person who gave you the instruction, but somehow in the process, you were over. Just clarify that part, which says, I received an instruction, sat with my team, wrote a response letter to the person who gave me the instruction, and this was their feedback in terms of overruling. Give us a clearer picture.
I want to state that I can't remember whether there was anything in writing, but all what I can remember is that there were several meetings with my line manager, who happened to be Mr. Ian Burial. When I went to the team, myself and the team agreed that there has to be investigations. But I then had to go back to Mr. Ian and said, look, firing employees without a formal hearing in the circumstances, it's unfair in terms of procedure. Now, Mr. Burial said, this is an instruction from the CEO. This is what must be carried out. And like I said, the managers of most of these employees were against it because it was going to take away the capacity that they had to manage the claims.
I have received your response.
Okay.
And I just have one follow-up on it. Because I want to understand exactly what you are saying.
Yeah.
Because what I'm hearing you saying now is that what you said is that firing employees without a process would be unfair.
Correct.
You are not saying, and I don't think that this is what the CEO was saying. The CEO was saying fire them, but I think the CEO was saying fire them through a process. And you are not saying that predetermining an outcome of a hearing is a problem. You are saying we should just subject them to a process, even if we want to fire them. And what I have a problem with is a predetermination of an outcome of a process that is supposed to be independent. So I need you to just carefully then tell us what was your view. Was it your view that the only problem is not subjecting them to a process? And was that even an issue on the table by the CEO to say don't subject them to a process?
It was practically or going to be practically impossible to have hearings for all those employees, more than 200. At some point, there was a directive from the CEO that a clause in the disciplinary policy, I can't remember whether it's 7.5, where the matters were supposed to be dispensed of by way of asking all those employees or some of the employees to make written representations as to why they couldn't be fired. And I think that was at the time when the union came in, wanting to negotiate with the CEO because they knew that the directive came from the office of the CEO.
Okay, no, it's fine. So the internal disciplinary process makes provision for collective misconduct, which is generally the part in the collective agreement. And in many other, in the Labor Relations Act and in many other collective agreements, like you're saying, you can't have a hearing for all of them, but there's a different collective misconduct process. You are saying that provision is there?
Not necessarily collective. I forgot what.
Okay, like you are saying, you'll write to all of them,
yes.
Say they must give written submissions, appoint a presiding person to look into those written submissions,
yes.
Write to them, tell them of the decision and all of that. So
yes.
That is provided for in the policy of RAF.
Yes, but obviously with the reasons why that could be applied, not for every misconduct. As far as,
Okay, just answer me on this part then, which I think you may have omitted. Still, in my understanding of that process, you would appoint an independent presiding officer. Where does the CEO come in terms of the determination of the outcome of dismissal or not in that process? Because still an independent person will be appointed, then the unions would represent and write on behalf of their members collectively or individually, whatever the case is, and then that presiding officer will have to take a decision. And that decision is not a decision generally taken in consultation with the CEO, because that person has an independent role. That's my understanding, but just indulge me on that.
I agree with your understanding, but that was not what was happening at the RAF. We were supposed to request those employees to write representations as to why they should not be dismissed, and the CEO was going to decide on those representations.
So the CEO in this matter was going to be the presiding officer?
In a way, because he was going to take decisions.
All right, no problem. I have my own conclusion. Thank you.
You are entering injury time, but 2 more questions.
Okay. All right. Thank you, Chair. I think I'll take the 2 and then I'll come back on the last 15 minutes with the other questions. I wanted to ask Okay, just this one pending question. I'm going to ask other question. Ms. I think that's the right pronunciation. Ms. Manyasha. You seem to have worked with Mr. Letsoalo for quite a long time. You seem to have been one of his most preferred person. But you also share the sentiments that working at RAF in the last couple of years was you said, I can't remember the exact words, but you highlighted it to be a challenge.
Extreme sport.
An extreme sport. And you survived that extreme sport until recently. But you survived it in the last 3 years. I want to understand in your own words, in a minute, why would you specifically, forget the institution, why would you regard it as an extreme sport?
Letsoalo, if you switch off your mic, we can hear Ms. Manyasha better.
I think from the time that I joined the Road Accident Fund, obviously it's a space that was unknown to me, even though I was working at the Department of Transport. And being a new space, finding the challenges that I observed working with Mr. Letsoalo, there was a lot to be done. And that lot had to be done in a very short space of time. There was a lot of pressure in terms of making sure that the work is done. Mr. Letsoalo is a hard taskmaster. If something needs to be done, it has to be done. So it has been a very pressurized environment since the time I joined the Road Accident Fund. Up until now, I think I can't say it's getting better, but it's been a very pressurized space for the past few years. The difficulties in the Road Accident Fund are not starting now. Every day there's a problem that we would sit and try to resolve. And yeah, as you know, I mean, even in the previous administration, there has been a lot of problems that the executive and the board were trying to get around. And for that to happen and the efficiencies that had to be brought over the past few years, it has not been easy for any of the executives. I would attend EXCO meetings, but not as an EXCO member, because I'm not an executive. I'm supporting the CEO. However, the conversations that were in those meetings and implementing that strategy from 2020 to 2025 has been a very difficult task, I must be honest, and very pressurized also. Working with the limited resources that we have, I must admit, Chair, that what the legal guys are saying in terms of resources is not only in legal, where we found to not have enough resources. However, I believe that certain things we could have done better. We could have maybe taken things bite by bite instead of taking a lot of things. I think we took a lot of work and tried to do it in a very short space of time. And I think in hindsight, we could have maybe taken things in Afrikaans biggie. Maybe we could have...
All right. I get your response. I will have some follow-ups after... on my last 15 minutes.
During second half of extra time.
Yeah. No, that's fine. Your extreme sport of it is on a different perspective from what everyone else is saying. You were at the highest office. You were setting the strategy. You were in charge. So I will have my follow-up questions. Let me just have one question for you, Ms. Khumalo. Khumalo would be probably the, because there's no right pronunciation. Or Khumalo. Oh, okay, no, that's fine. Thank you. The issue of the head legal, which has been vacant for over 3 years now. I want to understand, you keep making reference that you do have advocates. I want to know if you've ever had an acting person in the role. It's been vacant, you're struggling to fill it, and I think that has been ventilated. Have you ever then appointed someone on an acting capacity or a responsibility allowance capacity? Because I'm trying to think whether the duties of that office fell right to you, or they were disseminated into the various advocates to handle on behalf of the sections, as you have mentioned it. Because and then what has been the the equivalent compensation to that, because there's a financial aspect. This was speaking about a funded vacant position here. Then someone who does the duties would have had to be remunerated for, and also the level of accountability and responsibility be added, as well as consequence management where there's been failure to deliver. At this point, I'm just hearing a void in terms of that, because you are operating at a senior level, and there's a gap in between. Can you just clarify if what happened to those duties? Was there a responsibility allowance or an acting issued against that post? Or the duties were then separated in line with the senior the advocates who then advise you? If you can just give me clarity on that, I'll make probably one last follow-up question on that, and then that will be the end. Thank you.
Right. This was your last. Please answer the question. It's trying to get extra time of extra time.
Thank you, Honourable Member. So, I had appointed an acting head. Ms. Moahi was acting as the acting head for a while. And then she requested not to act any longer. But before then, and she was remunerated for it during her acting. With the vacancy, there isn't anybody remunerated for the acting, because I'm assuming those responsibilities. So what happens is the 3 advocates in their 3 different units would then report to me instead of reporting to the head. So in an ideal situation, when I have a head legal services, the head legal services will then report to me, while the 3 advocates then will report to the head legal services. But in this case, the 3 of them report to me, provide me with advice, legal advice in the various divisions that we then discuss. Then I will take the decisions or take the proposals further. So that's how it's working.
Thank you very much. Let's just indulge one more member, Honorable Isaac, then we go for lunch for 45 minutes. You look surprised. Mzala, are you good to go? Okay, the clock's ticking. Thank you.
Thank you, Chair. Good day. Good afternoon, colleagues. Chairperson, yeah, I think I'll just go. I'll go straight to Ms. Manyasha here. Ms. Manyasha, lots has been said. So, if I'm duplicating something, please forgive me. But I'll try to be concise. And what's ironical, this is just an opening comment, is that, and I say this again with due respect, is that you seem to feature, as the main individual or character in all these tender debacles that are coming up and that we're discussing over an extended period of time. So obviously you're probably an individual with immense influence, if I might make that comment, because of everything that comes across here. If I can ask you, what was the business rationale about the outsourcing of the RAF call center? So I'll just do one question at a time. You answer, I'll come back with the next question. If that's okay with you, Chair? Yeah, thank you.
Chair, through you, I'll answer that question at a very high level because it was not in the scope of the letter that I have received. There was a business case that was developed for establishing a customer relationships management service. And the rationale for that was that the Road Accident Fund was having too many channels of communicating with stakeholders and mainly claimants. And the contact center that we had at the time was working as sort of a reception. Like people would just call and they would just get a basic answer. So the CRM came about as a way of consolidating that service, and also to to make sure that Road Accident Fund gets information. It's not just for us to answer calls and to respond, but to also gather information in terms of what is it that the claimants are complaining about. So that CRM is giving us information. It is digital. It has digital customer engagement capabilities, whereby we are able to see that this person has called for this many times. This person has called for this kind of a query. So we're managing our relationships with our customers in that. So the call center was not outsourced in that way, because the call center that we had, which had about around 30 people, they could not, they did not have data intelligence because the system they were using did not have that intelligence. And the number of calls that were going everywhere in the organization, and it was not centralized. So the main thing was to centralize the communication and to also gather intelligence in terms of how to deal with our customers. Thank you.
Okay, so what you're saying is that obviously it was funded.
Understand the question? Okay, can you please clarify? Also, what do you mean it was funded?
So how was it funded then? I mean, where did the money come from just to set this thing up? Because you needed more people, you needed more funds, you needed more money. I mean, how was this decision made?
So the Department of, I think, Public Works, I think it's Public Works, had a tender for a CRM system, which we participated in. And we got the service provider through that participation in a tender. So the business case was written, and it was budgeted for. The funds were allocated to that project.
Okay, so it was another tender taken care of.
It was a participation in a tender.
Thank you, ma'am. Ma'am, can I ask you, do you know the owners of Alterum?
I know them because I have worked with them in the CRM. Before that, I met them at the DLCA, where they were co-sourced for the provision of, I think, the machinery that the DLCA is using now. So personally, no, I don't know them, but I have interacted with them before at the DLCA.
So you're aware of them? Okay, because the notes that I looked at on Sunday, if I can recall also, spoke to the contract value with them, and correct me if I'm wrong, the contract value with them was initially some 200 million rand, right? And then, of course, that very same contract was extended to 506 million rand. Now, in your opinion, does this not contravene the prescripts of the PFMA, being so well versed in signing off on tenders?
Apologies, I didn't get the last part, being so versed in?
In signing off on tenders and having lots of experience with all these tenders that come across your desk. So my question is, again, I'll repeat, the tender was 200 million rand, and then extended to 506 million rand, according to my notes. My question is, I mean, do you not honestly believe that this seriously contravenes the prescripts of the PFMA, the Public Finance Management Act? You get it, ma'am, or shall I put it in not simple English? Okay.
Thank you, Honorable Isaac. I don't get involved in a lot of tenders. I think, as I'm saying on this one, it was not a tender that the Road Accident Fund initiated. It was a participation. The people that get involved is supply chain management. In terms of the extension of the contract also, the business unit would go to supply chain management and indicate that because of whatever reason that they're putting on the table, there needs to be an extension of a contract. That contract extension would go through the stages of BAC. First of all, request BAC to extend the contract. It will go to OPSIT, which is a subcommittee of the board, and it would go to the board. And there will be reasons why this contract should be extended. So it is not my decision to extend contracts. It goes through the supply chain processes, and it is in line with the business strategy of the period that we are looking at. So it is not a decision that I would personally make.
Sorry, can I just interrupt? So I have a thing with acronyms. What is DLCA?
The driving license card account. It's an entity under the Department of Transport that prints driver's licenses.
Oh, I see. Okay. All right. Thank you.
Thank you. Okay, so you say you obviously wouldn't make that decision. It goes to the board. The BAC would obviously, but you sit on the BAC, right? And you obviously have a certain element of influence and having to give some sense of direction to move a contract from 200 million to 506 million. I mean, you sit on the BAC, and it's your input. I think that is of essence.
Mr. Honorable Isaac, in my substantive position as the head office of the CEO, I do not sit in the BAC. When I was acting as Chief Corporate Support Officer, I did sit on the BAC, but at the time when this contract was started, I did not sit at the BAC. When it was extended, I can't remember the period, I could have sat at the BAC because of my acting capacity. But in my substantive position, I don't sit at the BAC.
So when it was extended, you just said that you could have been then occupying the seat on the BAC when it was then extended from 200 million to 506 million. And at that point, you were there at the BAC, and you obviously had comments to make because the board obviously looked at you and asked you for guidance, and you had to give input. Am I correct, ma'am?
The board would get a presentation from the chairperson of OPSIT, who would have then gotten the input from the CEO.
Sorry, Ms. Manyasha, let's solve the acronym. What's OPSIT?
Oh.
Yeah.
It's the committee that deals with operations and ICT matters, as well as supply chain matters. It's a subcommittee of the board.
I think let's just park that for now. Let's just talk a little about when you arrived at RAF, ma'am. Okay. Now, upon your secondment to RAF, when you got employed at RAF, according to the notes again, you were on a salary scale of 500,000 rand. Okay? You will quantify that when you joined RAF. And currently, you're now earning 2.5 million rand a year plus perks. So, in spite of the fact that I don't know what additional qualifications came in between that period that motivated an increment of salary from 500,000 to 2.5 million plus perks. Maybe you can explain to committee what really justified this, that you could grow through the ranks so suddenly, so quick, with really no additional qualifications in the midst of that. So if you can just quantify that, and I'll move on again, Chairperson.
Honorable Isaac, the salary scales of government departments and the salary scales of SOEs or public entities are quite different. At the Department of Transport, I was a deputy director, and I had qualifications when I was at the Department of Transport. As I stated earlier on when I did my introduction, I possess the right qualifications to occupy those positions. And in between, I was acting as a senior manager in various positions when I was seconded. So I did not determine the salary at the Road Accident Fund. It was a position that was advertised at that salary level which I applied for, which I have qualifications for. So if you're asking if I do qualify for that position, absolutely yes, I do qualify for the position. As for the salary scales, they are very different from government to public entity.
Okay, great. Thank you for that one. Then I want to move on, Chairperson. I don't know, maybe I should do it round number 2.
You do have a few minutes, Honorable
Can I?
Isaac.
Okay,
Yeah,
quickly then, because I need to do some stuff with Mr. Letsoalo, but I think we'll do that when we come back. I'll just maybe close off on this one, talking to Ms. Manyasha. Ms. Manyasha, I got a note here again. Mr. Barriel testified here that human resources shared recruitment process information directly with you, okay? Including which recruitment agencies would be used and where CVs should be submitted, giving you absolute transparency and visibility of influencing appointments. Now that is what he testified here. What are your comments to that?
Honorable Isaac, I listened to Mr. Barriel's testimony. He was talking about the specialist positions, and I think I did earlier mention that they were shared with me. However, the agency that was to be used was decided by HR, not the office of the CEO, not the CEO himself, not myself. So those adverts would be shared with me. The adverts would be shared with me, but not necessarily that this is which agency should we use. So that is the prerogative of HR, which agency to use. The advert would be shared with me.
Okay, in my dying minutes for now, I'm going to sneak this one in quickly.
It's the minutes that are dying, not you. I just want to clear that.
Point taken, sir. Quick one. I'll just move quickly to Ms. Khumalo. Ms. Khumalo, did you know Mr. Collins Letsoalo, the CEO, prior to joining REF?
Honorable Member, yes, I did mention when I was doing my introductory remarks about where I started working. I did mention that he found me at RTMC, Road Traffic Management Corporation.
Okay, but did you work with him there, or he found you there?
He found me there, and he was transferred. Seconded from DOT to act as the acting CEO of RTMC.
Okay.
While I was there.
Okay, and then I don't mean to be personal here, okay, but how's the relationship right now between you and him?
What do you mean, how is the relationship?
I mean, what is the relationship like? What kind of relationship do you guys enjoy? Is it cordial? Is it peaceful?
Yes.
Everything is good?
Yes.
Awesome. Thank you, Chair.
Oh, thank you very much.
Sorry, but I'd like to get my opportunity when we come back after lunch.
Oh, no, of course. No.
Yeah.
As per suggestion. Okay, honorable members, I don't want
Thank you, sir.
So it is lunchtime. Could I ask that we return, don't kill me, at 2? So we'll break for 45 minutes. And thank you to our witnesses. There is lunch, right? So there's lunch downstairs. It's also for you. So I think Mr. Phillips knows it very well. He has visited before. He will lead the way. So we'll reconvene at 2 o'clock. Thank you so much. Honorable members, welcome. And Mr. Letsoalo, Ms. Khumalo, and Ms. Manyasha, welcome back as well. Can I take advantage of you, Ms. Khumalo, given your role, and ask a general question? So can you just explain to me how delegation of authority works? So if, in fact, let me start here. Can you just explain the financial authorization limits at the Road Accident Fund, just in general? Who's got authority to sign for how much? I'm going to how delegations work. So, I mean, you don't need to remember every level. Maybe what is considered a material amount. I mean, I understand managers have to sign for something.
I'm looking for that document because there is a document on the delegations of authority from, starting from guys from operations, what they can sign in terms of the claims.
No. You know, actually, I'm talking about invoices. I mean, I don't know if it falls within the same. You know, like what can a general manager authorize on their own without sending it upstairs, and what does the next person? You know, that just at that level, we're gonna get to the delegations.
I'll have to check, Chair. My colleague is looking for the document because really, I would really be speaking off the cuff.
Okay, let's talk about yours, and not you as Ms. Khumalo, but executives at your level, or at least the person below you, and then you, and then the chief executive. So that should be easier.
Me, I'll sign things up to 1 million as the executive.
As the executive. And then what do you send upstairs to a chief executive?
To the CEO above 1 million. And I think the CEO is
up
until
to
what? 30 million? 30 or 40 million? 40 million.
Up to 40 million. And then anything above that is the board. So when then there is delegation of authority, I am assuming the delegation flows down. In other words, it doesn't skip. It doesn't skip from the board and then it goes to a general manager. It would, it would go down the chain. So can you just explain how that gets passed on? More specifically, let us say the board had authorized, something for as delegated authority on delegation is specific or is it general?
What do you mean?
So in other words, above the stipulated amount, if the chief executive or an executive is to be delegated an amount above their level, is it something that is just done on a blanket basis, or the board says, okay, for this specific thing, we delegate you to sign, and then if you breach your level on another matter, you need to come back? How does it work?
Chair, and I stand under correction, but for example, with my delegation by the CEO, the delegation was for me to sign the service provider agreement.
No.
So,
I'm really asking in general.
Yeah.
So here's where I'm going so that it's not a trick question. I just want to understand whether powers delegated onto for instance, let's say they delegated to the chief executive, let's say by the board, because that's what I would imagine that's the next level, right? When those powers have to be delegated to someone else, is there a limit in terms of how does it work that it can get passed down? My English bundles escape me. But I'm just trying to understand whether you don't then, because your delegated power isn't yours, it belongs to the board. So if I want to delegate it further, don't I need to go back to the board to get permission to delegate it further? Because now that person is now signing a level that is even above mine, and you know what I mean? Something that should go to the board. I'm really asking in general terms because we've got the delegation of authority guidelines or policy or whatever from the RAF. I just want to understand how that's supposed to work.
So Chair, you're saying whether the delegated person can also further delegate.
Yes. What is the process? I mean, I'm assuming that maybe it can be done, but what is the process of doing so? Because what could happen is that if I'm the chief executive or an executive, I get delegated to sign or at a particular level. I'm thinking that it's possible that I can delegate that to someone else and the board has no idea that I did. You get what I mean? So that's all I'm trying to solve, and then I'll hand over to Honorable Beasley, who didn't ask his questions last time.
Apologies, Chair. Chair, yes, I don't think the board would have sight of the sub-delegations. I don't think so. But I stand under correction.
Okay, so can you just ask your colleague? I do want the real answer, right? So just ask one of your colleagues to just find it in the meantime, because it must be somewhere in there. Because I'm thinking that if only the board can sign above 40 million, I think, yeah, above 40 million, it is acceptable that they would delegate sometimes, upon careful consideration, they can delegate. And I'd imagine claims, I mean, there are so many of them that there's some level of delegation, I'm assuming. But then I am also thinking that the board would need to have sight of what has happened to that delegation that it has given, because before they know it, the guy at the gate is also signing for things and they have no idea. I mean, I'm exaggerating, but you get the point I'm making. So if you can just, maybe Ms. Manyasha, if you can just locate it, and then once you are ready later on, you can just assist us. I just want to develop a proper understanding of how it's supposed to work. Okay, Honorable Beasley. So I'm going to go back to Honorable Beasley, Honorable Atkinson, because when I go there again, I'll now have to do him twice, and I don't want to do it. Okay.
Thank you, Chair, and greetings from the people from the REF, and honourable members and staff. So I'm going to start off with you, Mr. Letsoalo, and the Chair has spoken about the financial cost of these disciplinary matters, but I want to take it a further level and talk about the human cost, because behind every single action, there's a human. Do you feel, in hindsight, that you were part of a process to bully people?
No, Honourable Member.
So you think it's fair, whilst you were there, to suspend people for longer than 180 days when the policy said 180 days, and it was fair to spend 36 million in disciplinary cases? You mentioned earlier that people don't have the funds, and you said you feel it now, don't have the funds to fight those cases. I've just gone through the spreadsheet we were given. Some individuals, that the legal costs, the disciplinary costs were 2 million against them. I mean, how's an ordinary person? So you were saying just now that you know what it's like to be on the other side. I'm just asking you, do you not think that staff were actually bullied through this process?
I agree with you, Chair. I'm an honourable member, 100%.
So then the question is, how can you wash your hands of it and say you weren't part of it when you were part of it?
I think I've explained that we were getting instructions, and there were times when you would be told that if you don't do it, then you are going. And I want to talk of an incident that happened in Ms. Manyasha's office about an employee who was appointed at the time as spokesperson. That employee was reporting to the CEO. So they had issues, and the CEO wanted him disciplined. But as I indicated, he would always say, I no longer want this employee here. So when we were together with Ms. Manyasha in her office, she called the CEO and she put the CEO on speaker. And then she said to the CEO that I was also in the office with her, and that my view is that we can look at a different way of resolving this matter. The CEO on the phone said, if that man doesn't go, I must go. I was with her in that office. So that is the type of environment that we operated in. You either do what you are told to do, if not, then your job is on the line.
Thank you. And yeah, I just want the record to note that some people did not buckle to the pressure, and as a result, they're on the list of people who had huge legal fees and suspended for 180 days. And then why were you suspended?
There was a report or a complaint by one of the ER managers against me. But it turned out that some of the contents of the report resulted in malicious reporting, to the extent that the investigating team recommended that he be charged also for malicious reporting. However, he was never charged. It's only us who were charged.
And then you received financial settlement. How many staff received financial settlements in this processes? And how was your financial settlement? And don't go into the details, but on what basis was it?
Yeah, okay. In every employee who faced such situations would negotiate his or her own terms of the settlement, because I felt that I just needed to quit, and the process was taking a toll on me.
So the question is, how many other people have got a financial settlement? Because I just see huge legal costs. And the thing also that does appear is that the RAF has disregard for processes in the labour court. So they just fight it all the way. Ultimately, they'll take a matter to the Constitutional Court. So they're bullying people into actual submission. So my question is, why were you offered a financial settlement and many others haven't?
I am not aware of others who haven't, obviously, after having consulted and wanted to have a financial settlement. I can give instances of 4 senior managers at Main Lane branch who were consulted and agreed to a financial settlement. I am not aware of any person who said he or she wanted a financial settlement and he or she did not get it. I'm not aware.
And then how were the lawyers chosen in these particular disciplinary cases? Because the one spreadsheet that we've got it looked like one lawyer firm got all the work in these disciplinary actions. So how was it actually shared amongst the lawyers, and on what basis?
The procedure for that, for the appointment of chairpersons in ER processes, was that we would write to, especially on dispute matters, CCMA matters and labour court, we would write to legal services and ask them to appoint, because all the panels, legal panels, sat in the legal office. And then they would appoint for us. And I believed it was on a rotational basis as it was supposed to be.
And thank you. Mrs. Khumalo, can you add to that, please? Because it clearly wasn't on a rotation basis. There was obviously preference to one or 2 legal firms.
Thank you, Honourable Member. Certainly that was done before my time. When I came into the RAF, what we did was we gave the list, we would do the tender for the panel, and we then give the list of ER specialists or ER lawyers to ER. Then ER will handle it from there in terms of instructions and all.
So then how is it possible that one legal firm got the majority of the work?
Is it addressed to me?
It was to one of you.
That's what I'm saying. Certainly at my time, I was not around when legal services was giving instructions to the ER specialist. For me, when I came, we gave the list of the ER specialists to ER themselves, and ER then would then nominate the appropriate panel.
So how does it work now that you were there last week when you were there, because you're no longer there now? So how was it that the lawyer firm actually appointed to represent RAF in a disciplinary matter?
We give the names to the ER, to the head of corporate support. Then from ER side, because they've got the list of successful panel members, then they will then choose from their side in terms of who do they give instructions to. So in a nutshell, I'm not involved in giving instructions or otherwise on ER related matters.
And would you find it strange or disturbing, I don't know what the right word is, that 1 or 2 legal firms got 90% of the work as head of governance?
Yes, Chair, and I get Oh, sorry. Yes, Honorable Member, and I guess...
You're allowed to say chair, it's always through the chairs.
Okay.
You can use them interchangeably.
All right, except for my lady and my lord.
Mr. Letsoalo, just the mic, the sound comes through better if only one is on. Thank you. Yeah, you know, we've had very interesting experiences here with rough people. At least your accent, no comment.
Sorry, did you answer the question? I must have missed it, sorry.
Honorable Member, I'm saying, yes, it will be strange why 90% of the work has gone to that specialist, ER specialist, but I'm guessing then ER will have a reason on that, but I would find it strange, yes.
And as head of governance, you never felt it like reason to question it at all, or?
Honorable Member, I did not have sight of it. That's why I was saying to you, we give them the list of names, and it's up to them and their executive to manage it. Because it's headed by an executive in my level as well.
Okay, then Ms. Manyasha, something that really perturbed me earlier when you said there wasn't a headhunting process, but there actually was a headhunting process. I mean, that just shows the disregard for legal things, because it clearly was a headhunting process. How does it, I mean, that's just like cheating. If you've got a policy and you're going around the policy, what are your thoughts on that? I mean, do you think that is, what I'm trying to find the word is, yeah, morally right to do that? When your policy says something, can you intentionally crook? And I'm going to use the word crook because that's what happened. You crooked, not you, but the process was actually crooked to get the headhunted person.
Thank you, Honorable Beasley. I think I did mention earlier that it was headhunting, and it was the advice from HR that this is the only way that you can headhunt. You headhunt through agencies, and they can get you 2 or 3 people that you can interview. What I can mention is that the headhunting process still required people to have the minimum requirements or the requisite skills for the position. I would like not to comment on the moral part of it.
But you to comment on the moral side. You're a senior executive. I mean, if you don't comment on the moral side, that means you don't think it's a problem, because the policy said you mustn't headhunt, and now you just said that you've headhunted. I mean, it's either right or it's wrong. I mean,
my general view is that headhunting is not a wrong thing to do if it's allowed.
What did the policy say?
The policy said you can't headhunt a person, one person, and bring them in without going through an interview. However, you can take the person through interview process and competency assessment to make sure that they do qualify.
Yeah, I mean, it's headhunting. I mean, you said it's headhunting. I mean, you're trying to, yeah, I just don't know what you're trying to do. And then whilst you were there, how many promotions did you receive?
I've never received a promotion.
And then coming back to Ms. Khumalo, as head of governance, how much input did you have into the new RAF1 form?
When I joined, the RAF1 form had already been introduced.
And at any stage, did you give any input as head of governance that potentially there was something wrong with it?
Through you, Chair, I mean, from legal services, we did see the type of pushback that we had with the fraternity, the plaintiff attorneys. We had discussions around it. What is it so different from the previous RAF1 form? And we understood why was the RAF1 form with the terms and conditions introduced, or rather amended. We understood what the challenges were, and those were around the challenges of backlogs and not being able to finalize claims because they are missing documents.
Thanks. And then coming back to Ms. Manyasha, sorry, I forgot a question. The one thing that I've seen that's really upset South Africans is that RAF can spend 4 million on an awards function. You signed that invoice off. What are your thoughts on that? When RAF, everybody mentioned earlier that they got cost restraints. It's 650 people, so the cost per head is 6,000. I mean, that is outrageous. You talk about moral, that's immoral. Spending 6,000 Rand when they're RAF, and you've signed that. So if you can just explain the background, how can one expend such an exorbitant amount of public money on a RAF function when RAF is actually in free fall?
Honourable Member, in the previous years, the RAF had employee awards, and these employee awards would be in the regions. So every region would have their own award ceremony, which they would hire a venue, catering, and other services. However, in the last year, I proposed that we combine and have one award ceremony instead of having 6 functions. Combine all the money and have one function. So for me, that was a way of curbing the expenditure in terms of the ceremony itself, the prices to staff, because otherwise, if it's regionally based, then you have prices for the regional awards, and then you go to the national awards. So last year we decided to have one and not regional awards, and that amount is the amount that was combined from all the functions that could have been had, 6 of them.
So do you think that amount is fair and reasonable, bearing in mind the constraints that you had? And now you're just saying people obviously had to fly in from the regions. So that cost would have, I don't know, unless they hitchhiked there, but I mean, they would have had to get there too. So that cost would have been far higher. And again, it comes back to, is it fair when people aren't getting claims paid that the RAF can expend such an exorbitant amount on a function?
In my opinion, Honourable Member, the amount was fair looking at the fact that we combined the functions. Instead of having 6, we had 1.
Okay. And then I noticed in the invoice there was a thing for executive drinks. Can you just define what executive drinks are? Because for the rest of the staff, there were soft drinks. So what is executive drinks?
Chair, I'm not aware of that line item.
You signed the invoice off.
Yeah, I signed the invoice, but I cannot remember that line item, so I would not be able to respond on that now. I don't know about executive drinks, but I will have to go and check with the team. We can, Chair, if you allow, respond to that in writing.
So let's do this, because you're going to come back, Honorable Beasley. It's in the documents that were sent members yesterday. Ms. Manyasha doesn't have it. Can we make sure that it is printed for Ms. Manyasha and Ms. Khumalo? That breakdown of the costs of the function. You were on injury time. I'll allow you one more. Is it fine? Okay. So I just want to just 2 things. So there were 2 law firms. There was Mashia and Moodley, etc. That law firm. Are you familiar with it, Ms. Khumalo? In the external law firms.
I know of them because they are in part of the other categories of the panel of attorneys.
Okay, so I just want to assist with specifics on that. So the one between themselves and Mboyana Lidwaba. Mboyana Lidwaba got 44 matters. I think Smith Mashia and Moodley got 22 matters. The others got like 2 here. Most of them got 0. Got no allocation at all. We were told, and I'm asking you this now, in 2 capacities, as Chief Governance Officer, firstly, and secondly, as a person who also oversees legal services. If the policy is to rotate, I cannot see how 2 law firms can get allocated so much work while the rest get allocated nothing. I can ask, please, can you print that there is also a table with all of the law firms, the external DC law firms. But I'm just asking you to comment on two things. Was it policy to rotate? And as Chief Governance Officer, if you see this information, where two law firms get over 90% of the work, what does that trigger you to do in terms of your responsibilities?
Chairperson, I guess you are referring to on the ER side of things. Okay. Firstly, I must say, as I've previously said to the honourable member, that the ER, there's a executive responsible for ER.
You are Chief Governance Officer.
Yes, I'm getting there, Chair. There's an executive responsible for ER matters. We give them the law firm that have been duly appointed. And it is incumbent on that executive to ensure that the operations of their units are well taken care of. And if for them they had said they will appoint on a rotational basis, I expect them to have systems to say, this is how we're going to rotate, or what type of system are we going to use to ensure that we are appointing on rotational basis. Because in all fairness, Chairperson, the mere fact that I'm a Chief Governance Officer, I would not be able to police all my colleagues and know their operational things. I would not be able to know what my other colleagues have signed in terms of invoices on a daily basis, for example.
No, my question is different. So I am accepting that you did not know. I am now, let us assume you are sitting at your desk at the Road Accident Fund, and a colleague of yours, Ms. Manyasha here, brings you this information. Says, Ms. Khumalo, look at this, what's going on here? I'm asking, what response is expected of you or the chief executive of anyone in such a case where it is clear that the allocation of work is directed only towards two particular firms? What is supposed to happen under ordinary circumstances when you see something like that?
Thanks, Chair. I would then talk to the executive, my counterpart, to understand what is the reason. Firstly, to understand how, if they're saying it's for rotation, for example, then what is the reason then for that high percentage of just a few of the firms being given work? To understand the reason so that then we can put measures in place to then remedy the situation.
Okay, so my expectation of the RAF is the following, and it's premised on experience that we've received from the RAF itself. So we had a witness sitting on your chair, Ms. Mteto. She was disciplined on suspicion that she was preferring Sunshine Hospital for accident victims. So my expectation sitting here is that, okay, the RAF actually really worries about this kind of thing. It's not acceptable, right? They're expecting that hospitals must be allocated according to a criteria. And sorry, I understand that she's still out on the street. I'm not fighting a case. I have a difficulty with the inconsistency, which is why I'm asking you an abstract question. You understand? That is the impression we've been given. You are saying there would be steps to rectify. I would have expected in her case that should be as well. I am not understanding why it's so difficult for you to state specifically what is supposed to happen, because I'm assuming then there should be an investigation, right? I mean, there is two Sunshine Hospital reports that we've been given. All of them are investigating this kind of thing. But in this case, and it continues today. So are you telling us that you don't actually know whether any disciplinary investigation should at least take place to see if there is any impropriety on the allocation?
Chair, I don't know.
And I'm saying this from a governance perspective. I'm going to come to
yes.
coming to Mr. Letsoalo, by the way, on the same matter. Don't worry, he will have his own turn.
Yes, Chairperson, I agree. From a governance perspective, that's what I'm saying. I would first talk to my counterpart to understand what are the reasons. Firstly, what did they say? How did they say or commit or contract to say they're going to appoint those specialists? Secondly, was the process followed? If not, why not? And then thirdly, what are we going to put in place, measures to put in place to ensure that this does not happen again from a risk mitigation side?
But you wouldn't leave it?
No. No,
thank you. I wanted to understand. Mr. Letsoalo, I just want to understand process here. How were law firms appointed for these kind of things? How was that decision made?
In respect of this particular matter, Chair, I think I left before the firm could be appointed to manage the process. But the normal process of appointing chairpersons or initiators would be that there is a database and they were supposed to be appointed on a rotational basis. That's all I know.
Okay, you are not the first person to talk about rotational. Okay, we'll deal with this later. I just felt that we really need to canvass it. Final question. Mr. Polela told us, and it's become apparent, it wasn't just him, there was another witness who told us that two things which concern me from a governance perspective as well, Ms. Khumalo, that when the external agencies send an invoice, and this is the two agencies, Media Mix 360 and Zinc, the Road Accident Fund does not scrutinize those invoices. They assigned them. That's the first thing, right? The second thing that Mr. Polela says to the committee is that they also don't check. And by the way, I read the service level agreement. The service level agreement, in as far as this next point is concerned, actually, I think it's clause 8.1 or 8. I haven't looked at it for some weeks, but you may find. And that is, if the external agency wants to procure a service, subcontract anyone else, they must get permission from the Road Accident Fund, which I thought was prudent. Nonetheless, Mr. Polela says they get an invoice, they just sign it. And so same thing is priced at wildly differing prices, and it just gets signed. So for an example, there's a podcast for 45,000 Rand and there's a podcast for 110,000 Rand per episode. Mr. Polela can't tell you exactly why the two differ and so on, right? I'm just asking in terms of the expectation there. Is it really that when an agency gets 500 million to spend, the Road Accident Fund does not check how that money is spent? Does that sound right to you? And can you give us an insight into what the rules say and what should happen?
Thank you, Chair. Chairperson, that's not the procedures within the RAF. How it happens within the RAF is that invoices are sent through to SCM by the service providers. Then SCM will then send it to the relevant business units to say, please look at the invoice and see whether the services that they say they've rendered have indeed been rendered. Secondly, whether they've rendered services in accordance with your agreement, your award letter. That's what happens. Then the business units themselves then look at the invoices against the work that has been given to those service providers to satisfy themselves that indeed we are happy to pay for these services. Then on the invoice themselves, the business units will then sign to say, SCM, we are happy, the work has been done, please continue with the payment. Then those invoices will be sent back to SCM to effect payment.
So that's one part of what ordinarily gets done. There's price as well.
Mm-hmm.
Is the Road Accident Fund supposed to check whether the pricing is fair or not to the Road Accident Fund?
Yes, Chair.
Okay, so that's my second question. My third question is, are the suppliers expected to manage conflict of interest? Because I remember asking a specific question. Is there a way in which you make sure that your supplier does not just hire their own family and cousins? And he said, no, there is no way to find out. You know why? Also because some of the work is commissioned in the business units, and therefore it just gets validated there. So by the time he gets to sign, he really has no clue what he's signing, except that there was an activation somewhere. He told us here under oath, and we can favor you with the transcript. So the question I'm asking, and I'm not asking you to account for Mr. Polela, I'm asking you to tell the committee whether that kind of environment appears to be the right kind of environment from a financial controls perspective.
Chairperson, no, it's not the correct environment. And I mean, I know that when we have suppliers, we do have training for suppliers, especially on the ethics side of it, where the ethics unit will then train suppliers in terms of conflict of interest, in terms of possible bribery maybe they might get from employees, and where and how to report it.
In terms of monitoring of those conflicts, is there supposed to be any monitoring at all of conflicts of interest by suppliers?
Yes, Chair, and I suppose it should be within the business unit. Yeah, because and I'm saying that because I'm thinking in terms of our employees, we expect them to fill in the declaration of interest for conflict, and if there's a change, they know it's upon them then upon the employees then to then substitute their forms in terms of any changes. But with suppliers, I will stand under correction in terms of how then supply chain management or contract management unit under SCM then monitors that.
Okay, we can come back to it later. It's an area, it's one of the areas we really need to canvass, because when you externalize R1 billion and then it appears that there is no checking in terms of price, no checking in terms of conflict of interest, no checking in terms of whether the work done is worth the kind of money that is being said, I think you and I can agree that it appears problematic on its face. And we were told by somebody who was sitting here that actually, as a person who signs on the signature, they don't know. And it seems odd, R1 billion. Honorable Atkinson. It is your turn. I went back to Honorable Beasley because we skipped him in the beginning. I don't want him to get 2 bites one after the next.
Thank you very much, Chair, and thank you very much to the 3 of you from Road Accident Fund. I just want to make a comment. This is the 7th week of the inquiry, okay? And we've heard a lot of evidence from people who work for the Road Accident Fund and those who've been affected by what's been going on at the Road Accident Fund. And there are 3 things that come to mind about how the Road Accident Fund has really wrecked the lives of so many people in South Africa. The first is through the claims process and the fact that people have had to wait years to get money out of the fund, poor people who can't provide for their families, people who've in hospital and can't get the money to be paid for their treatment and various other things. You just hear that on multiple levels, and a lot of that was because of this battle going on over default judgments and various other things. There was a time when the Road Accident Fund did run a lot more efficiently than it did now, and very sadly, the last 5 years in particular have been particularly bad, and particularly over this whole issue of the issuance of the RAF1 form, which people have found so difficult to fill out effectively in a legal form. So the 3 people that have been really, really badly hit have been, number 1, the people of South Africa have been involved in car accidents. People's lives have been wrecked by you and your organization. Number 2, institutions like the Sunshine Hospital, which was forced to close down because, and this goes back to your CEO, refused to pay on court orders and actually resulted in a medical institution that was doing good for the people of South Africa and was treating people. That's been forced to close as well. And then the third issue, I think, where your institution has been particularly bad with people has been with your own employees. And this is a question to you, Mr. Letsoalo. I mean, how do you feel, and I know Honourable Beasley has touched on it, but the fact that people came here and broke down in front of this committee about the bullying and the really, really bad treatment that was meted out to them. I mean, you gave a little bit of a view in it by the fact that your leader was a dictator and his word went. But how did you feel about being part of that process where people apparently have taken their lives as well because of what they went through in the process? I mean, I think those are the three appalling things. In fact, there's when I hear about what's been done to the people of South Africa, what's been done to entities like the Sunshine Hospital, and what you've done to your own employees, there seems to be a complete lack of heart anywhere of anyone in the organization having any compassion for the people of South Africa, for institutions destroyed, and for your own staff. And I'd just like to know what your feeling is about being probably the main cog in the wheel as far as your staff is concerned on that part, on that one of the three.
Thank you, Honourable Member. I think mine would be on the employees who worked for the RAF and who went through turbulent times. I can tell you that I really felt very sympathetic to them. They can come and testify. I'll give a few names of people who appeared here before you, who I tried to assist. Number one, Mr. Victor Songelwa. Number two, John Mudisi. I remember when the two had to go through Section 188, capital A of the LRA. John was on suspension already for a long time, and he couldn't afford to go to the premises of the RAF for him to sign the documents. And I volunteered to go and meet with them at a shopping center closer to the RAF. The moment was very emotional because I felt for him with Victor Songelwa. I gave them the papers because I had to. But deep down I knew that this process is tormenting. And it's not only those two. It's quite a number of them. I actually have names of people here who went through difficult times. I can speak about the general managers as they were called before the introduction of the new structure. Those managers had to go through a restructuring process. And in that process, there was also another process for the employees in the bargaining council. I had to consult with the bargaining council employees. I had to consult separately with the general managers. And they then declared a dispute. We went to the Labour Court. The Labour Court said, RAF, appoint an independent chairperson, and which was their prayer, by the way, that an independent chairperson be appointed so that they also can be clapped together with the employees in the bargaining council. And that, Honourable Member, was the simplest thing to do. But we returned from the Labour Court with counsel that I went with, and we briefed the CEO. And he said, the court can't tell me what to do. You are going to run this process as directed. And our hands were tied. I then engaged Mr. Songelwa, because I used to go to his office. He used to give me sweets. He's a very nice old man. And he said to me, Mhlekazi, he showed me the bill that he had already paid at that time. It was exorbitant. And I asked him, is this from your pocket? That's how deeply I felt about how they were treated. And how many were they? More than 5 who lost their jobs as a result of restructuring because their contracts were not renewed. And the reason for the non-renewal was that the RAF was restructuring and those positions were not going to exist any longer. But my emphasis is on the Labour Court judgment, which a reasonable man could have clearly understood and implemented. It did not require any complication to say, RAF, get a chairperson. Not parties agree, there's a difference. the parties may agree, but in this instance, the court said, RAF, appoint an independent chairperson. And we were happy when we went back that, no, this is actually victory for all of us. Because then a chairperson will be appointed and the chairperson will then run with the process. And that never happened. Because the CEO, Collins Letsoalo, said, the court can't tell me what to do. But we went and appeared before the court. So I don't know. And I can say to you, honorable members, that most of the outcomes of labor court cases, CCMA cases, those that were in favor of the employees, there was reasonable ground. But how we operated, it was like, and I'm going to say this, it was like they say to you, go into that room. It's at night, there are no lights, there are no windows, the room is dark, and there's a black cat that you must find in there. How do you find it? That's how we operated at the RAF. And okay, the second one, and it's about Mr. Songelo. Because he was charged, and we got the senior counsel, Kasim Nasi, from Mazel's chambers in Senten. And we were advised by the CEO to get that man. Instead of Victor Songelo being charged or even being dismissed, we had a meeting with Kasim, and he managed to convince the CEO that, but for this, it's practically not possible. Allow him and look at other things. But that decision, that advice from Kasim, was then left with me, because each time there was something between the CEO and Victor would tell me, yeah, it's you and Kasim who said this man mustn't go. That's the extent I can explain.
Thanks, Mr. Letsoalo. And if I can ask you one further follow-up question on that. In a number of instances, staff members received court orders from the CCMA and various other institutions which required that they actually be taken back to work, but they weren't. I mean, what was the reason for ignoring legal actions, for people to be restored?
That was not ignored. I'll give another example. We had a matter at the Labour Court. The instructing attorney was Helden Hayes. The counsel appointed was Mufike Nkolani. He also acted sometimes as a Labour Court judge. After Nkolani realized that he's not going anywhere with the attitude of the RAF, he then said, let's get senior counsel, maybe we will get an audience. And we approached the deputy commissioner in the Madlanka Commission, Khumalo SC. He wrote a beautiful opinion that was brought to me so I could take it to the CEO. He chucked me out of the office. And he told me there and there to fire Khumalo SC. And he told me he was not going to pay, I mustn't pay. So that is the kind of environment, insofar as ER matters, we had to be subjected to.
Thank you, Mr. Letsoalo. I just want to move on to Ms. Khumalo, Chief Governance Officer. Surely in that role, you would raise red flags to anything that is a legal or existential issue for the organization. And on this, I'm going back to the RAF1 form, which had been declared illegal by the courts, and in essence, by continuing in your operation of requiring people to fill out the RAF1 forms, you're effectively continuing with illegal operations. Because the result of that, as we well know, is loads and loads of default judgments of things that you haven't even registered, because people could go to court if they complied with the RAF Act, and then get the matter seen by courts, and then default judgments against the Road Accident Fund. So what was your advice to the executives about the use of RAF1, knowing it was illegal and knowing the danger that it has represented to the organization by the effects it has on the liabilities and on default judgments?
Thank you, Honourable Member. Maybe let's start, Honourable Member, on this, because I've heard since the inquiry started, the saying has been that the RAF 1 form is being used illegally. Currently, it's not, because the RAF has appealed in terms of Section 18(1) of the Superior Courts Act, which then states that an order is when an order is appealed, then the operation is suspended until the finalization of the appeal. So we've appealed, so therefore it means that the RAF 1 form is still legitimate and used. It's not used illegally. So that's the current status of the RAF 1 form in terms of the law.
Isn't it true to say legally that something is not legitimate until it's actually declared legitimate? But, I mean, what you're doing is you're kind of doing a double negative. You've put something in place. No court has actually ever agreed that it's legitimate. So actually what you should be doing is going back to your original means of operation until you actually win your appeal. I mean, that's the way the law works. You can't go and change the law and then go, oh, well, the whole thing's still on appeal, and therefore we can continue down the route of the changed law. You've got to revert back to the original thing until the law is changed by the court.
With the law, Honourable Atkinson, is not like that. As I've read for you, 18(1) of the Superior Court Act, it says that unless then somebody brings an 18(3) to say that they'll be prejudiced if this order is being implemented while there's an appeal process, and this was not done. So the RAF 1 form is still legal.
All right, we might have a dispute with you about that, but nevertheless, what the RAF 1 form has done is it's massively increased unknown liabilities, because now you're getting all these default judgments coming through because people are legally able to put in a claim according just to the 3 requirements of the RAF Act. And that's where a lot of your default judgments are coming in, things that you can't even see because you're telling the people that they don't meet the requirements of the RAF 1 form. So you are getting default judgments of people that meet the requirements of the Act but don't meet the requirements of your RAF 1 form. So is that not a risk to the organisation?
Honourable Member, the RAF 1 form is part of the requirements of the Act. So that's why I'm trying to find out when you're saying.
All right, I know exactly what you're talking about. The Act requires 3 items to actually get a claim into process. Okay, the RAF 1 requires a whole lot more stuff. Okay, so in essence, what you're doing is you're not allowing a claim to be registered, and according to the RAF Act, you only have to provide 3 things to get a claim registered. I know that on your RAF 1 form, quite a bit of that stuff ultimately has to get added in for the claim to be processed, but not ab initio, not at the beginning, okay? And the RAF 1 form requires that to be done at the beginning. And that's where your issue is the fact that you've been turning away claims of people that have met the requirements of the RAF Act, but not of your RAF 1 form, and they actually do have a legal claim. And because you're not looking at that, these things are going to court and you're getting default judgments against you. So, you know, that's, to my mind, that's a major structural problem, it's a major threat to the business, basically.
Honourable Member, from my understanding, right, in terms of the Act, Section 24, that talks to the procedures and what you need to do, but how to fill in the form. That has not changed. It has always been in the RAF Act. What the RAF 1 form wanted to do, or the amendments to the RAF 1 form wanted to do, is to ensure that when you bring in a claim as a plaintiff attorney, you bring a claim with all documents that are required for our claims people to be able to look to verify the claim, to be able to make the offer to the claimant in time within the 120 days. Remember, the issue, and why was that introduced? Maybe let's start there. It's because of the backlog that we have. Currently, there's huge amounts of monies on the RNYP, over 180 days, that should have been paid. But they are not paid, claims are not paid. And the reason was, let's look at why are they not paid. And the reason for non-payment of them is that there are documents missing on these claims. You would find that certified copies of IDs are missing. You'd find that people did not give us if they are claiming for loss of earnings, they did not give us our certified 6 months salary advice. I mean, those are easy things that you have. that you can provide to the RAF, so that the RAF then can finalize your claim. So what did we do with that? We said, since they have been over 180 days on our RNYP, what do we do? Then we said, let's do a backlog campaign. We called it, bring your claim forward. So we said to the public that, can you contact this toll-free number of the RAF, where if you know you've got a claim from RAF that has long been outstanding, so that you can have an understanding of where the process is, why aren't you getting paid? And I must tell you, Honorable Member, the response was very dismal. We even had to extend the period of the campaign itself through communications, because it was very dismal and we could not understand why. Why would a claimant not want to call RAF to say, hey, even though it was through a lawyer, to say, but RAF, please help me. Khumalo attorneys had my claim. This is my ID number. I don't know my link number, but this is my ID number. Can you check where my claim is? The response was very dismal. And part of the conclusions was that either these claims were falsified, because there's no way that you know that you're owed money and you would not come forward when they say come forward. So part of the RAF 1 form is to then say, guys, for us not to have a backlog and having an RNYP that's not moving too much because we cannot really process payment, we don't have all the required documents, can you then say what the documents that we need to have when you bring us the claim form, the RAF 1 form at RAF, so that the processing and assessing and verification of it can be done within 120 days? Because remember, if we take your claim form or your RAF 1 form with missing documents that are essential for us to verify whether the claim exists or not, for example, like your accident reports, we have 60 days to say whether the claim is valid or not. And if not, it's valid in all aspects of law. And that's the part that our plaintiff attorneys take advantage of, because usually they will just give us a claim with not all the documents, knowing that with the amount of claims that we receive, we will not be able to process all of them within 60 days. So what happens to them? They are valid in all respects of in law. Then what used to happen? Our claim officers will spend countless hours on the phones with plaintiff attorneys, on emails with plaintiff attorneys to say, can you give me these documents of this claim and these documents of these claims? And the plaintiff attorneys will say, I will give you, I'm busy, I will give you, I know, I will give you, because they know it's valid anyway. Whether they're going to take 5 or 6 or 7 years to give us those documents, they know it's valid. We cannot get rid of it. So those are the challenges that we are having. And that's why we said, for us to be able to not have people in hospital not being paid, the poorest of the poor waiting for money from RAF, and it goes with our I care principles to say empathy for the claimant. What do you want to do? Can you give us all the documents that are required for us to be able to finalize your claim quickly? So that's the main input of the RAF 1 form. And we are challenged because if plaintiff attorneys are always saying they also have the claimant at heart, why is it so difficult for them to give? Because remember, you've got 3 years. The minimum is 3 years to file. So you can't say within 3 years you don't have an accident report form or medical report or a certified ID copy.
I take what you say.
So, Honorable Atkinson, you are 5 minutes over.
Right. Can I just make one further point?
Yes. So
it's just a point.
Okay.
I take everything you're saying, but the thing that really concerns me is that in 2020 you processed 325,000 claims, and last year you only processed 78,000 claims. So you've literally processed a fifth of the claims. And don't tell me that there's been an 80% drop in accidents in South Africa.
So what I'll do, Ms. Khumalo, is I will ask the staff to print us LPWIF1 and LPWIF2 and one other judgment. You know that these pertain to the board notice and the matter pertaining to the minister's regulations, right? And later on, you and I will walk through that judgment together. We will. We'll slow walk through aspects of that judgment, because it is important. It is important to ascertain, and I'll tell you why already, so that you know. the application for leave to appeal was a full bench. You remember that Judge Unterholter was on that bench. You remember. Towards the end of the judgment, don't need to canvass the issue now. Towards the end of the judgment, the court expresses its disappointment that the Road Accident Fund has still not reversed the RAF 1 form because the matters under appeal at the Supreme Court of Appeal have no bearing on the unlawfulness of the RAF 1 form. So we are going to walk through it together because I don't want the public to be misled. We will slow walk it together so that we can get at an assertion that is correct in terms of what the judgment says. As you know, there have been further judgments, one in Bloemfontein, I think there was another one in the Eastern Cape. We will walk through those together as well. Okay, so I'm going to ask the staff here to print those judgments so that we may get there. I wanted to ask you, Ms. Manyasha, and then I'll give Honorable Blosser an opportunity. So Mr. Letsoalo there said he was in your office, and sometimes he leaves at the right time, you know. he said he was in your office when you both called the chief executive. And I don't want things to be said in your presence about what happened in your presence without giving you an opportunity to respond. Do you remember the incident he's talking about?
I do, Chair.
Would you say, did he have opportunity to refuse? So in other words, if he had simply refused to carry out the instruction, do you think the matter would have been left there?
I don't know, Chair, if it would have been left there, if he refused. I don't know.
In your own experience? Because you said he was a hard taskmaster. And I'll tell you why this is important. It's much less about the incident. It's much more about a particular attitude towards the rules and rules of governance. Because often Honorable Madlala, when he's here, he asks employees why they didn't refuse. There are simply too many people who have been asked that question. And we need to get to the bottom of it because it's got governance implications in terms of the decisions taken and their cost implication. That's why I'm asking. Had, in your experience, and if you don't know, you don't know, I'm asking you for the last time. Once that instruction came from Mr. Letsoalo, at his level, did he have the space in that organization to say, I'm sorry, it's not happening, I'm not going to do it? Do you think there would have been no consequence for him?
Chair, I don't know if there would have been no consequence for him, but let me just give my opinion. I believe as a senior manager at a management level, at an executive level, everybody has a right because you are a professional and you are an expert in your field. And I have, in some instances, and we talk about it with the executives, if I do not agree to something, there's a memo in front of me that says, recommend this. I have a right to say recommended or not recommended. If I don't recommend, I write my notes there. It's very important, Chair.
When it's verbal, what happens? Because Honorable Madlala asks all the time, you know, where was the written instruction? So somebody, the chief executive no less, and there are power dynamics at work. The chief executive gives a verbal instruction, says something must be done. Is it your evidence that your expectation, because I'm going to ask you what you did in that same situation on that same day, is it your answer to the committee that at the Road Accident Fund, staff were free to say, I'm sorry, I can't do it?
Chair, my experience is that I was free to say I can't do it, and I've done it before. In that case, that person was reporting directly to the CEO. The matter had to be done via my office because I would handle administrative matters. And Mr. Letsoalo, Mr. Letsoalo, did try to say bad person. And the CEO was adamant that this person, the offense that they've committed does not deserve a lesser sanction. So I can't say that if he did not carry that through, something would have happened to him. I've not seen it.
Okay, so but you can concede that he was under pressure from the most powerful person, by the chairperson in the company, to do that. You were in the room.
Yes, Chair. And I just want to go back to where you're saying, I said he's a hard taskmaster. By that I mean, and I think I did elaborate on it, when he wants work to be done, it doesn't matter what time it has to be done. So he was very hands-on in that way. When I say he was a hard taskmaster, it's like, if the work has to be done, the work has to be done. You don't have tomorrow to do that. A report must be written, it must be written. Something must be done, it must be done.
Okay, we will come back to this when I get my chance at the end of everybody. Via the labor relations issues with Mr. Letsoalo and the process of appealing judgments and which judgments would be obeyed and which judgments would not be obeyed. So it's another issue we are going to slow walk together until we get to the end. Honorable Bloss.
Asibonge Sihlalo. Greetings, afternoon, colleagues. It's been a long day. Well, Chair, I think I must firstly start and send my greetings. I see you've got a permanent member here in this committee, Advocate Gert Nel.
No, he's not. He's not a member of the committee. He's a member of the public who's sitting in the committee.
You must give him membership, Chair. He's always here.
Not a member of parliament.
I think he's the same one who allegedly took 2.2 billion a draft. Maybe we must find time, Chair, and put him on that seat as well himself, and find out. Maybe he can give us some light as well. But that's just a passing shot, Chair.
Recommendation noted.
Yeah, he's always here, so we'll just cross him over for during tea. I'm sure he can give us some light. But look, colleagues from RAF, I just want to make a few comments, and you can comment on my comments if you so wish. If not, we can let it pass so that I can go through the questions. There might be challenges of RAF. I don't think anyone disputes that. But I feel as if there are some external forces that are affecting the institution. I know that in this current administration, just a month in office, the Minister of Transport, because I sit in transport and this is our entity, the Minister of Transport received a letter from Discovery and they were complaining about the CEO, Collins Letsoalo, that he has closed their tap of 500 million a year that they were taking from RAF. Just a month in office, the minister received a love letter from the owners of Discovery Medical Aid complaining about this Collins. Sunshine Hospital was here. Sunshine Hospital is a private hospital. They are here and telling us that they closed because RAF closed their taps. What does RAF has to do with the hospital? They can't stay afloat because RAF stopped paying their money. We've got Advocate Gert here. He's here behind us, accused. His law firm has taken over 2 billion a draft. And he's here every day to guard his interest. So I feel as if there are big white business behind this whole thing, creating a mess that is not at the extent that we are trying to elevate. And that's why, Chair, I don't think we're going to get to the bottom of this thing, because we are not discussing what we're supposed to be discussing here. The white interest that is in this thing. And the people that now are crying because their taps have been closed by the former CEO. Do you guys want to comment on that?
No, the question, the comment has been put through to you. He's asking if you want to comment.
Ms. Khumalo,
he's not compelling you.
Yeah, I'm asking Ms. Khumalo, would you like to comment? Yeah, if not, then I will pass. It's not a problem.
Thanks, Honourable Member. I mean, what you've stated is facts around the letters and what used to happen. I mean, from my point of view, certainly when I joined the RAF, just a few months after I've joined within a month, I could see that there's a lot of stakeholders that want this bags of millies that we have at the RAF. These billions of rands that we have that are supposed to pay claimants, there are a lot of stakeholders that want it. From your medical legal, from your actuaries, from your plaintiff attorneys, there's a lot. And I guess that's it. It explains why RAF is so litigious. Because any and every direction we go, people go to court against it. Just of instance, when we did the RAF amendment bill before it was withdrawn by the minister, we had 30,000 comments against the RAF bill. 30,000 comments. And yet when the RAPS bill come, the same law firm say they don't want the RAPS bill. What do they want? They go on media to say, no, we want the RAF as it is currently, not to change. Because they know there are loopholes, they know that it's to their advantage rather than to the claimant. Thanks.
You know, Ms. Khumalo, you've assisted me. Because this is exactly what I wanted to address. Because for me, it seems as if everything that has been tried at RAF seems to be a problem. Now, let's speak about the default judgments. So, you do away with the panel of attorneys because you recognize, and you'll correct me, you recognize that there is a lot of money that you are wasting in these law firms that are defending cases of RAF, and you want to redirect that money and take it directly to the claimants. Why is this a problem now? That you've done away with the panel of attorneys, and in comparison to what the issue is now, default judgment vis-a-vis what you were paying to the panel of attorneys, give me a context on that. Why is this seems to be a problem, and why did you take that direction as an entity?
Thank you, Chair. Honourable Member, I mean, the numbers show and the annual reports show in terms of how much was spent on the previous panel of attorney. And the issue was, in this manner, RAF will not be sustainable. So what do we do to make sure that RAF gets to be sustainable? Part of the issues was, let's reduce the legal costs, the billions that were paid to the panel of attorneys. And part of the reasons was why. It was because statistics showed that over 80% of the matters were settled at the doorstep of the court. And what we know what will happen, then the panel of attorney will then, then the panel of attorneys or the law firms will then bill us because they've put the day for that matter. So then the RAF said, if things are settled at the doorstep of the courts, and the judges were also complaining around that, why can't we have internal employees or seconded employees that will pay salaries to be able to then be able to look after or defend the RAF in court? Because those state attorneys, by the way, they've got the same qualifications as what the panel has. They've all got LLBs, they've been admitted, Legal Practice Council has given them certificates of appearance, rights of appearance, etc. So for us, it was to say, can we get our own state attorneys or seconded state attorneys to deal just with RAF-related matters? And why did we want that? Because we want that because then they'll be able to know what are the RAF issues and be able to defend them. Unlike just going to the Solicitor General and on an ad hoc basis, they give matters to the state attorneys. So it was around reduction of costs because we saw that we can be able to do it internally. And it's unfortunate then that the numbers of state attorneys are not enough to handle the cases that we have. And part of the things that I was talking to when we said we had plans on how are we going to migrate from panel of attorneys to state attorneys, but the issue was there were some unforeseen circumstances. And some of those unforeseen circumstances that I'm talking about is that it was not foreseen that the previous panel would not want with their files or bring empty files. Then RAF must start investigations and ask the plaintiff attorneys for files. It was not foreseen that LPC will take long to then give our state attorneys then the right of appearance. So there are a number of issues that were not foreseen that I was talking about, to say plans were in place, but with any plan and project, there will be downfalls. But I think the issue is around how do we then make good of the current challenges that we have? How do we fix them?
Okay, I'm going to come back to you, Ms. Khumalo. The thing is time. Mr. Letsoalo, you arrived at draft in May 2019.
January, Honorable Member.
January 2019. Was the former CEO Collins Letsoalo already there?
Okay, I started work at RAF on the 1st of Jan 2019, and at the time the CEO was Mrs. Lindela Qingwani Jabavu. And then she left on the 6th.
Oh, no, it's fine, it's fine.
He came on the 9th of September.
Yeah, your mic?
He came on the 9th of September.
No, I'm saying you can switch off your mic here. So Collins Letsoalo finds you a draft?
Yes, Honorable Member.
And then what then was the process at that time in terms of dealing with internal DC matters?
I think we had room as ER to do our work, to advise management.
No. I'm asking, just your mic. Yeah. So I'm saying, you've explained to us here that to deal with internal DC matters, there is this panel of attorneys, and there's a complaint here now that even the rotation was not happening. 2 law firms are getting that back of the work. I'm saying, when you arrived at draft and Collins Letsoalo was not there, how were you dealing with internal DC matters?
Okay, we also had the panel of attorneys.
So this design of the panel of attorneys to deal with internal DC matters is not a design of the former CEO?
No, I also found it there.
So then why is the perception given as if, including by yourself, that this thing, because Honorable Madlala was even asking you that you are, part of your responsibility to capacitate internal members to deal with these issues. But the perception you are leaving us with here is that even those people you were training, they were unable to execute their job because there's this panel of attorneys that must deal with these issues, and it's all because of the CEO who was giving those instructions. When it's a design that you found there, he found you there with the same design.
That is correct, Honorable Member. Slightly different because pre his arrival, there were no cases as many as we had or we are having current or they are having currently. So there were no issues. But I want to emphasize the panel was there, and they did the disciplinary hearings, grievances sometimes were dealt by with managers and so on.
You're not answering my question, but it's fine. So when do you leave the RAF?
I said technically on the 11th of May, but officially on the 30th of September 2024.
And why did you leave?
I've indicated that we entered into a mutual separation agreement.
Why?
There were allegations of misconduct against me. I went to the first 2 or so DCs, which did not move, and I felt that it was becoming too much for me, money-wise. I opted for mutual separation, and they agreed, so we separated.
Are you able to share with us what was the misconduct?
I am not comfortable sharing the details of the misconduct because the separation agreement says it's confidential.
May I say, Mr. Letsoalo, so that unfortunately won't do here. Having asked Ms. Khumalo, do you recall that conversation? Yes, having asked Ms. Khumalo to say what is on her suspension letter and she took it out, I think it's only fair that you furnish, Honorable. Remember, you are indemnified, so if anyone from the RAF tries to go after you, write to Ms. Ibrahim, we'll deal with it. Okay.
Okay,
so
that's fine. one of the things was that I was not able to pay attorneys on time. That is one. Two, there was an allegation that I have committed an act of sexual harassment, which was not proven because I was not charged for that. And then the third one, there are about three of I can't remember, but those are the most critical ones that were put before me.
Can't remember.
Yeah, I don't have the records here, but I am saying that there was this one and the other one that I spoke about.
Okay.
Okay, let me get back to my laptop because I think I can get something.
Okay, so wait. So, do you want all of them, Honorable Blosse, or
no?
Has he said enough for you?
Yeah, I'm proceeding.
Okay, no. It's Honorable Blosse's time. I'm worried that he needs to get as many answers out of you as possible.
Yeah, no, I'm proceeding, Chair. Okay, so the two you remember is that you didn't pay supplies on time, and you also accused of sexual misconduct.
Correct.
Okay, you gave us testimony as well that there are people who have appeared before even this inquiry, which you have tried to assist and help. Is that correct?
That is correct, Honorable Member.
Okay. Do you know a person by the name of Nicholas Zwane?
Yes, I know him.
Have you ever tried to assist him in any way? What's the story there?
I don't know in what sense, Chairperson, Honorable Member, because Nicholas Zwane is actually the person who wrote the complaint about the charges that I've just spoken about. If I can be guided on the type of assistance that he sought from me.
Oh, so Nicholas was the one who wrote a complaint against you?
Yes, Honorable Member.
Oh, he was a whistleblower.
No.
Oh, okay. All right. No, that's fine. Let me move away from you, Mr. Letsoalo. Paul. Oh, Miss Manyasha. My apologies. I'm reading the Paul Manyasha. My apologies. Look, let's speak about also the perception of the direct claims or the promotion of these direct claims. The perception again that I'm seeing that I want you to assist us to either vindicate or dispel was the decision to stop the promotion of the direct claims a decision to stop RAF from accepting direct claims? Just speak into that.
Honorable Blosse, thank you for the question. No, the decision was not to stop accepting direct claims, but was to stop touting, if I can use the word touting, for direct claims.
I'm going to make a small comment as well. I want to speak on the issue of headhunting. So there was a recent interview, Chair, by the former state president, President Thabo Mbeki. So Thabo Mbeki explains the policy of cadre deployment. And he speaks to it in the sense of saying that in trying to achieve transformation in the country, there are certain sectors that needed certain skills. And to achieve a transformation agenda, they needed to get certain individuals into certain positions. But that didn't equate in getting unqualified and unworthy people to those positions. So cadre deployment would mean that we identify that to achieve a strategic objective in this particular area, we need Honorable Mazwe Blosse to play a role in this position. But now, because we can't just willy-nilly hire Mazwe Blosse, we then subject him to the process of applying, him being verified against other candidates being interviewed, so that we are able to see that he is capable and qualified enough against other candidates, so that he can come through the correct process. But he's our preferred person. And if he doesn't make it through that process, then he doesn't make it. But if he makes it to that process, then he confirms that what we are trying to achieve plays in a role. So will that be
a sense in terms of what you guys were trying to do in terms of the headcounting policy? Because I don't hear that you guys engaged in an illegal process. I hear that you all want, Collins or the former CEO would have wanted someone, subjected them to a process, and those people came through the process. So will that be correct, or is there a different understanding in terms of what I'm raising? Thanks.
Honorable Blosse, that is correct. And like I explained earlier, the positions that were created were job profiled, evaluated, and graded. And their qualifications were very specific. If you look at the job profiles, I've emailed them. The job profiles were exactly like what were required. And all those specialists that were hired were qualified. There was none of them that did not qualify, and there was none of them in my recollection that did not perform well in an interview plus a competency assessment. I'm going to quote something that Mr. Letsoalo, I think, even said to the board at the time. He would say exactly what you're saying. In the private sector, if a CEO arrives, they want a PA that they can work with. Preferably somebody they know, because a PA, like, it's a personal assistant. You would want somebody that you can work with. I remember the day he spoke to the board to say, unfortunately in government, we cannot have a succession plan because you can't train somebody or mentor somebody to go and be the next CEO of the Road Accident Fund. Because if you do that in government, you are going to be found to be wrong. Even if you mentor that person to that point, you will still have to advertise that position, knowing very well that you've mentored somebody, you have done succession planning for this somebody. But unfortunately in government, it does not work that way. And he used the word, he'll forgive me, I'm sure he's watching. He used the word, and he said it to the board. It was in a board meeting. He said that we are made to act schizophrenic. We know we want to appoint Manyasha as the head of the office of the CEO, but we must pretend as if we don't. And we must go through, we must spend money to advertise the position, spend time to shortlist, spend time to interview, spend money for competency assessments, and what he never did was to appoint people that were not qualified. And I must add, with all the specialists, I said none of them were ever appointed to a permanent position. Some of them were let go within 6 months. Some of them it was because of performance, because they did not perform. So he would not keep them by fire, by force. If you're not performing, you are out. Some of them had other things, but I think only one of them finished their term of 3 years, and only Mr. Modiba's contract was extended. But all of them, Mr. Blosse, they were qualified.
Blosse, I've given you 5 minutes, Grace. You are on 20 minutes now.
Chair, can I just finish my date? It's fine.
So,
Chair, I can finish my date.
So yeah. ask one more, and then we're done.
Let me finish my date. It's fine.
No, yeah. But we agreed. I had offered 30 you members. All right, so told me you want different.
All right, so one more, Chair. But Chair, maybe just a comment. You know, Chair, because the EFF is going to be in government, and when I become the Minister of Land Reform, I'm not going to hire a DDG who's against land expropriation. It's not going to happen. So in order to achieve certain objectives in the institution, there are certain things that are important. But what is important for us as a committee is that to find out if processes were flawed or not. And as long as those were met, then we are fine. My last question, Chair, before you cut me short. So, so what's your current status now at the entity?
I was suspended on the 7th of November.
But were you part of so your suspension forms part of the board decision to suspend executives?
Yes, the board suspended me as part with other 3 executives. I'm not an executive, so I was suspended with other 3 executives.
Honorable Blosse, you can come back. Okay, you are now on 22 minutes, so I think I've given you more than enough grace. So please, let's give Honorable Mende a chance.
Thank you, Chair, and good afternoon to everyone. Now, Chair, I'm not going to make comments now. I think I'll make my comments later. I just want to establish a few things. Firstly, to Mr. Letsoalo, and I want to start off where my colleague left in terms of the complainant, that complained about you, and that led to you being suspended. What were you, the two of you, quarreling about that led to your suspension?
I don't remember having anything against him at the time. I was at work, I think it was in May, and I saw an email popping up, which was a complaint that was sent to the CEO, other executives, and I was copied. But at that time, I can't remember of anything that was between us that was negative.
Do you know how many people were copied in that email?
I remember the Chief Governance Officer was copied, Mr. Ian Barriel was copied. I can't remember, I don't remember whether Mr. Patulukwaren was also copied, but quite a number of people were copied. I can remember the Chief Governance Officer, I remember the Mr. Ian Barriel.
So a decision for you to do the separation, mutual separation agreement was based on what, instead of fighting if you believe you didn't do anything to him?
Honorable Member, I felt that I did not have the financial muscle because I had to appoint an attorney. I have a family, I have a bond. So this is something that was not within my budget, and I realized I was not going to afford legal representation. Already before the start of the formal process, I had paid around 50,000. So it was going to take a toll on me financially.
And this is a process of anyone who's being processed in terms of discipline at RAF. You found it like that at RAF?
Please elaborate.
You found a process that makes whoever has been accused of a transgression paying in order for them to state their case. You found it like that at RAF?
Oh, yes. If you elect to appoint a legal representation, and more so that the RAF will also be represented by an attorney, or will be having legal representation.
Now, I wanted to make sure so that we dispel the myth that the CEO is the one that was taking money from people who have been taken through the disease.
I don't know about that, Honorable Member. That he was taking money from people, that I don't know.
Not necessarily literally taking money, but a process which he has designed was taking money from workers. Because that's a belief, that's a narrative, that he designed a system that makes it very much impossible for workers to defend themselves.
I could say impossible stemming from finances, but any other thing besides that, I don't know.
No, sir. What I need is a very clear answer. Here we are trying to establish facts, and we want to know, is this systematic or is it a human designed system? You found a system that enables an environment where employees cannot defend themselves because they have to pay lawyers in order to defend themselves through labor issues. Did you find that system there?
That is correct, Honorable Member.
Thank you. It was not designed by Collins Letsoalo.
And I never said it's him who designed it, Honorable
Thank you very much. Now, let's come here. Your line manager gives you an instruction that people who have
Your mic is
failed-
off, Honorable.
No. Doesn't. Can you hear me now?
Yeah, no.
Sure. No, it doesn't have a light, my man. So, your line manager gives you an instruction that the CEO says everyone who had failed to load claim payouts within 180 days must be fired. Am I correct?
Correct.
Your line manager. Thank you. So what do you do afterwards?
Okay, what you do is to advise on ER processes that you cannot just fire employees without a fair process. And the line manager tells you that this is an instruction.
You said who was your line manager again?
Mr. Ian Barriel.
Mr. Barrel. Okay. I didn't want to take my time with, but I want to paint a scenario to you. I'm a leader. And I have different roles that I play. I'll give you a role here in Parliament. If, as a whip here in Parliament, it happens that on my week that we have to be posing questions and follow-up questions to ministers. And then our admin or PA or researcher does not submit our follow-up questions within a prescribed time period in Parliament, which then ultimately leads to the entire EFF not having a question to pose to any minister on the day. You do realize that you will put the EFF in a very bad picture, ne?
Correct.
So do you think I would say to HR of the EFF, please process these people? I would say to them, fire that PA. But I'm done as a leader. Fire that PA. I don't want her or him anymore. But the HR knows what to do from there. They don't have to come back to me. Now I'm done with my objective. So why do you think that the CEO did not know what the process that should unfold afterwards?
And I'm speaking on his behalf. I don't think he did not know, Honorable Member. But all what I said, and I explained earlier, that this problem even led to the union at the time bringing in its General Secretary to try and speak to him about these matters. It's because the intention was to get rid of the employees. And the union was saying, we understand there was a commission of misconduct. However, we want to mitigate and ask for a lenient sanction, which could be any sanction short of dismissal.
Okay. The nice thing is that earlier on you did make a reference to Code of Good Practice in terms of Labor Relations Act. And you made a clear reference thereof that it does not compel the employer to follow certain steps on certain instances. Now, here again, I'm saying to you, the CEO says anyone who has failed to upload payment of claimants within 180 days must be fired. What's left for you is to undertake the process. And then in that process, you have to go and report back. Because one, he doesn't know how many employees he's talking about. One, what he knows is that in all offices, there are cases that are coming through of monies that are not loaded. That's what he knows. But he doesn't know who. Who must go and establish that?
Honorable Member, we submitted monthly reports at the time when I was there. And for this specific matter, there were reports outside of the usual monthly reports that we submitted because he had keen interest in those 180 days matters. So he knew. And I'm saying discipline is not only about punishing, it's also a corrective in nature. And when we say to him, let's correct behavior, that was not accepted. And he wanted them out. And we said, but each case, they may have been that huge number of employees failing to load the claims. However, the merits of each of those cases would be different.
So did you come with those different categories to him? No, the categories, having done the process to establish who has who's the first offender, second offender, third offender, the ones that have done the worst and the ones that have done the less. Did you categorize that and present that to him?
To my recollection, I think we did, because some were about 70 days late, some 20-something days late, some 120 days late, and we explained those scenarios to him. But the point was, those employees did not load the claims as required.
I think the last question to you was, it's clear who failed to do the work. My last question to you is that understanding the mandate of RAF, that claimants should be compensated, those that are in it. I think one of the two ladies did mention the situations or conditions of our people. And even now, we have a lot of those. Do you believe it's not a serious offense not to load a claim?
Honorable Member, I contend it is a serious offense. I do contend. But we have looked at the numbers of people who were affected by this, and you wouldn't have applied a blanket approach when the number of days for each case differed.
The last one, because I should have joined it. Do you know what happens with these cases? And there's quite a number of them that we've already received between myself and my colleague, because we have a campaign on rough matters. Do you believe that some of your people sitting in those offices do not load claim because they want to be assured that they will be paid by the lawyers if they load a claim?
Yes, there was that element. I heard that they were conniving with or colluding with lawyers for financial gains, some of them.
Did you have that category in that list of yours?
Those would have been dealt with as separate misconducts because it's collusion, it's not failure to load the claims. I want to believe that if one was involved in such activities, he would have at least two charges. One, talking to the failure to load. The second charge, collusion or fraud. Or yes, collusion would have been the most appropriate charge.
No, Chair, it would be very interesting to know, because this scenario which is painted that RAF has suspended a lot of people because for some reason the CEO hated people that he didn't meet. He doesn't even know. If we can get the categories of the people that were suspended and why. Because it is not normal for someone who arrives and starts suspending or dismissing people whom he doesn't know, but he also doesn't own the process. What I want to understand, the categories, especially of collusion, then the categories of people who failed to load the claims. If we can get that clear in that lot, because we speak like we're in the bush. We're not in the bush. Let's get out of the forest. Let's be
I hope you're not including me in that we, Honorable Member. We'll ask the team to just look. I suspect it's already in the memory stick, but I will ask the colleagues to just have a look. But the members are supposed to have it. I'll just ask them to look for it.
No, thank you very much. Ms. Khumalo, you explained for me, and thank you very much for
injury time, Honorable Member.
Yes,
I'm telling you, you're over 15 already.
Now, sir, Ms. Khumalo, thank you very much with Ms. Manyasha for explaining certain aspects of this thing, especially around a rough one form and the necessity thereof, and also the default judgments, because there's also another wrong narrative around that. But what I want to understand from you, and I think it's Ms. Manyasha before you, if I'm a master's graduate, I know nothing about security, but my degree can earn me a seat as a security specialist. Then yourself, you are a current special security, or you have run that role for more than 10 years with, let's assume, a diploma. Do you think I qualify to be a security specialist with my degree simply because I have so many years of being a member of parliament than a person who has been running that role successfully, so whether in whichever department?
My apologies, Honorable Member. Can you please repeat, I think, the last part for me? The qualifications part.
Yes. A master's graduate in management and finance and whatever qualifies to earn a seat as a specialist in a security specialist. But you have a security manager who's not a specialist, who has run a position successfully elsewhere in another department without fail and fits the criteria, or rather ticks all the boxes of the qualifications you are looking for with experience. Do you think when I apply and that person's apply, who will get the post?
Thank you, Honorable Member. I get you now. That is one of the areas that we have been debating as the executive, the area of qualifications versus experience. And I think that's what you are alluding to. There are some people that do not have qualifications, but have the experience and can actually do the work, have been doing the work and been performing adequately in the position. So if I were to interview the two, a master's person who does not have experience and a security person who has minimum experience requirements as well as maximum experience in the field, I think I would go for the person with the maximum experience.
Oh, thank you very much. I'll come back later.
Thank you very much. We're going to take a break after we just do a few questions. So I'm just going to focus myself on cost. Let's just you and I. In fact, let me start with Mr. Letsoalo, then I'll come to you, Ms. Khumalo, and then we'll take a break. So we've already established that the Road Accident Fund uses external lawyers for internal processes. The members will have to debate that, right, and decide what to make of it. But I think we've both got the documentary evidence and also testimony. I think it's common cause that this is what happens. So we'll have to opine on it, members, on the appropriateness thereof. I think we've had enough on that. What I now want to focus on is, and I will use a case study to illustrate the point. Okay, so let me are you familiar with a case of a rough employee called Mrs. Zamaswazi Hlope from Durban? Are you familiar with it? So Ms. Zamaswazi Hlope was dismissed. She went to the CCMA, she won. The Road Accident Fund appealed to the Labour Court and lost, so she won. Then she went to the Labour Appeal Court and she won. And the Road Accident Fund still refused to reinstate her. She then went and obtained an enforcement order. It was ignored. And then she went again, and the judge now wanted to call the acting chief executive, right? And then eventually she was reinstated at the last minute. Here's my difficulty with it. It is the persistence with litigation or incurring further costs. Okay? So Ms. Samaswazi-Hlophe's case has been adjudicated. I am not here to ask whether any or whatever should have happened. I now want you to assist the committee in understanding the process of deciding to appeal a matter where it appears that the Road Accident Fund does not have a leg to stand on. So when a matter has been to the CCMA and the CCMA has ruled in their favor, what sort of process takes place at the Road Accident Fund? So you all come back from the case, and then what happens? Can you enlighten us there?
Thank you, Chair. If a matter is before the Labour Court, I'm making an example.
Let's start with CCMA.
Okay.
So you've now lost as the employer.
Yes.
At the CCMA.
At the
What happens
CCMA.
next? So you go back to the office, and then what happens?
We report after receiving the award to the head of HR and the CEO, because the CEO took keen interest in CCMA and Labour Court matters. So we would also report to him. And I don't remember a single moment or time where he said, let us go with the judgment or the CCMA award.
No, we will come there. I am only interested in the process for now.
Okay, yeah.
Okay. Then the Labour Court rules in favor of the employee, and there's more than one of these cases. I'm simply using this one as a case study. So Road Accident Fund goes to the Labour Court, loses. What then happens?
After losing at the Labour Court, since I joined, I have never went beyond the Labour Court. I'm hearing for the first time about who's this Nomaswazi? Zamaswazi, that she went as far as the Labour Appeal Court. When I left, that matter was, I think, at the CCMA. So beyond that, I don't have any knowledge.
No, that's not. I said I'm using it as a case study. In your time when you were there, was there no matter that ever escalated to the Labour Court?
There are matters that escalated to the Labour Court, yes.
Who signs off on the decision to go to the Labour Court?
Is the CEO.
Okay. Would I be safe in assuming then that the CEO would also sign off on any further steps thereafter?
Yes.
Okay. When the court has now ruled as it was in this case, would I be correct in then assuming that the order would then be tabled before the chief executive for guidance on what should happen to that employee? No, the mic.
Correct, Chairperson.
Okay, can you explain to me on what basis the chief executive would make these decisions? Because he or she is far removed from the actual case. I mean, a person reporting to Honorable Beasley somewhere in the system, and there's lots of these cases. I just want to know if you do. If you don't, it's okay. What would make the CEO particularly interested at such a granular level?
Chair, what I can say is, from my experience dealing with him on Labour Court matters, CCMA matters, like I have indicated, he takes keen interest. And he's the one who once told me that I also report to him, and especially on dispute resolution. So,
okay, so he took a keen interest in those matters.
Yes.
Okay.
But what I can tell you, he told me that we defend throughout. We don't settle. Hence, earlier on, I said we received an opinion from a senior counsel about a matter that was taking place in Durban. We lost that matter. There was an interim judgment. I was with counsel, and counsel said, let's deal with this, but you can't appeal it. And I relayed that to the CEO, and he said, you are going to appeal it. We were at pains managing that process. And when I left, the matter was still at the Labour Court. I don't know where it is now. So his attitude would be that, and this he mentioned many times, we do not settle, we defend. That was his position.
All right. Okay. Thank you very much. Ms. Khumalo, I just want to ask a process question relating to the ER matters as well, right? Would this litigation pass by the legal department at all? What was the role that the legal department played in labor matters in general when it comes to taking a decision to appeal to? Do you know, just in terms, I'll come back to you, Mr. Letsoalo, in terms of as the accountable executive, what is your understanding of the process in terms of the guidance provided by the legal department, if any?
Chair, we were not involved. Certainly, from when I started, we were not involved in those processes. We left them to human capital because they are the specialists and experts on those matters, labor relations matters. They're specialists of labor relations matters that are hired. So they would know the processes, they would look at the cases and review, etc. So we were not involved.
Okay, can you please educate me? I am a little bit confused, and I must say I'm only using my own personal experience, so I am imposing it here, and you need to assist me because I've noted these anomalies in terms of my own experience. I am working under the impression that the legal department oversees, has to be cited on what matters are in court, or that briefing happens all over the place without the knowledge of the legal department. How does it work at the RAF? This is, you know, in the labor appeal court. So are you telling us that the legal department may actually not know and only see the judgment on SAFLI when it's published?
Yes, Chair.
Okay. All right. Mr. Letsoalo?
Thank you, Chair. Thank you. All right.
Okay, Honorable.
Thank you, Chair. I think maybe the Chief Governance Officer has forgotten. A number of times when we get affidavits, they would come to ER. I would read the affidavit and look at the content because I am not an attorney. I'm an ER person. After reading, then I'll take that to the legal department to check me. Then from there, we would take that document to the CEO after legal would have checked the document. There was never a time where I would read an affidavit drafted by attorneys and say it is fine. I always wanted to be checked, and it was an agreement between me and the CEO that you've got to go to legal because you are not a lawyer, and indeed I did that. So
that appears very normal, I have to say, that the legal department has to know what is being. So what would they check for? I mean, would they make any value judgments in terms of whether the litigation should proceed or not? Because in my, sorry, can you switch off the mic? So in my own experience, part of what the legal department does is it may be to obtain independent legal opinion and say, let's leave this case. Sometimes it's also because there are concurrent matters in court, and the argument being made here is contradicting another argument being made in another matter, and therefore the legal department is a custodian of this thing, so that your interpretations and affirmance in terms of what the law says are consistent as an organization, because it's the juristic person undertaking the litigation. That's my expectation. So was there an instance where the legal department said, I don't think we should proceed with this case in the case of an appeal, for instance?
That chairperson was not their lane. It wasn't. I have dealt with them. I have dealt with the CEO. What they would check is the jargon. the jargon. That's the cases that I've dealt with our legal services. But insofar as the merits are concerned, I knew the merits from when the case started till the point where it would have been at that time. And theirs is just to check whether this is properly written.
So one of the what concerns me is that you say you always went to legal. Ms. Khumalo here says never, and the two of you work together. I am deeply concerned about that.
Like I'm saying, Chair, I took.
No, I'm not doubting what you're saying. I'm just worried about the contradiction. That's all. I'm not saying you are lying. No, don't stress.
Thank you.
And I'm not saying she is lying either. I don't think she would. So, Ms. Manyasha, it looks like you want in on this conversation.
I was hoping not to get into especially conversations that are not for me. I know I've got my own. But Chair, it will be remiss of me if I don't come in onto this one, because I did act as acting Chief Corporate Support Officer for a year. And before my acting, the CEO had actually delegated the signing of affidavits relating to labor court to the Chief Corporate Support Officer, at the time, Mr. Ian Barrell. So these affidavits that Mr. Letsoalo is talking about were actually not signed by the CEO, at least at the time when I started acting. And because I'm not an expert in labor relations matters in ER, when I started acting, then this was given to me, which is a discomfort, because that's a document that goes to court. The process is that the ER senior manager and the managers, they would sit and look at a matter, let's say from the CCMA, and consult with lawyers. That's my understanding, and that's what I was briefed on. They would consult with someone and look at the merits of the case. And they would be the one that recommend that this case goes further. Then they will write to the CEO to say, we recommend that this case, we take this case further, depending on case by case. But the ones that I have received were recommendations from ER, and they would be the one writing to me and saying that we believe that the merits of this case deserves to go further to the next level, to the CCMA or to the labor court. So the recommendation would not be a recommendation by the CEO to say continue the matter, but it will come from ER practitioners themselves. The senior manager ER would also look at that. Sometimes there are times where I said, how do you determine this merits? And they would say, we have actually asked for external legal advice so that we can determine this.
Okay, I don't think we are going to resolve this matter here. What I'm really interested in is, so this is part of what fiduciary responsibility is. Employee X earns 350,000 rand per annum. The litigation is costing 700,000. You know, management makes those determinations, and they are like, leave it, right? The offense is not so serious. We're now having to hire counsel. We're gonna be spending 1 million, 2 million. So you know the cost benefit, and that's some of the discretion that management has, especially when. So my expectation of this entire conversation is that, at least at the CEO level, at an aggregate level, it's all to make some strategic guidances in terms of how much money do you spend on what, right? Because the person is suspended for a long time, they're getting paid without doing any work. Someone is getting paid an acting allowance. There is an acting allowance at the road accident fund, right? So it started off at the beginning with an external chairperson, an external prosecutor, then it goes to the CCMA, you have lawyers there, you might have counsel there, it goes to the labor court again and again. The costs pile up. We've asked for a table with costs per matter. Sometimes they run into millions, right? And that's what we're concerned with here. right? And our expectation, at least my expectation, is that some of the judgments that management makes is to say, we're spending way too much money on this case and we've lost twice. Okay, so let's leave it. And that's what I expect management who, you know what I mean? And that does not appear to have happened, because this case of Ms. Samaswazi Hlope is extremely egregious. It's triggering, in the sense that you get an impression of an organization with no regard for the rule of law whatsoever. When you simply defy a court order because you can, I don't know what to say. Half the judgments I read, I think I disagree with them, but they are such as they are. And we are supposed to comply with the law at that level, right? So that's, let's leave it here, right? We need to ask at the right level why it is that this practice persisted, because when you tally up the costs, that's what I'm interested in. And the cost is significant, given the numbers. So the 200 people that were suspended, two lawyers per case for each one of them, just for those. And the cost escalate. Hence, Mr. Letsoalo says they were shopping around for money. It's concerning, right? But I think we can move on. Ms. Khumalo, I just want to canvass the issue of the default judgments with you, because I also don't want us to operate in the realm of conspiracy theories. I now want us to walk through it. So how many lawyers, warm bodies, were there during the time that you had the panel of attorneys? I.e., what was the average caseload? I am wanting to eventually get to Mr. Phillips' 5,000, 4,000 claims per state attorney. How many lawyers? So not just the law firms, the lawyers. So it's a lawyer, then I suppose there'll be a paralegal, or you know, those lovely, clever people that make a case happen. So I'm assuming there was an infrastructure behind the law firms, right? Do you know the size of that infrastructure in terms of people?
Chairperson, unfortunately not. When I started at the RAF, the panel was not existing.
Was gone, okay. When you started at the RAF, how many state attorneys were there?
There were around 86 or 80 something. No? About 68. Around 68.
Is it just? It was just attorneys, excluding the people that assist them, like paralegals and that kind of stuff, attorneys, right? Okay.
And I would request Brett to keep me honest as well. Yeah.
No, that's fine. I mean, I'm not gonna hang you with missing, you know. Yeah.
Oh, you say I'm not right?
No. I'm easy with that. I'm trying to establish something different. So, but would you say, in your opinion, in your observation, the number of attorneys you had was sufficient, or was at least equivalent to what you had when the panel of attorneys were there, when you're looking at the caseload?
Chairperson, even regardless of the caseload, it's not enough, because we know that law firms, law firms have got paralegals, admin assistants.
Don't suppose where I'm going. So let's just walk slowly together. I'm just asking, in your observation, would you say that the caseload of the state attorneys was equal to or greater than, was equal to or less than what the panel of attorneys could handle? In other words, did you have enough lawyers? Did you have enough supporting infrastructure? So was it just a straight swap in infrastructure-wise in terms of lawyers and paralegals with the state attorneys, or you actually needed more?
Chairperson, like I said, I was not around, so I don't know the model of the panel of attorneys, what they have. But I'm saying, from what I know, how law firms, my little information about how law firms work and what we have, it's not enough, because we still have that challenge now of saying we don't have enough.
So we know they were not enough. So when we'll come to RAF 1 form just now, right? And then I'll release us to go for break, okay? So with you having said that, would I be incorrect in saying, given that there are prescriptions, for instance, that attorneys worry about, that in that instance there would be an increased number of cases which end up in court because in the road accident fund, not for unwillingness, but you simply don't have enough people to meet all the cases, would then find itself in a situation where there's a matter in court and there is nobody to defend it. Does that happen?
Chairperson, I need to understand your question because then you also included the issue around prescription. So how?
So what I'm trying to say is part of what we have been told by RAF employees, but also by the Law Society, is that sometimes, because you haven't received an answer from the Road Accident Fund, if you don't interrupt the prescription of the matter in legal terms by basically issuing a letter of demand or whatever the case might be, the matter might actually prescribe, even though it's in the hands of the Road Accident Fund, right? So it triggers the beginning of a litigation process. That's what I'm saying. Some of that also, so there is one, so the volume of cases might increase. But what I'm trying to say is, when you don't have enough lawyers, even for the matters that have not prescribed, the matter is due in court. When somebody has got a caseload of 4,000 claims, and I've seen judgments where judges complain about this, the RAF attorney is just not there. They're in the courtroom defending another matter. They just can't come to court B as well because they've got too many cases. I'm asking, does that, in your observation or in your experience, does that sort of thing okay?
Chair, maybe let me start with the one of us not being in all the courtrooms where we're supposed to. Yes, it happens because we just can't handle the volume that we have. Volume of court cases vis-a-vis our state attorneys. That we are in agreement with, it happens. On the issue of prescription, Chair, I don't know if you are talking about the prescription after 5 years if no summonses were issued. Is that the prescription that you're talking about? When a claim has been lodged? Yes. And what were you saying about it, Chair?
So I was saying that, look, actually I think substantively you've answered me, because my question is fundamentally about capacity, right? Which is, if you don't have enough people, you naturally then going to lose, in inverted commas, right? Simply because you can't be there. And then you have to apply for a rescission. So you get the order, you're like, but this is crazy. This is not, there's no way this is 3 million. This is not even 75,000, right? Now you must go back to court, right? That kind of thing happens. Okay. So when you apply for a rescission and you lose, what typically happens in terms of the cost award by the court? So there's like normal party and party costs. What I have seen is that in cases where the Road Accident Fund applies for a rescission and does not succeed, there are punitive costs attached.
Yes, if the court order says that, yes, Chair, and we have to pay it.
Okay, right. So you see how the legal costs for me start accumulating, right? Because now you don't have enough people. You get default judgments awarded against you. Then you are forced later on to go and apply for a rescission, and then you are not successful, and then you are charged costs and so on. Okay. Second last question on this matter. We were also told that since the introduction of the new RAF 1 form, what is now happening is that attorneys go to court to force you guys to accept the claim. Does that happen?
Correct, Chair.
Which means more legal costs, right? I mean, it goes without saying, especially if you defend the matter, right? So the costs escalate. Look, don't want to exceed my own time too much, okay? Because where I want us to get to, in fact, I need to ask this question as a last question. Were you involved in obtaining the legal opinion of Advocate Ishmael Semenya, SC, on the Busuku judgment? Okay, so there was an opinion that was sought after the Constitutional Court ruled in the Busuku matter. So I will ask that they provide you with a copy of that opinion. The members have it, but I do want to read it. I do want you to read it, and I'll direct you which paragraph to read, because it goes to the appropriateness of continuing to litigate an issue in principle that your own, both the Constitutional Court and your own legal senior counsel has said. So can you please give that to both Ms. Is it that one? The memorandum, is it the same one? Is it the same one that you've got? I just want to be sure. Okay, so yeah, I want the paragraphs to match, and then we will leave. We will go for break. Okay, so if you go to paragraph, let's say page 10. Page 10, para 16. Can you see that? Can you read that paragraph into the record?
The RAF1 form does not call for detailed information. It is intended of itself to enable the fund to assess the quantum.
It is not.
It is not. Sorry, Chair, it is not intended of itself to enable the fund to assess the quantum of the plaintiff's claim. It seeks to enable it to investigate the impact of the injuries sustained. In order to do so, the RAF1 form requires the disclosure of information to guide and facilitate the investigation. On the first page of the medical report section of the form, it seeks particulars of any emergency transport which had been required, whether the plaintiff had been hospitalized, and if so, whether he was in ICU. All of this was contained in the hospital records. The third page of the report requires the provision of particulars of the medical facilities where treatment was received and the identity of practitioners who treated the plaintiff. This too was recorded in the hospital records.
Okay, and I mean, we can come back to this later on, because there are other judgments. So there's LPWIF1, which is the initial application in the High Court in Gauteng. There's LPWF2, which is the application for leave to appeal. Then there's the Banyane judgment, which also speaks to the same issue. My reading of those judgments is that the matter under appeal does not actually say whether the fund should or not. And again, we can discuss the merits and demerits. Again, where I get concerned is a pattern of behavior at the Road Accident Fund, where the courts are just disregarded. And litigation carries on, and the RAF keeps losing. It just keeps losing all the way. Right? And when I was asking about the role of the legal department, I was telling the members, in my situation, I had a legal advisor who would say, I've looked at both cases. I like their case better than ours. And then I would know I need to leave it, right? Because those people are going to win. I'm not saying the RAF shouldn't litigate, right? But you really need to make as management with the advice of a legal department. And my anxiety is we have not had a competent head of legal who has the kind of scope of work in their job to even know what sort of adventures or misadventures Mr. Letsoalo and his colleagues are getting involved in, and exposing the RAF to further legal risk and financial risk and that kind of thing. Like I said, I'm really not fighting. I do need us to just work through this as professionals and just work through what the right decisions are. And the pattern of behavior concerns me, I have to say. members, can we? Yeah, sure, you can.
Yeah, thanks, Chair. I hear you. And Chair, that's why we have augmented our internal corporate legal capacity with the panel of attorneys. We get legal advice in terms of what is our strategy going forward. Is there some reasonable prospect of success for us to take matters forward?
No, we'll deal with that, Ms. Khumalo, later on. I'll come in right at the end when members have exhausted the matters. I'm just laying my cards on the table. I do have a concern because money gets spent. And sometimes we get involved in conspiracy making and it's not necessary. Let's just look at the facts and what professionally, in terms of professional judgment, decisions we should take. Where we've made a mistake, we say, you know, actually with hindsight, maybe we shouldn't have done it this way, and we move on. Thank you. Honorable members, the time is 16... What? Hey, my eyes are bad. Okay, we'll be back here at 16:40. Thank you. The witnesses are on the stand the whole time. They can't walk out.
talking about how you never want to see us again. Yeah, you tell us and say, if I see those people after 10 years, it will be too soon. But at least you will be rid of us. So I want to get everyone out of here long before 9 p.m. So. No, I don't want, to be honest. I don't want. So the only thing I can ask our witnesses, your answers are long. I'm not saying don't give the detail, but when the member says, were you there? Just say yes. Don't say, we went on a trip. Don't say that. You're also going to get yourself into trouble. Honorable Beasley, we are back with you. At least order has been restored. So we're going back to our 15 minutes. And I would like to encourage members to surrender any time that they're not going to use. Honorable Matun. On what rule are you writing? No, Chair, I was going to say rather the easier one is usually a point of order. No, thanks. No, Chair, I want to propose. I believe my lovely honorable members will agree to this proposal. That maybe we very lovely honorable members. That perhaps let us just take 10 minutes now. Thank you, Chair. So members, here's the thing. Honestly, you don't need to ask questions that you don't need. And what I'd also like to encourage members is that, some questions are very interesting, but they also fall outside our terms of reference, which means we have a really interesting conversation which we cannot put in our report. Because if anyone, later on says, yeah, but this had nothing to do with you. And so, can I just ask, that's why I keep trying to bring everything back to the money. So if we can try and do that as far as possible, that will help us to focus on what we really need to do here. So I'm encouraging members to take Honorable Maduna's advice, but I'm going to be strict on 15 minutes now. Yeah, so it's not 15 for 20 now, it's 15. Honorable Beasley.
Thank you, Chair. So just starting off with Ms. Manyasha, had you had a chance to look at that detailed breakdown of your rewards function that cost 4 million at 6,500 Rand a head?
Yes, Honorable Beasley, I did have a chance to look at it. This is a quotation that was signed by the senior manager responsible for this, and I see the amount you're talking about.
And what would be the executive drinks?
Honorable Beasley, I do not know. I would have called the person that signed for this during break. Unfortunately, I'm not allowed to speak to the employees, but I promise, Chair, that when I get to the office, I will look into this matter, because looking at this amount for executive drinks, I don't know what this would have been for.
But you signed the invoice.
Agreed, Honorable Beasley. I signed the invoice. The quotation in front of me is a detailed quotation line by line, which was signed by Mr. Majola. I agree that I signed the invoice, and I'm saying I'll go back and talk to the team and find out what exactly this was and if it was it was allowed. Thank you.
Yes, I know I'm harboring the point, but when you sign an invoice, you check it to the quote. So you check it that it's right. So did you not check that?
I usually always check the codes, and I must admit I may have missed this in this quotation. As you can see, it's quite long, and I'm not saying that I overlook certain things. Usually what I do, I check the quotation vis-a-vis the invoice to see that I'm signing for the right thing. But here, Chair and members, let me admit that I may have not seen this in the invoice, and I'll go back and check with the team.
Yeah, just when I was perusing it, it's the first thing that stepped out to me is that executives have executive drinks and staff have soft drinks. And we were told earlier that the Road Accident Fund is on a big crusade for no drinking. So, yeah, I mean, There's not much more I can say on that. Then in terms of the direct claims, there's a bit of, I don't know what the right word is. I always say English, it's not my first language, but the irony is that we're saying we don't want direct claims, but it involves lawyers, but at the same time, we want to cut down on lawyers. So there seems to be a bit of irony in that, reducing direct claims, because the minute you don't have a direct claim, it needs to be represented by a lawyer, and it's the litigation process starts. So maybe if either of the two of you could just maybe explain, one of you can explain the logic behind that.
Thanks, Honourable Bisley. The point is, we agree with you to say that we, as the RAF, it will be important that most of the money, if not all, goes to the claimants, as it's supposed to be, rather than the lawyers. As minimal as possible go to the lawyers. And that's why we had then said, let's then do RAF Amendment Act. We did the RAF Amendment Bill to allow the process to be easier and to allow it for the claimants to come directly to the RAF. Currently, the issue is around what happens to those claims if then the 120 days expires without nothing being done by the RAF. They can't issue summons. For them to issue summons, they must go to the law firms.
Thanks. And then if the plan was to cut down on legal fees, your legal costs per claim has gone from 41,000 in 2020 to 110,000 4 years later. So it appears, or it doesn't appear, it is the fact that your plan to cut down legal fees has actually not worked.
So can I get clarity, Honourable Member? You are saying that the value per claim has increased?
Yeah, the legal cost per claim. So if you take the legal fees divided by the number of claims, because the organisation has cut down legal fees in global numbers, but in terms of the actual claims processed and paid, they've reduced by, I've got the figures here, they've reduced by, claims finalised and paid has reduced by 70%. But your legal fees have only dropped by 20%. So the net result is that your legal cost per claim has gone up.
Honourable Bisley, I think I would need to look at those numbers. But what I know for sure, as audited by the AG, is that the legal cost for the RAF had, in year 4, had decreased by 75%. In terms of having listened to the discussions when other witnesses were here, I know there was an issue around the value per claim that has increased. And that our actuaries actually have really studied what could have brought the value per claim to increase.
May I interrupt, if that's okay? I will stop the clock, Honourable Beasley. I think we do need to stay on this value per claim. So what I understand Honourable Beasley to be saying is that, and I may be missing the number, but I think he used to have 10 point something odd billion per annum. I think that's dropped by some number, 3-4 billion, or whatever the case might be. The problem is the ratio of total amount of money spent divided by the number of claims, right? And that means your legal fees per claim. So you guys used to process about 253,000 claims, finalized 253,000 claims. Forget which year, let's say 4 or 5 years ago. By last year, you were doing 63,000. I think you back up to 78,000 or whatever, right? The problem is that when you take the total number and you divide it by a number of claims, which are incredibly much lower, right? You arrive at a ratio that is unhelpful, that shows you that the legal cost per claim has gone up. It's in the annual report. I think you should assist Honourable Beasley with the page if you've got the thing in front of you. That's so before we go on to the value per claim, I will canvass that with Ms. Potgieter tomorrow. So we'll leave you out of it. We're just talking about the legal fees. That's what he's asking. That have you considered that? So the absolute number is dropped, but the amount of money spent per claim has gone up?
Chairperson, I would have to look at the information to be able to apply my mind. Yeah, I can't answer it off the top of my head.
Chair, I've just got to state that I think as head of governance and head of legal, those figures should be one of the key drivers. And then I just want to go on to the Joburg thing. I don't know how much time I've got left, Chair, but I just want to note what...
About 10 minutes.
Okay, I want to note what the SRU says. It's imperative to note that the amount presented to National Treasury by the RAF is limited to rental expenses. The submission made by the RAF to National Treasury which indicated that the RAF would save costs was a misrepresentation, as the cost implication submitted to National Treasury omitted the critical components such as parking, storage, maintenance, electricity, sewage and diesel for the generator. In addition, the SRU found the size of the building differed substantially from the initial building, that the new office space procured through deviation is smaller in size. Any comments on that, please?
Sorry, can you just orientate us on what is this on?
It's a
Joburg lease.
It's a rental of the Johannesburg.
Okay.
Yeah.
Okay.
Yeah.
Through you, Chair, my understanding is that the Joburg office space is being discussed on Thursday. I'm not sure if I should answer that now because I've not done preparing for Thursday.
No, so let me ask you this question. Is it something that is within your personal knowledge, the Joburg lease issue in general?
The project management part of it, yes. The procurement part of it will fall under the CFO and the Chief Procurement Officer.
Okay. No, sure, of course, but the question is who had overall responsibility for the task? We all involve various departments, but somebody is ultimately responsible. Who was that?
Facilities management. The responsibilities, facilities management, the procurement part is procurement.
Okay, so I've stopped the clock. What was your role in the whole thing?
I was the project manager.
Okay, look, just answer questions that you can with honorable business. Got nothing to do with Thursday. So what you remember, you remember. What you don't, you'll have to refresh your memory one way or the other. So leave the Thursday issues. We're kind of going back and forth, as you heard. Some issues we'll canvass with Ms. Potgieter, but there are portions that we ask witnesses anyway. So answer what you can.
Okay. That is part of the contracting. I was not part of that.
And were you part of the submission to to the National Treasury for the deviation at all?
No, I was not part.
And then, Ms. Khumalo, we had the Law Society of South Africa here last week, and the one comment that they made that stuck out to me quite large was that the RAF's wanton disregard for court orders. So court orders are being issued against the RAF. We've also heard that the financial guys are moving bank accounts, so bank accounts can't be attached. As a head of governance and legal, what are your thoughts on that?
Thank you, Honorable Member. You know, I think the case is with this word, what I'm called Chief Governance Office, because it's as if I'm expected to know everything. It's as if I'm the COO, I'm the CEO. It's not that way. And that's why when I started, I said, I've got colleagues in my level that are responsible for their units. So some of the questions are a bit unfair to me, because I'm not involved in those. And I think when we started, the chairperson said, if you are not involved, if you don't know, say so. And sometimes when we say so, then there's comments to say, we expected you to know. It's not that way. I mean, case in point, the last time the CFO had indicated to you that she doesn't sign invoices. That's how the processes are within the RAF.
So I'm just asking you a question as who oversees legal. Are you aware of court orders being issued that the RAF is ignoring?
Honorable Member, I don't know. I'm not aware of court issues that the RAF is ignoring. There might be court orders that we are not aware of or that have not been loaded for payment of claims that will then result in writs or attachment that comes to the RAF, yes. But if those are there, then there are processes in place to say, is this matter payable or not? If not, why not? So what are the next steps? But just to have court orders and say, no, we are ignoring, no. I'm not aware.
Okay, you've answered that question. Thank you. And then you mentioned earlier that you had forensics under you. Is that correct?
Correct, Honourable Member.
And do you know why it was taken away at all? Was there explanation given at all?
There was a letter written by the chairperson of the board to say that it's going to report to the chairperson of the audit and risk so that they can do their work apparently without fear or favor.
Chair, I hand my time over. Thank you.
Thank you very much, Honourable Member. Honourable Nilmay.
Thank you, Chair, and good afternoon, everybody that is present here this afternoon. I'm also going to go back. We had the Law Society of South Africa here, and it was very interesting to have had that session with them. And this is for Ms. Khumalo. The LSSA had previously submitted that Road Accident Fund deliberate failure to make payments in contravention of valid and enforceable court judgments and settlement agreements constitute an act of contempt of court, undermining the rule of law and the integrity of the justice system. Who bears personal accountability in such circumstances? The Chief Executive Officer, the Chairperson of the board collectively, or can contempt of court be directed at the institution as a whole, or at the individuals responsible for operational and executive decisions leading to non-compliance?
Thanks, Honourable Nilmay. I'm starting with the code to say that there's deliberate failure to make payments by the Road Accident Fund. I don't think that is true. And why do I say so? That is based on the fact that I just said earlier on that we've got an RNYP that matters are over 180 days that needs to be paid. But we cannot make payments because there are certain documents that are required for us to comply with regulation and legislation. So you might find that there's a court order that is there to say make payments. And when we want to make payments, we say maybe provide us with a certified copy of the ID or tax clearance certificate, then those things are not done. And unfortunately, until we get those documents, we would only release payments after then, because legislatively we can't.
Sorry, my mic was on. We heard in detail how the legal fraternity has been put in disarray. I think it is common knowledge, because looking at the Act was compiled to take into account the role of the legal fraternity, being the attorneys, panel of attorneys. And I think we've been here long enough to hear every single aspect of the devastation. So if the system that yourselves have put into practice is working, why is there such devastation? Because there is devastation. Without, we see it, we hear it, we're all sitting here, people are suspended. There's chaos, absolute chaos. And the point that I was getting to, it seems that in your perception, and the perception of the officials that were there, is that the the organization's conduct has had on the broader legal fraternity, particularly the growing perception that the RAF shows a total disregard for honoring the legislation. We saw it from the legal side, from the accounting side, we see it from all over. Now, looking at the, in your view, and looking back, what do you think has failed dismally? Because we are sitting here, all of us, except for some of my other colleagues, and but the majority, we have had evidence, we've had witnesses, and you know, it's just unbelievable, the devastation that has happened. Attorneys can't pay their advocates. There's money outstanding. Why would one want to take a system, if there are challenges in that system, why would you not fix the challenges? If there were attorneys, companies that you needed to move, the tender that went out for corporate attorneys, what were their terms of reference? Because we've been told that there's a company, one of your firms, Madiba and Company, were only open a month or two before being part of the attorneys, corporate attorneys. So one tries to work out, what were you trying to do? Because obviously it's not working. And now one has to go back to basics and start all over again. However, it's like when you've had an accident, there is rubble and devastation. And there are a lot of people that have been injured in this fact, not only the claimants, but officials, people in the workplace, attorneys. The whole industry has been devastated, as though a bomb hit it and everything is in ruins.
Your Honorable Member, I don't know. There's been a number of issues that you are raising, so I've even lost sight of what the question is. Maybe let me start with the panel of corporate attorneys. We wanted the panel of corporate attorneys so that it can assist us in corporate matters of the RAF, because we did not see it as making sense that we would then have a large corporate legal services unit. So they help us in terms of also getting counsel for us, in terms of representing us in court for corporate legal matters. That's why we issued out the tender of the corporate panel of attorneys. In terms of the requirements of the tender, the requirements, part of the specifications was that we wanted experience of the lead team practitioner. We're looking at the experience of lead team practitioners and not necessarily of the law firm. That was part of the criteria, because the people themselves will be the ones representing us and doing the job, not when a law firm was established. Thirdly, this tender process had gone through probity by internal audit, and the AGSA as well sampled the tender, and nothing was found unwanted. So that's as it relates to the panel. That's what I'm saying, Honorable Member, I'm finding it difficult to answer your questions because I've had a lot of disregard of honoring things, and there's a deliberate failure and there's chaos at the Road Accident Fund. My opinion is I really don't think so. In terms of the AGSA report, our performance was over 85%. That was issued by the AGSA. And that's why RAF employees then got to be paid performance bonuses. Secondly, if we look at, the media statement that was issued, by the board, the interim board, on the 16th of September. No, excuse me, it's not the interim board. 16th of September 2024. on RAF financial outcomes for 2023-24. It was saying that, the conclusion was saying that there is no doubt that the RAF is not out of the woods yet. The fund still faces significant challenges. What is indisputable is that the 2020 to 2025 strategy presents the best opportunity to finally set the RAF on a sustainable financial and operational plan. The focus should therefore be on optimizing what works and managing the inherent risk that come with implementing a turnaround strategy. So, Honorable Member, in a nutshell, I don't think there's that chaos that has been purported as it has been said at the RAF. Thanks.
This is my last question, and that it is actually quite painful to hear that statement, because if you're on the ground and you hear what people say, I think it's like pulling the wool over one's eyes. It might be one or two things on paper, but in reality, and we've asked the Law Society of South Africa to do an assessment, an impact assessment of what is going on there. In fact, it's like an ostrich putting his head in the soil and thinking everything is okay, when in fact it's not okay. You have some officials running around with more than 1,000 claims trying to go through. I can just say that you have no state attorneys in Grahamstown. Lawyers are coming out with defaults. I'm just telling you little things that we are just picking up. So you haven't answered my question with regards to who is going to be, in your opinion, take responsible for this disaster. We wouldn't be sitting here in a commission of inquiry if there wasn't a challenge. It's a fact. We are sitting right here because of the challenges that have come out of the Road Accident Fund. There are at least thousands of people waiting in anticipation. I really don't understand, and I'm trying to work out what kind of, I wouldn't like to use the word brainwashing, but the point is, when you sit here and listen to officials from the Road Accident Fund, I'm talking about executives, and then you look at reality on the ground, and it will come, the proof will be in the pudding, as soon as we get to the bottom of many of their aspects, because we still have a little way to go. But if you look at the witness statements, you look at the situation, you look at your liability, you look at your accounting system, how can you say that it's not in disarray? So at the end of the day, somebody is going to take responsibility for this mess. At the end of the day, and I'd like to be optimistic, because I am an optimist. I'm trusting that at the end of the day, that we go back to square one and start again in the correct way. Thank you.
Thanks very much, Honorable Nelmay. Honorable Skosana.
No, thank you very much, Chair. And good afternoon to everyone. Yeah, Ms. Khumalo. Yeah, I saw some members. I think they were surprised that you are Khumalo, but your Khumalo doesn't have an H. And I'm also Skosana, but I don't have an H. It's Skosana without H, but it's Skosana. So I think there's nothing untoward of having a Khumalo without an H.
Same WhatsApp group.
Yes. Mrs. Khumalo, I think you indicated earlier that you were acting in the position of the head of legal services. And then I think there are senior attorneys who were reporting to you, but ordinarily if there was if the position was not vacant, it means those senior attorneys were going to report to the head of legal services. But because the position has been vacant for some time, so you had to act on that position, and those senior attorneys are therefore reporting to you. So as you were explaining it seems like that position of the head of legal services, it's below you. Is that correct?
Correct, Honorable Member.
Okay. Is it usual for a person to act in a position that is below his or her position? Because normally we're used to people acting in positions that are senior than the position that they are occupying. Is it normal maybe in the RAF that a person will act in a junior position than the position that he or she is occupying?
So, Honorable Member, as I said previously, that I am not, it's not called acting, and that's why I'm not getting an acting allowance. But because it's a position lower than my level, excuse me, it's because it's a position lower than my level, and there has to be tasks that are approved at that level by that person. I therefore approve them because I'm the boss of the head of legal services. So I don't have an acting letter, I don't have an acting allowance, but because it's vacant, therefore, naturally, then the duties will come to me of the decisions that that person would have to have taken. So that's how it is.
Okay. Don't you think one of those senior attorneys should have been appointed to act in that vacant position? Because they are the next level from that particular position.
Honorable Member, when I started, there were no senior managers under legal services. I appointed them during my tenure. And as a result, they had then requested that they need to get to know their units better. Because the positions in their units as well were quite vacant. I left them to do that, and sometime this year, I then appointed the senior manager, corporate legal, to act as the head legal services. Until then, she decided that she wants to now go back and rather concentrate on her unit than being responsible for the various senior managers.
Okay. No, thank you very much. Let's pass that one. Coming to the issue of signing the service provider agreement with regards to the issue of witnesses, I think you did indicate that you signed in relation to the two contracts of Mix 360 and Zinga. You signed and then sent the document back to the SCM, and your expectation was that then witnesses were then going to sign after you. How do you understand this thing of witnesses? Because my understanding is that if somebody is witnessing, when I sign, the person must be here. I signed, then I give to that person who's a witness to also sign. But then to say I signed, then they take the document somewhere, and then that person is going to sign, not in my presence, but then still regarded as a witness. How do you understand this issue of witnessing?
Honorable Member, my signatures are electronic signatures, as you might have seen. And for us, electronic signatures, before I sign, it means then I have to put in my credentials to log in. So therefore, it verifies that indeed Mampe Khumalo signed those documents. And after I've signed them electronically, they go back to Contracts Management Unit, which is a unit within SCM, to finalize the process.
Okay. No, thank you very much. Yeah, earlier, I think when we were talking about the issue of these two contracts, I think in your response, you seem to divorce yourself from the SCM processes because you kept on saying, no, then that belongs to the ACM. I have just to sign the service provider agreement. But my understanding is that though there's an SCM unit, which is a full-time unit with full-time employees that deals with SCM matters, but the role of signing is also part of the SCM processes. Because SCM processes start at the planning level. When you plan for a project, when you do specification through the bid specification committee, when you do adverts and call for bidders to submit bids, when you do briefings, when the people from the unit, they collate all the info from the bidders, when you do the evaluation through the bid evaluation process, when you do adjudication through the adjudication process, when then the awarding takes place, and the signing of this what you call service provider agreement. So all these processes, in my understanding, are part of the supply chain management process. But I was worried because you seem to divorce yourself from these processes. Why is that the case?
Honorable Member, I'm not divorcing myself from all these processes. What I said was that internally there are processes that are followed before an award is made or before a tender is awarded to a service provider. And those processes are in the main the responsibility of SCM with the relevant business unit. What happens, that's why then it's SCM as well that provides the supplier with an award letter to say that you can start the job while we are busy with the service provider agreement. The service provider agreement really manages the relationship between the service provider and the RAF to say what would happen in terms of a breach, what would happen in terms of that, what is your domicile, so that's what the service level agreement is all about. But in terms of management of the award itself, not. Because remember, this delegation it's basically CEO's delegation. So there's no way that then you would expect the CEO to be involved in all those processes. That's why we've got units and SCM that specializes in those.
But coming to the issue of value for money, because you said, no, those are the people that deals with the budget and stuff like that. Because my main worry is when you have budgeted 500 million for a project to run for 5 years, and you budget out of that 500 million, you say it's 100 million per year. But here comes somebody says, I can do that thing for 5 million. I mean, you should have picked it up that this is too good to be true. Because we have put aside 100 million per year for this particular project. But because before you put that 100 million per year, which is 500 million for 5 years, you would have done your research in terms of what is it at that particular time that project can cost. Hence, you put 100 million. So obviously, my assumption would be a person that would be appointed should be a person that maybe would be around, say, 90 million, 80 million, 70 million. As much as you would prefer a cheaper service provider. But if somebody says, I can do that work for 5 million, when you have budgeted 100 million, I mean, you should see that this is too good to be true. So I'm worried that as the last person to sign, I'm not only worried about you, I'm worried about all the process, especially I'm worried about the evaluation, the bid evaluation, I'm worried about the bid adjudication, but I'm also worried about you as the last person to sign. That still, even yourself, you did not pick it up, but this is too good to be true. How can a person do the work that we have budgeted 100 million, say, I can do it with only 5 million? And as we speak, in 2.5 years, that Mix 60 has been paid 400 million already. It's not even 5 years. It's not even that 5 years. In 2.5 years, he has been paid 400 million. Yet, he or she or that company said they can do that job with 5 million per year, which means in 5 years, they are going to be paid 25 million. But already we are standing at 400 million in their payment. So that's my worry to say, but as the last person to sign, even yourself, you could not pick it up that this is too good to be true. It can't be.
Honorable Member, the motivation to source, when a business unit wants to issue a tender or appoint a service provider for a service or one service or another, they fill in a form, motivation to source, that says why they want that service and how much do they have in the budget and how they envision that service to take place. That is within the business unit, and it will then go through supply chain management processes. What I'm signing, it is the management of the relationships. It has nothing to do with to say then it means if it's 500,000, then you must then it means then you must then spend 100,000 per year for the 5 years. That what I'm signing does not have those details. The award letter would then talk about those to say this is what you awarded and this is what you expect. So the management of the contract, it's not in my purview. I sign the service provider's agreement, which manages the relationship between the service provider and the RAF. So I think those questions will be relevant for the business unit itself.
No, thank you very much, Ms. Khumalo. Coming to you, Ms. Manyasha, I think you alluded to the fact that I think you were sort of, I'm not quoting you verbatim, maybe I'm paraphrasing you, that you were working under pressure, that the former CEO was a hard taskmaster, meaning somebody who wanted results, so you had to work hard in order to deliver the results as soon as possible. But you went further to say maybe you could have done some other things differently. Can you briefly maybe highlight what are those things that, with the benefit of hindsight, that you think that you could have, as an organization, done them differently?
Thank you, Honorable Skosana. I think you quoted me right in terms of working under pressure. What I mean by, in hindsight, maybe certain things we could have done better. I think we put ourselves under too much pressure to want to deliver a lot of things at the same time. And that's why I'm saying we could have maybe slowed down in certain areas and focus in a few areas at a time, finish them, and then focus in other areas and finish it after. But I think what we did, we took on a lot of work in an effort to bring efficiencies, and we ended up like with too much on our plate, which put pressure on all of us. I mean, at the Road Accident Fund, most of the time you find this time, so Chairperson, we're not surprised if you knock off here or if you leave here after 12 midnight. That is something that we are used to, working late nights, making sure that the work happens. So what I'm saying is that I think we took on a lot. Maybe we could have staggered the work.
No, thank you very much. Honorable Isaac mentioned a figure and said that is your salary, and you did not dispute it. Is that correct? And can you remind us what is that figure?
No, you have to say, because in the public service, these things are not secret, unfortunately. I'm sorry that you'll have new cousins. I'm sorry that you'll have new cousins trying to find you, but you have to say.
I live in Pretoria, Chair. And they hijack people to take their money. Yes, I think my current total cost to company is 2.1 million.
Okay. So, yeah, all right. That's interesting. So, let me check. Are other people who are at your level, but maybe working in other unit within the RAF, also getting the same salary?
There are quite a few that are earning more than I do, depending on where they are. The salary band is, I think, the minimum, but there are quite a few head of departments that are earning more than I do.
who are at your level. Okay.
Yeah.
So you okay.
Sorry, Honorable Skosan.
No, my apologies, Chair. I was just saying, for a disclaimer, we must just note that we've got DA ministers with matric who earn more than. Thank you, Chair.
Honorable Plus, please.
At least she's got qualifications.
This is on Honorable Skosana's time. Honorable Skosana, please proceed.
Yeah, no, thanks. I don't know why he's putting DA in my questions.
You are in injury time, by the way.
All right.
Skosana, your
Yeah.
last question.
So you are, I think you are at the level of deputy ministers. It means you and Honorable Hlengwa, the Deputy Minister of Transport, are earning almost the same salary. Now, it's very interesting. These public entities, they are really paying. So my last question, Chair, to Mr. Letsoalo. Mr. Letsoalo, I think you made emphasis on the issue of following processes in disciplining those employees that were affected, especially by the issue of 180 days of failing to process the claim within 180 days. But I think you indicated that the main reason was because of financial challenges, and hence you had to go to other departments and request money. Meaningly, as much as those employees might have failed on their part, but the main failure or the main cause of this was the shortage of financial resources. But then you did not come out very clear in saying that you were advocating for the fact that these employees should not be charged because it is the main fault is with RAF. You kept on emphasizing the issue of processes, that processes must be followed. And my worry is having processes where there's already a predetermined outcome. So following processes is one thing, but I'm more worried about even if the CEO agreed to say, okay, let's follow process, but already there's a predetermined outcome. So I'm worried about the predetermined outcome to say these people must go. But you seem to be more worried about processes. You did not come out very clear in terms of or in terms of the predetermined outcome, which is undesirable.
Thank you, Honorable Skosana. Yes, that was of great concern, of course, that there appeared to be a predetermined position in respect of those employees. And all what I was saying was that those employees were supposed to be subjected to a fair process. You can't apply discipline using the blanket approach, because every case, like I said, should be treated on its own merit. There are different mitigating factors for each and every employee who was affected by that. Now, if a blanket approach is applied, it means those employees are denied the opportunity to state their case in a fair and objective manner.
No, thanks, Chair.
All right, thank you very much. Just a quick question. So, doesn't marketing fall under the Chief Corporate Support Officer's area?
It does.
Okay, so the Zinge and Media Mix 360 contracts would be under your supervision from an executive level in an acting role?
Yes.
So they would have. The only thing I want to know is that it appears from what Mr. Polela said and what you shared with us as the committee, is that the Road Accident Fund has no way of working out whether it is not being ripped off, at least at your level and at Mr. Polela's level. He said so himself, one. And secondly, that its own internal rules of procurement are followed. In other words, we really don't know if these guys are not employing cousins and the like. We just don't know. At least you don't know, it appears. That's not information that comes across you, or somebody makes an assessment and does a report. To the best of your knowledge, does that kind of auditing happen to see if the service providers who have R1 billion to spend over a period don't do things they should not do?
Chair, it is my responsibility as a person that is procuring a service to look at the values and to make sure that we're not paying exorbitant prices. Also, supply chain management, when they source quotations for us, they also have to look and do a sort of a market analysis to make sure that we're not paying 60 rands for a bottle of water, for example. What I implemented when I started acting, I found that in the marketing division, they would just have quotations, sign, and invoices would come and they would sign. I must mention, Chair, that the invoice that you saw that had one quantity of bucket heads for a lot of money that doesn't make sense. It's something that I found when I started acting in the position. And the first invoice that I had to sign when I started acting, I insisted that they attach a quotation of that invoice and also attach proof of work where possible. And that is the process that I work with all the people that report to me. So that became the practice from then on, to say, I can't sign an invoice, because I think there was one point where they submitted an invoice to me that was not matching the quotation. So with the service provider, they just give you a quotation, but when they invoice, they don't match it. So their item, sometimes they just put it in bulk. But I insisted, Chair, and you can check with them. And I must mention, Chair, that there are some quotations that would come to my table, and I would refuse.
No, I accept that, Ms. Manyasha. I have a different difficulty. So that's one, and it's very important to check, but there are different levels of checking. So for example, I took a sample of invoices. There's too many, right? So I took a sample of invoices, we looked at them. You can get a quotation, but for corporate golf shares, for the kind of things that get done in companies, you get cheapskate ones, right? You go to one of these providers who are situated somewhere, and they produce this in bulk. And if you were to Google now, corporate apparel golf shirt, right? You can get one for 185 rand, 165 rand, right? T-shirts, $50, thereabouts. And when you're an institution that is cash strapped, you try and go for something that's presentable, but you're not gonna go expensive, right? We saw a quote for 409 rand, and it's signed off, right? I must tell you, that's a lot of money for a corporate golf shirt, right? Especially for a public institution that's really battling to make ends meet. So that's my difficulty. So it's not just the matching of the invoice. It's also the value for money. You do accept that.
I do, Chair, and
I'm not accusing you. I'm just hoping that you can walk me through the process. So that invoice is signed, okay? Which then says to me that either the Road Accident Fund wanted expensive golf shirts, in inverted commas, or was just happy that there were golf shirts, but didn't do the due diligence to say, but do you really have to get golf shirts for 409 rand? Why not? The limit is 250. That kind of guidance, right? I just want to understand why it is that you would sign a golf shirt at a 409 rand, and I can itemize other things. Bottle of water, 85 rand. Empty one with no water in it, right? And I'm raising this issue to say I have a concern that there is no process to make sure the Road Accident Fund does not get taken to the cleaners, because that's the other side, or unless you do it as well. Because then I would ask, how come those invoices get signed off by someone somewhere in HR or whatever, because it also became apparent that everyone signs.
Chair, it is the responsibility of every manager to make sure that they get value for money. I want to give you an example of something that landed on my desk.
No, sorry. So I just want to know: is there a guideline? Is there limits set for these kind of things? I'm just trying to understand the point at which that it's a value judgment. Do we want to be paying for 409 rand golf shirts or not? It's really a simple question, you understand? And it appears to me that that's not there. Otherwise, we wouldn't be talking about it, you and I.
Chair, you are correct. It's a value judgment. And that's why I'm saying each manager, each senior manager has the responsibility to make sure that whatever they spend, the money of the road accident fund, it's value for money. And that's why I wanted to give you an example. There would be an event that we're having, and what a ma'am gave me there is a bill of quantities. So where I'm involved, I actually go through the bill of quantities with the service provider one by one, line by line. And I can tell you, Chair, that I have scratched out a lot of things, because that's my responsibility to make sure that we don't print, who prints programs in this day and age? We can make them digital. So I've cancelled such things. Chair, I can give you an example. This year in August.
No, Ms. Manyasha, remember I said you're not on trial.
Yes.
Honestly, you don't need to defend yourself. What we concerned about here are systemic issues, right? I mean, there might be instances where an individual has done something really bad, right? It's clear to us because those invoices are signed. I mean, we don't need to belabor the point. The point I'm making is, would we be unjustified if in our recommendations we said that the board, because it is the accounting authority, management will do it, right? The board needs to scrutinize supplier invoices, those supplier invoices, and see the extent to which the road accident fund has overpaid for certain goods, services, apparel, etc., right? Because it's clear that while you may do it, as I understand, if HR want an event, then the HR people sign. You understand? So it's all over the show. There is no control. The budget might fall under marketing, but everybody is spending it, right? It's a concern for me. So all I'm asking you is, would we be unjustified? Would we be wasting time if we said to the board, can you look at all of those invoices and see whether the road accident fund did not overpay for any of these things, given that some managers do it, other managers don't?
Chair, you are justified 100%. And I would say you actually recommend not only to the board, but it must start with the executive, because there will be somebody under me that's signing, but we must start there at the executive level.
Yeah, no, we can only talk to the board, as it were, as the accounting authority, but I get you and I agree with you, right? So that's the one thing I wanted to get to. The other thing I would ask, since this, because the service level agreements, and I've looked at both of them, the Zinge and the Media Mix 360, it says if you are going to subcontract any of this work, you need to get our permission. My expectation is that the road accident fund is also going to make sure that there's no nepotism there, where that agency I buy from my cousin, Honorable Blosse here, right? And my impression is that that level of due diligence doesn't happen. And this 1 billion has been externalized, where people are potentially overpricing, and secondly, they're procuring from friends and relatives, and there are no controls in place. Because I do need us to get to the recommendations phase, right? Because what I also want to propose is that the board should, through management and whichever, also scrutinize conflicts that may have arisen between the agencies and their own suppliers, because the road accident fund is unsighted on that. Would that be fair?
100% fair, Chairperson.
Okay, all right. Unless you disagree. Okay, Honorable Madlala. So not Honorable Madlala, Honorable. You see, you two are always talking to each other and teasing. Honorable.
Honorable Matu. And I won't say who takes offense about what being likened to the other one. Okay, I get Lisa. No, ngiyabonga, Chairman. I cannot be a Madlala. At least, let's choose another name. It might be mistaken for Madlala here. And I have problems. No, thanks, Chair. One, on the, I think we spoke a lot on the awards, ne? And I wanted to establish, because Mr. Polela told us that there's someone else above him that signs. I just want to confirm, it should be yourself, right? So you sign the invoices. So I would assume that you would have received, because I do have the code, you would have received the bill of quantities that breaks down everything. So it's correct to say you paid Mikasa about around 222,000 to perform at that event?
That's correct.
I'm trying to establish who's Katleko Mabui. I see you paid the guy or the girl 65,000.
He was the MC of the event.
Oh, so is this someone popular maybe? I'm trying to establish, looking at the amount that he was paid.
Yes, he is. He is on SABC3, I think on the morning show.
You are too old, Matu. No, I am too old. I only watch news. No, and Maskande, obviously. When I'm looking at the code and I'm seeing branding, I'm not sure whether you paid twice for it or it's maybe a mistake in the code, because it's 1, 2, the third item. It's branding 30,000, and then it also has a standalone item. I'm just not sure. Yes, of branding, it should be around 150 or so. If you add all those items that are there, is it correct, or maybe it was a mistake, or it's me that does not understand?
I cannot say it's a mistake or it's correct, Honorable Maduna. It could have been separated for a reason. I'm not sure why it was separated, if it's both branding.
I think the answer, Ms. Mayaba, is giving me a problem, because I'm really trying to understand. Because really, I see that your at least the code is itemized, and it's giving a perspective in terms of how much was charged for what. But in terms of the branding work, you have its own standalone item, whereby each item that makes up the entire item or the branding of the event, if you look at it, the printout works and everything. But now it doesn't really make sense. Why do you have it above as well?
Mr. Maduna, I'm going to have to go and look at, study this and have a conversation with the people that were involved on the itemized bill. At this point, I cannot really point out what could have been the reason for putting branding on 2 line items.
I think my colleague would have spoken about drinks. It's such a huge amount if you add all of them on drinks. You know, such a huge amount. But I want to check. Do perhaps have to have insight, to happen to have insights into the chairs? I see you guys are, or were you buying the chairs?
No, we were not buying the chairs.
So you hired each chair for about 144 rand for a night?
Yes, Honorable Member.
Well, I assume you don't know if that's okay. I mean, if you compare to the market, that would be okay. That's a normal price, if you happen to know.
I don't think it could be the normal price. I've not looked at prices of hiring chairs recently, so I wouldn't know if it's a normal price or not.
I really wonder, because I think the maximum, the last time I checked, according to people who do these things of events, because I took my time, Chair, when I saw this 144 to check how much usually is a chair event. You see those expensive ones, those nice ones, they're about 65 rand at most. I really don't understand how did you arrive at, you hired chairs for 93,000 in total. It's really not making sense to me, and I don't think it's something that is acceptable. Because I believe this invoice, we are not going to get far. I think let us just leave it. But there are a number of items that I had noted in it that I thought that we must speak about. But it's fine. We can just follow up on them as a written question, questions. I wanted to thanks, Ms. Mayaba. Ms. Khumalo, I wanted to check. We spoke about the fact that can a work begin before the LSA is signed? And then you would have said to us, if the standard, if the standard, what do they call it? SPD. Standard, SBD, the standard bidding documents are there, you can. But I think, I'm not sure, my Leonard colleagues would help me. I think that would be a normal tender document. Obviously, if you look at it inside, it has number of sections, which is your pricing, terms and conditions, the MPTs that are needed, and so on. I think it's about 6 items. But generally, when you speak about the SPT, you are speaking about the standard bidding documents. Now, usually in SCM, according to my recollections, there are 2 processes whereby you bid using this standard bidding document. We award you, where we give you an award letter after you have won the tender. And then usually you would find out in organization with good control environment, you would have a separate, whether it's a unit within SCM, but usually it's under the CFO, where it's contract management. And then contract management, when you have been given the appointment letter, would take over from them, which is where they prepare the SLA, and then according to the GGC, the general conditions of contract, which clearly state that the SLA must be signed before the work resumes. Now, my question that I want to ask, if a service provider, in your case a draft, because clearly they can resume with work before they are signing the LSA, if they do something that is not in accordance to what they would have quoted in the standard bidding documents, how do you penalize them? You penalize them based on what?
Thanks, Honourable Member. Honourable Member, I must say, and I've said, I am not in supply chain management, and as a result, I'm not an expert in that. But from my layman's understanding of what is happening is that the SBD form, it allows then the RAF to receive the services from the service provider while we finalize then the service provider agreement. Maybe I must then take you through just the elements under in the service providers agreement. The service providers agreement, which is signed after, while the contractor is busy with the work. Inside of that, it has issues around payments. It has issues, and there isn't any money there, but it says how would the service provider be paid and what is expected of the service provider and how to submit invoices. It has issues around the duration and dates of the contract. It has issues around the special terms and conditions, and most of these things are coming from the tender that was issued. It has the issues around data protection. It has the issues around tax clearance certificates and issues around penalties. So what I've been informed is National Treasury allows that a contract can start after the award letter has been issued and the SBD form has been signed. I think the CFO will be here tomorrow. She'll be able to explain properly to you.
Perhaps let me make an example, Chair. Let's say you are buying a building for $1 billion. I'm making an example. Or you ask, no, let's not. Say you are buying a machine to do whatever, or a system. Now, in your buying a system, it's a once-off transaction. You buy, you award a person. Obviously, when a person bids, they sign all those the standard bidding documents. They are part of the tender document, by the way. Those are documents that I think they're your MP. There are a number of things that you need to attach and supply. It might be different with draft, but usually in many entities, those documents are part of what must be part of tender documents. A tender document that you bid with, especially if it's a tender, not a quotation. In a case of a quotation, it could be something else. Now, the person delivers the system after you have given him the appointment letter, but then the system does not work properly. How do you then penalize that person? When you have not yet entered in an agreement with him that tells him that if your system is not working according to our expectation, this is how we're going to penalize you.
Honorable Member, as I said before, remember when there's a tender document coming out, would say what you require. So in your example, it would say what we require the system to do. And obviously, if the system is not doing that, the people that are supposed to sign invoices would not then make payments because they would not have received their value for money. And you are correct, there are other documents that are provided during the bidding process. But the SBD 7.2 that I'm talking about is the one where the service provider has been appointed, and it then says to say that I hereby undertake to render the services described in the attached bidding documents in accordance with the requirements of the tender. It says what the tender is and the specifications therefore. And then it further says that I confirm that I have satisfied myself as to the correctness and validity of my bid, that the price, the rates quoted cover all the services specified in the bidding documents, that the price and the rates cover all my obligations, and accept that any mistake regarding price and rates and calculations will be at my own risk. So those are the issues that are in the SBD 7.2 that are just signed by the winning bidder.
That's why I'm saying maybe at RAF it's different, because usually, I think that MPT is usually towards the end of a tender document. In most organizations, you sign it as in when you apply for that particular tender, but it's fine. I will verify that. Oh, no, thanks. That is what I wanted to verify with you. Mr.
Injury
Letsoalo,
time. Injury
in
time.
my injury time.
Yes, 2 questions.
I wanted to check, how did you guys end up in a situation whereby you are mass firing people whereas you did not mass hire them?
I don't know what to say, but from people management's point of view, people were supposed to be fired, and I don't know at this stage whether ultimately they have been fired because I left, but the intention was to fire. Insofar as mass employment is concerned, it has never happened during my time at the RAF. People will be employed by various business units as and when there was a need from a business unit to source in a particular skill. I want to think of a situation where there was mass recruitment. I can't think of any.
So, because we don't have mass recruitment, I assume it would not be correct to mass fire people.
Certainly.
Lastly, no, thank you. Before Miss Khumalo and Miss Mayaba were Manyaba, sorry.
Manyasha.
Manyasha.
Yes, please.
Ngicela uxolo ba Manyasha. Bafike kaRaf, were you already there?
Yes, yeah, Honorable Maduna. I was already there.
So the CEO was hands-on in their recruitment.
I should think so because their positions, or the positions they hold, report to the CEO. So as a matter of principle, if you have reportees coming in, you've got to be hands-on.
Okay, no, thank you very much. As a parting short chair, as a comment, I just want to state that your salary and that of the CEO of NERSA, the difference is plus minus 100,000. Thank you.
All right, thank you very much. I just want to provide, before we go to Honorable Becker, some information. So I asked the Road Accident Fund to send us some information about how much the costs of initiating and chairing the matters. So I'll give just a few examples to illustrate the point, and I'll just ask for a comment, Mr. Letsoalo, and leave it. So on the matter of Mr. Fikile Lamula, the Road Accident Fund paid Mashiane Mudli Monama attorneys 987,543 rand and 51 cents to initiate the issue, one case, right? The chairperson from Ningiza Hona attorneys 311,898 rand 66 cents. That's one matter at nearly 1.3 million. In fact, it is about 1.3 million together. That's just one. There's another matter, Lloyd Pretoria, 787,000 for the initiate. There's the issue of Tavadas and Naidu, 1.5 million for the chairperson, same law firm, one of the law firms that appear to get all the work. On the issue of Sipoma Pumul, 2,007,806 rand. Khenga Incorporated for the chairperson, 676,275 rand, 72 cents. An employer that trains its own employees in presiding over matters doesn't pay these kind of monies. The question I have to ask you, did anyone raise the issue of these exorbitant amounts paid for internal disciplinary processes? It really feels like a money-making scheme as far as the lawyers are concerned. Did you raise it? Did anyone ever raise? This spreadsheet, by the way, has how many cases? Just a sample, 69 cases. The law firms got over 16 million just from this, just on the initiator's side, and then the chairpersons got over 20 million. Which is about 38 million. So did anyone ever raise the issue of costs of doing things this way? Now I'm asking you, Mr. Letsoalo.
Thanks, Chairperson. The matters that you have referred to happened after I had left. But I need to state that it did not start with those matters. Even previously, there were cases where the costs were huge. But all the matters that you mentioned would have been matters that came after I had left. I'm saying this because in those names that you mentioned, I know Sipuma Pumul. So it happened after I had left.
All right. No, I'm just asking. So, I was just making examples. Did anyone ever raise the issue of how much all of this is? This practice, let me put it like that. I was just using for illustration. So it appears that Ms. Manyasha wants. But answer the question, because you are in ER. You are the one who is responsible. When I say you, I mean the ER department is responsible for these processes. And these kind of monies are being spent on internal disciplinary processes. Were you involved at any time in a conversation about managing these costs and different ways of doing this?
Yes, Chairperson. That is why I said earlier that I approached my line manager and I spoke to him about the possibility of getting an MOU with sister organizations. I did too.
Oh, I see. Okay. Yes. No, I get you. All right, I remember. Ms. Manyasha, you wanted to add. I want to hand over to Honorable Kopek.
Thank you, Chair. I want to confirm that this matter was recently discussed at EXCO. And since then, before then, I had raised a concern with the senior manager ER. And then recently we submitted a recommendation via REMCO to the board to look into us reverting to having internal staff initiating, investigating, and chairing disciplinary matters. Because I know for a fact, Chair, that this is how other organizations are doing it without spending money. I believe that previously it was stated that why we started using lawyers was because there was collusion between the ER people, managers, and employees in terms of disciplinary hearings. But what we wrote to the REMCO, we've stated that the risk has been reduced significantly and that the use of lawyers should be under exceptional circumstances. We have recommended training again for managers so that this can be conducted internally without spending money.
Okay, no, thank you. You will deal with the collusion later. Okay. Because, I have difficulty with that belief, because if people are colluding, you discipline them. You understand, you don't spend so much money on, it's just a highly unusual practice. Honorable Kopek.
Thank you, Chair, and greetings once again to the House. Chair, earlier I asked a question to Ms. Manyasha about who was giving the lawyers a draft their mandate. And at some stage, she wanted to consult with Mr. Phillips. May I beg your indulgence on that one, Chair, because I'm going back to notes when Mr. Phillips was here. He also seemed to have a problem answering that question. So I just would like to know who from the Road Accident Fund is supposed to give the Road Accident Fund lawyers their briefs or their mandates? That's question one. Number two, why are RAF lawyers never given proper briefs? I think those two questions also, can we sum them up into one? Because I think between Ms. Manyasha and Mr. Phillips, we should get an answer. And I don't believe we've gotten that answer.
I think you wanted to say Ms. Khumalo.
You've been here all day, but comment will be struck off the record.
Thank you, Honourable Member. Who should give lawyers, and by lawyers, I assume you're saying state attorneys, who should give the state attorneys their briefs? State attorneys are given briefs by claim handlers from operations, and at other times from people from medical to say, we have looked at this file, we believe there's a case for us to defend, and these are the documents, or this is the thought process that we have.
Okay, so who was overseeing that process?
From operations, it should be the chief claims officer.
The chief claims officer. Okay, because I was under the impression that it's supposed to be the chief governance officer from conversations that we've had up until today. Because I think part of the reason you are here is that Mr. Phillips behind you, correct, and I think, Chair, please correct me if I'm wrong. Mr. Phillips suggested that the chief governance officer should be able to answer that question as to who is supposed to give rough lawyers their briefs or their mandates.
To be honest, I cannot recall exactly, but I remember this conversation and your line of questioning. So this issue came up, and I agree that we were not satisfied with what we can do, because Mr. Phillips is still under oath. And we said we won't pull him in unnecessarily. We can just ask him to refresh our memory, if that's okay with you. Because you remember when we, so let me just pause the clock. So you remember when we were having the conversation about, so the background to it was that sometimes the lawyer is in court, but does not have instructions on what to do about the matter. That was one part of the conversation. The second part of the conversation related to instances where lawyers have to pursue a matter, and it may have arisen out of this rough one thing or similar issues where the courts have ruled in a particular way. The people are getting instructions from the claims department, and the RAF isn't a chief claims officer anyway for a long time. So I'd be interested to hear who actually does it. But that was the conversation. And you were saying you're not the one who gives those instructions. The instructions, someone else should know about them. I don't think you said chief governance officer. You might have said legal, but can you just refresh us what your answer was so that we can then assist Ms. Khumalo in answering Honorable Kubek, because she wasn't here.
Thanks, Chair, and good evening, House. Yes, certainly, Chair. The conversation that we had initially was around the inflow of instructions, and I indicated that it can come from many sources at the RAF. It can come from the claims department, it can come from medical, because there could be certain actions linked to the instruction that is given to the state attorneys. The conversation around the CGO was the reporting lines in terms of the overall litigation management system. Chair, you'll recall that I think I would reference the LMS in my presentation, and I indicated that the claims, the state attorneys are briefed by various sources at the RAF, primarily the claims department. And the LMS, the litigation management system, is the system that is currently in play for the basis of these instructions coming in to the state attorney model.
Okay, so you said the CGO, Chief Governance Officer, you mentioned the CGO in that context.
In terms of my reporting lines, I was asked who I report to.
Okay, all right. Okay, I think we asked him who does he report to, and he said he reports to the Chief Governance Officer who's here. So I think we've closed the loop now.
Very good, Chair. Now, Mr. Phillips has just said the lawyers are briefed by various sources. Now, I want to know, Ms. Khumalo, who does oversight on those instructions? You've got your instructions from the various people who are whoever at the Road Accident Fund. Now, who makes sure that those instructions are correct and they are to the benefit of the Road Accident Fund?
Honourable Member, I don't understand you saying who makes sure that the instructions are correct. We would assume that claims handlers would provide correct instructions because they've looked at the file. They've looked at the merits, they've looked at the quantum, they've also then sent to the state attorney.
Okay, so basically, once the claims haven't, once those people have issued the instructions, there's no oversight. No one does oversight on them.
The state attorneys do have a chance to look at the file and to then say to them, you know what, I think let's settle, because we had made if you had made, for example, if a file, we had made an offer and the plaintiff attorney said no, declined the offer and said no, I want 1.5, while we said no, we'll give you a 1.2. State attorneys have chances to say, claims officer, can you relook at this matter, because
So
we don't
basically
think
there's no one at RAF who does that.
we're saying we do that. State attorneys that are briefed, that are given the file, the individual state attorney, when they look at the file, they still have that chance to advise the claims officer to say, from a legal point of view,
Yes.
my
I get it.
suggestion, yes.
The state attorneys are here and they get briefed by the people who are handling the files. My question is, who does oversight on that whole process between the state attorneys and the people who are issuing the instructions on behalf of the Road Accident Fund? That's the question. And I don't think I'm getting joy, Ms. Khumalo. Is there anyone who does the oversight on those people? Or are they just doing things themselves there in the corner?
No, that's why we've got Brett here as the senior manager responsible for the state attorneys.
But he's saying that he reports to you.
Yes, I don't do operational work. He reports to me,
So that-
but I don't look at the LMS and say,
Okay.
I don't look at the LMS and say how many matters have been given to a state attorney on a day.
I think now we're winning. So basically, there's no one who does oversight there.
Mr. Brad Phillips, as a senior manager, then has office managers, for example, in Pretoria and Joburg. He's got office managers that then are sort of...
Okay, Mr. Brad
Yes.
Phillips is not an ancestor. He's right behind you. You
Yes,
can talk
yes.
to- Yeah.
Yes. But I'm answering you, honorable member, because you're saying who does, and I'm saying to you, Brad Phillips does that.
Mr. Brad Phillips, please come in. So do you, because you came here and you said you are not the one who gives these, who does oversight on the instructions.
Thank you, Honourable Member, for the question. The instructions don't originate from my department.
Yes.
The instructions originate from the operations environment.
Yes.
There's obviously oversight from the operations teams.
That's who I'm looking for.
Yeah.
Who does
So-
oversight on the operations teams?
It will depend, and perhaps I think I also indicated, Chair, during my evidence in chief, operations would need to explain this, because primarily the instructions come in from the claims department. Each claims department has managers, senior managers, etc. The medical department, the same structure applies there. So if an instruction is given by the medical department to a state attorney to attend to an undertaking issue, there's oversight from the medical team when the instruction is given to the state attorney. I don't give the instructions. The state attorneys receive the instructions from the various departments.
So, Ms. Khumalo, did you not just say that Mr. Phillips gives instructions? Or maybe I misheard. Okay. Now, I think it's fine. I think I'll pass this one, Chair. I think we're not getting, I'm not getting.
No, I do want to do a bit of refreshment of where this came from.
Please, Chair.
So we had, I asked Mr. Phillips to read Judge Sutherland's note. And one of the things that he said, he spoke about a ruse. I've just asked Lwazgazi to find it for me. He spoke about a ruse where, you remember that, that portion where the attorneys just play smarty pants with the court, basically. They will rock up there, and I just want to get it correctly, but it appears that, so they were just playing around, playing the system, basically. Sometimes they would say, you know what, I don't want I'll just wait until it's here. But the long and the short of it is the following, that it appeared that the people did not get proper instructions. And I made a few examples, actually, where the attorney will apply for a rescission. And in fact, there will be a default. And the attorney applies for a rescission. When the rescission has to be argued, the person gets there and they say, I don't have instructions. And the court gets upset. I actually have one of those judgments. The court gets upset, says, but what do you mean you don't have instructions? You brought us here. So that was one example. There was the practice that Judge Sutherland referred to in his note to the legal fraternity and so on. That gave rise to the conversation of, but who oversees this mess here, because sometimes people don't have instructions at all. Sometimes they get there and they ask for a postponement, file a notice to oppose at the last minute, and then when they come back again, they're not ready to oppose. Like, okay, it appeared that there was a problem of process management. The reason that was important is because punitive costs arise out of that. That's why Honorable Kupega is asking this question. We then became unhappy because Mr. Phillips said, no, they don't take instructions from me. The claims administrators and all of these people tell them what's in the file and what needs to be done, and then they go. They don't come back to me as Brett Phillips. So please see this question as a question about process and oversight mechanisms. Because the question that we asked is, isn't there someone who plays a quality control role to say, hang on, there are too many of these decisions that get nowhere. We are dying of punitive costs here. Can somebody do something about it? Mr. Phillips said that's not his job, which is why we're canvassing it with you. So let me repeat then, having given you that context, is there someone within your structure whose job it is to make these assessments and say too many default judgments, too many rescissions that don't pass muster, too many instances of punitive costs, not just party and party costs, etc., appeals that we lose, etc. Does somebody make those assessments? I think you even mentioned a dashboard. If I remember, there was even mentioning of a dashboard. Is there a person who does that? It doesn't have to be you.
Chairperson, we have, with the new structure, we've got a unit called legal administration. That falls within my purview, and part of the role of this, of getting this legal administration, is to ensure that there is a link between operations and state attorneys, to ensure that there's a system that's efficient and effective in terms of providing of instructions to the state attorneys, and that they've got the files and the correct mandates before they appear. So this unit has just started. It's got 5% of the people, because there's still a process of taking people from operations and bringing them into this unit, because currently those things are done at operations.
Okay, I think we finally have an answer, which is until recently there wasn't. Okay, I think we're there. I'll resume the clock.
No, I think we are there now. We've got a chair. So now it makes sense now why there was this whole mismatch that was happening there at the Road Accident Fund. And then now it begs the question that since Ms. Khumalo was there and supposedly doing oversight on the issue, you dropped the ball on that one, Ms. Khumalo. I'll move on, Chair. Chair, I'll go back, way back, again to the day Mr. Phillips was here. Our notes were saying, or part of our notes were saying, in 2013-2014, annual reports noted that 4.62 billion rand went to legal fees, of which 1.7 billion was spent on RAF's own legal costs and 2.9 billion on claimants' legal costs. The purpose of the direct claims process strategy was to shift the RAF's focus from lawyers in litigation back to the intended beneficiaries, and those are the road accident victims. In 2017, the Road Accident Fund executives set goals to substantially increase the portion of claimants dealing directly with the fund. The long-term vision was to achieve an increased growth in the ratio of direct claims versus represented claims. In the year following the implementation of the strategy, direct claims originations increased from 22,524 in 2015-2016 to 40,986 in 2018-2019, as reported by the respective RAF annual reports. Now, I go back to our earlier conversation today now, where we were speaking about the cessation of the direct claims. Because we get that back in the day, 2015-2016, there was a strategy up until around 2020. I think this one is for Ms. Manyasha now, if I'm correct. Was there a new strategy to shift from the direct claims process to going back to lawyers? And this is now, I'm saying this on purpose because the idea behind the previous strategy, 2015-2016, was to reduce the reliance on lawyers because there was too much money being spent on lawyers. So I want to understand the logic and the rationale behind saying, no, we are going back to lawyers. When we know that during that time, the lawyers were draining RAF's funds badly. Please, could you take us through and make us understand what was going on there?
Honorable Member, I'm not aware of that strategic decision.
The strategic decision from around 2014-2015? Okay, when you arrived, there must have been a strategy that you guys were following. Do you know about that one?
The strategy before I arrived was the strategy to use lawyers. And the strategy 2020 to 2025 was not to use lawyers.
Please say that again.
You say, unless I didn't get, you're saying the strategy before 2019, yes. 2014-15
yes.
was to use lawyers?
No.
Okay, maybe let me get the question correctly.
Okay, I'm saying the strategy around 2015-2016 was to reduce the reliance on lawyers and to promote direct claims. That's why I was even reading that passage where I was saying the claims increased from 22,000, direct claims increased from 22,524 to 40,986. That was the strategy to reduce the reliance on lawyers because the lawyers were draining RAF significantly. So now I'm trying to understand the new strategy that was basically saying reduce the number of direct claims, go back to lawyers. So I'm trying to understand the rationale behind it.
Honorable Member, that's why I'm saying I'm not aware of the strategy to reduce direct claims. What I'm aware of is that we stop promoting direct claims and actively going into communities, and that's why I'm using the word touting for people to come and claim directly. And that was something that was discussed by the executive and the board. But it was not a strategy to reduce direct claims.
It was a strategy to reduce touting, but it wasn't a strategy to reduce direct claims.
It was a strategy to stop promoting, like marketing and touting for direct claims.
But
when people
did it
come,
not directly reduce direct claims, though?
No. No. If you look at the campaigns that we've had recently, we are encouraging people to come to the Road Accident Fund, to come and check, or they can bring a claim to the Road Accident Fund. So we are not stopping the receiving of direct claims, but we are not going out there and promoting it and touting for it.
Okay. In January 2020, during a Teams meeting at regional management, the regional management gave an instruction to cease all direct claim services and remove branding. No formal written directive or circular was given or issued in this regard. All existing direct claims files were transferred to Project Shanyela to wind down direct claims. The COO sent an internal email to this effect. And all systems and databases used to manage direct claims, including the SharePoint system, were deleted or dismantled. All direct claims policies, standard operating procedures, and guidelines were removed from the internal system. Do you know anything about that? And what would your comment be around that whole dismantling system? Because the system was clearly dismantled.
I'm not aware of that meeting. I'm not sure where that meeting took place. But if you look at it, it falls under claims management. So that's why you're mentioning that the COO. I would not have been involved in that process. I was not involved in that process.
So basically, you don't know anything about the shutting down of that whole system for direct claims?
I know that there was Project Shanyela, but in terms of the details of it, I don't know how it came about.
Okay, because Ms. Mtetwa, part of the notes that you gave us said the Road Accident Fund reverted to a wholly attorney-driven claim system with no viable alternative path for ordinary claimants.
I was not part of that process.
So you would not be able to comment on it either?
No.
Okay. Chair, I don't know if Ms. Khumalo wants to comment?
Yeah, she does. On your injury time.
Chair.
Thanks, Honourable Member. I was not around at that time, but my understanding is that the RAF did not change direction. In terms of the RAF Act, Section 19 talks to liability excluded in certain cases. And it says it excludes if a claim consent has not been instituted and prosecuted by a third party or on behalf of the third party by 1, any person entitled to practice as an attorney within the Republic, or this person, we never know who it is, any person who is in the service or is a representative of the state or government or provincial, territorial or local authority. So what this means is that the RAF Act has always said people must then bring their claims through their lawyers. And that's why then it says, should we not look at your claim within 120 days, then issue summons. The only people who will be able to issue summons are lawyers. What the RAF wanted to do there with the direct claims was a process of Ubuntu. But it unfortunately backfired because there are still direct claims as we speak now that are not finalized, that have prescribed under RAF. And the issues around then, how do we deal with those? When we did the claim bring your claim forward campaign, we had also thought that people from direct claims would come back to us to say, but you helped me and you didn't come back. They didn't. So there are still unpaid direct claims that are years and years old. There are direct claims whereby we cannot get the people because either their cell phone numbers have changed or their email address have changed, etc. That we cannot find, so that then the claims can be finalized. So those were the challenges that were seen with the direct claims, to say, you know what, as RAF, we wanted to do it for Ubuntu, but it's not working because we end up being in more trouble than helping out the nation. So that's my understanding of it. So RAF did not change. The Act has always said the claim must be submitted by an attorney.
RAF is something else, eh? Just lastly, Chair.
Say lastly.
Yes. On the role of the CIO, CIO role and responsibilities, Mr. Songelo's affidavit said the actuarial department was moved to the investment division without any formal HR facilitated transfer of portfolio and scope from the finance management to the acting CIO. Mr. Letsoalo, could you help us on that one?
What is the question, sir? Honorable Member.
How was the actuarial department moved to the investment division without any HR facilitated transfer of portfolio?
Oh, okay.
Or what was happening there for that to happen? Thank you.
I'm not able to respond to that because it's an office within the RAF that is responsible for movement of staff, which would be the HR department. I was in the employee relations, so I never played any role at all in that process.
Thank you, Chair.
All right, thank you very much. I do want us to really just, because I think there is a story we're not being told. It's not necessarily unlawful, but we need to reconcile public statements with the real situation, okay? So I will just give some numbers because the Road Accident Fund was kind enough to furnish us with the numbers. 2018-19, there were 36,000 direct claims. I think they amounted to about 35% of all claims. That is subsequently dropped over time to the extent that in 2024-2025, only 2,819 were registered, while 17,972 were represented, which means, for whatever reason, and we can canvass those, the number of people who are able to submit a direct claim has reduced significantly. The represented claims have as well, but as a proportion of all the claims registered, direct claims are really tiny, right? And we've always understood that the Road Accident Fund says lawyers get paid for pushing paper, people must come to us directly. What we subsequently heard is the following. The claims originations people were pulled out of rural and outlying areas and moved to customer service centers. Ms. Mtetwa used to manage those people. That's one example. The second thing that happened, which was unrelated but had an effect in any event, is that those 200 people that we're talking about, those managers were complaining, that had an impact on people. And we see in the annual report, the number of unfinalized claims is now not north of 420,000, including those that you were talking about, who I know send honorable man WhatsApps to say it's been 10 years and me and so on, right? We've also seen board minutes, board submissions and so on that clearly state that there was a decision to move away from direct claims, okay, onto represented claims. It's clear, and I can pull out the document, so it's clear that there was a decision. Mr. Barrell speculated in terms of what the issues are, and I do want us to just clear this now, because I'm then going to get onto the rough one forms requirements vis-a-vis a person in Ngutu or in Port Shepstone who has to do this themselves and the costs involved, right? Because we talk about the poorest of the poor here, so let's lay it out on the table. So in outlying areas, people are pulled back. So that means if you want to, you really have no choice but to go to a lawyer if you can find one. That would be the impact, wouldn't it? I'm asking Ms. Khumalo, if there were claims originators nearer to someone in an outlying area, Honorable Pila, who's not here, even made an example about Malamulele Hospital. And Ms. Christina Mtetwa said, no, but there was a person there, but that person was pulled out, right? So it's not touting per se, but just knowing where to go. Those people were pulled out. Can we agree that they were, unless you differ? I'm not saying you were there, it was your fault, but those people were pulled out. Are you aware that they were? I heard about it. Okay, you heard about it. Yes. Okay, so they were pulled back, right? So now that we know. Let us talk about the other practicality. Do you have an idea of what the medical reports needed cost? Okay, so we had somebody from the Law Society here. You can get us for anything. So if you want an accident report, depending on where you are, it's 200 and some odd rand to like 400 and some odd rand. You then need an occupational therapist. You might need to go to an orthopedic surgeon. You might need to go to all of these people. A person has to go on their own and pay for those reports, and some of them are up to 30-something odd thousand rand. As I understand each report, as I understand, in order for your claim to be registered, you must have all of that information ready in terms of the new RAF 1 form. Would that be correct? So that you can choose the products, because at the Road Accident Fund, the different claims are called products. You can now pick the products that you, right? Is that correct? You have to have all your information ready or your claim will not be registered.
Correct, Chair.
Okay, can we also agree that someone from a village who may not know which kind of specialist you need, who might not know where to find them, who might also not have the money, just won't know where to go, and therefore they get locked out because they also can't afford an attorney? Can we, am I unreasonable in that assumption? That person who used to be assisted by the RAF close to where they are now no longer gets assisted, so that person's out of the system. Am I wrong in that assumption? Are we talking now? So in substance, what has occurred is that it has been made difficult, particularly for vulnerable people, to be able to successfully launch a claim. And the difficulty that the committee has is that some of these people genuinely, in fact, a lot of, I mean, there are people who just want imali yamatambo and see if I can build a house with it, or I blew it, right? People need wheelchairs. People need to get medical attention. Sometimes, because it takes long, these reports are valid for 2 years, and you must go and get another one and pay money again, right? Would I be wrong in saying it really has been made difficult for normal people? Without an attorney, you screwed. Sorry, excuse my language, but without an attorney, you are out. That's what it appears to us, and that's what makes the committee members anxious, right? And so a statement that says the ability to launch a direct claim has been taken away, then you end up going to the same attorneys we say are ripping off the rough. Because what else can I do? Because the attorney we asked Mr. Mvundlela, he was here last week. The attorney pays for all of these things themselves. It's not just pushing paper, actually. It's untrue to say people get paid to push paper under these circumstances. And the whole dispute is that in order for somebody to be able to lodge a claim, it really shouldn't be this hard. And what we know from Mr. Moache, I think it is, the Chief Claims Officer, right, Sep? What we know from him, and we know from the other gentleman, I forget the guy who works with medical, and we know from others, is that the RAF used to help people with this stuff so that they don't need to go to an attorney. It doesn't happen anymore. Can we just be honest with one another and just stop playing silly buggers? It's been made difficult. While the message is we try claim directly, but you're going to need 100,000 rand. And you're going to need to wait a year. Am I wrong? It's more difficult, it's more expensive. And the undertaking letters, you can't get one if there's no person near you, right? Isn't that so? Where are you going to get an undertaking letter at the Tulele Hospital in Mkanduli? Honestly, let's just be honest with one another. I'm asking because the public claim is, and the reason some of us get called names here for having this process, is that we working for the attorneys, and my frustration is at the Tulele and Madwaleni Hospital, there is nobody. Miss Mate came and sat here. They destroyed marketing material. They were instructed to destroy marketing material. They pulled ads that had already been paid for, encouraging people to settle direct claims. If all of that is true, Ms. Khumalo, can we just as human beings level with one another here now?
Chairperson, my response to you was what the RAF Act currently says. That was my response to you, and that's why
I am coming to that part.
Okay.
I'm just asking here that the Road Accident Fund has taken active steps to take the ability to, in a reasonable process, lodge a direct claim so that I don't need to go to an attorney unnecessarily. It's gone. I'm asking if I'm being unreasonable. I've listed all of these things. If I'm a vulnerable person from Madwaleni Hospital, can we agree it's harder? I don't want to put words in your mouth, but it's harder, it's more expensive. It's unaffordable. Okay, I'll leave you to it, but it's harder and it's more expensive. We can't have it both ways, where we say we don't want attorneys, but we put up obstacles to make it difficult for people to do it on their own. And the information that the RAF has given us proves the point. Direct claims have collapsed. Now, it may well be that that's what the RAF Act envisages. There's a part about the requirements of the RAF form. All I want to know from you is this now. Was it the view of the board, to your knowledge, the board as the accounting authority and management, that actually the RAF Act envisages a situation where people are actually represented? And you know what? We have no obligation to make it easy for them. They must go and find a representative, and logically. In sum, is that the position?
Chairperson, this started before my time, but certainly between discussions as this RAF 1 form issue is taking place, it's not the view. Actually, the issue around amending the RAF 1 form was to say we need to settle as soon as possible for the claimant. So for us to do that, operations needs all the documents so that then it can make an offer.
I get the theory. You also wanted to reduce costs, you as a organization, by firing the firm of attorneys, right? The panel of attorneys, without an active replacement immediately, right? We know that. So intention is one thing. My question was, in effect, the requirements are more. The access to people who can help you has been withdrawn. Maybe we can just leave it. I'll leave it as my opinion for the members. But that's what we see in front of us. Honorable Kupek.
Chair, given the last 20 minutes here regarding what we're speaking about now, the issue of direct claims, and the team from RAF today basically distancing themselves from the decision as if they know nothing about it, then I have to say that it's no wonder the draft doesn't work. Because the other day, the team that was here, they basically gave to us pound for pound, this is what happened. They basically were told to do away with direct claims. The team that's sitting here in front of us today, they do not want to acknowledge any part of that. And just to give credence to what you were saying here, Chair, the RAF's marketing and communication budget for public outreach on direct claims, the expenditure fell to zero from 12.17 million 2 years prior. Essentially, by year 2020, the RAF had entirely halted the campaign and efforts to encourage and facilitate direct claims. Now, the team that is sitting here in front of us, dare I say, are being disingenuous in that they do not know anything about this thing. So there's no wonder RAF it doesn't work, Chair. Thank you.
Yeah, we'll leave that as a comment. Thank you. Anyway, okay.
I don't think it's fair, Honorable Member, to say we are distancing ourselves and making as if we don't know. I had just raised my hands when we were asking Ms. Manyasha around direct claims and talked about what had happened and the issues of Ubuntu and what the Act says. I had just said that. So we know about direct claims, but we are also saying that we understand, and I had said, like the chairperson has said when we started to say, if you were not around, say you were not around. If you've read things, say you've read things. I have clearly said I have read them. I have read about direct claims. And because of the issue around RAF 1 form, and because of the issues that we're discussing at ESCO around doing the campaigns to say people must come in and say, how far is my claim? I know about the direct claims. So I've never said I don't know. So I think it's an unfair statement for you to make. Thank you.
Okay, Honorable Kupek, can we leave? Yeah.
I won't comment, Chair. I'll leave it at that.
Okay, thank you. Honorable
Otherwise, it's not going to finish.
Thank you, Chair. I want to go straight to the questions without making a comment, but I am really tempted to make a comment first. I think the picture that has been painted today, which is common with what all other witnesses have projected, is the fact that Mr. Collins Letsoalo was a dictator. That's the summary of the day. And this is why I say that. So that when I ask questions, maybe clarity could be brought to dispute that if such exists. My understanding of how MANCO would work is that even if it's not my department, if I'm a member of MANCO, a proposal or a strategic view would be brought into Manco, and we'll deliberate on it. We'll review it from time to time. It becomes our collective decision and approach. So I can't sit here as a member of Manco and say that strategic decision belongs to somebody else. Unless if I say that the CEO, it was from that department to the CEO and downwards, and there was no vertical engagement at a strategic management level. And unless, obviously, if my understanding of what a management committee or an executive management committee's role is. But what seems to be coming through is that there are certain strategic directions that cannot be accounted for to detail, because even if the decision was taken before my time, at some point I would have engaged with it, and as a responsible and as a senior management or an executive management person, I would have sat down and said, in terms of the business processes, how is this thing working for us? When in 5 years, there's no way that we could have not reviewed any decision. And I think it's not only a role of a line manager to come up with that, to come up with the kind of questions that we're asking here today. So I'm just laying that as an overall picture that seems to be coming out. And then I'll ask my follow-up questions. Maybe then also it can be refuted if it is not an accurate picture. Maybe let me start with yourself, Mr. Letsoalo. Who signed the letters dismissing those employees? Oh, you're saying you were not there by the time it was finalized, so you wouldn't know. Okay, no, it's fine. Because I wanted to come to the decision of who signed and whether there was an appeal process provided and who will then have appealed. Because earlier on you said it would have appeared that the CEO wanted to be the presiding officer, was the one responsible for the decision. So if then the same person who gives an instruction to get rid would have under him or directly by him overseen the appeal by those employees, because those are how internal process would work, and I don't think that would have been fair. But let me leave that question out because you were not involved. Let me come to Ms. Manyasha, and you'll forgive me if I was out. I think the chair tried to canvass some of these issues, but I want a direct response. There was a decision to not promote direct claims. Why was that decision not communicated in writing? And I think it has been common cause that it was not communicated in writing. I just want to understand why it was not communicated in writing. And maybe coupled with that, whose decision was it? Was it an executive management decision of a meeting, or was it a board decision? Was it a decision of the chair of the CEO? And can I just pause there on that question? Thank you.
I'm trying to multitask and possibly also tired. I heard the part about who made the decision. And then the other question was, it was 2 questions?
Why was it not deduced in writing and communicated and circulated to staff? Because you did say earlier that it was not in writing. I just want to know why was it not put in writing? And I think many other witnesses have also confirmed that it was not put in writing.
Unfortunately, Honorable Madlala, I don't know why it was not put in writing. What I can say is that I know that the conversation took place between executive and the board at the time, and there was a debate around it, and the board was strongly saying what Ms. Khumalo is saying, that if the act is not helping us in terms of direct claims, why should we continue with it? As to why it was not put in writing, I don't know. The person that is responsible for claims, I suspect, should have been the one that is communicating that decision, because it falls under their responsibilities.
Okay, who took the decision? Is it the board? If you are not in the board, like the chair said, then you can say, I don't know. Because you are mentioning that it was a debate. I just want to understand who then took the decision, because someone took the decision which gave effect to this banners withdrawn, all of these things, staff relocated and all of that, which also came to the Chief Claims Officer, if I'm not mistaken, Ms. Mtetwa, as a verbal instruction, because she did also mention that there was nothing written to that effect. So I need to know who took the decision, because whoever took the decision then is also liable for communicating it, not necessarily the one who must operationalize it. That one should have received it as an instruction, which she did not receive it in writing. So I need to understand if it was a board, so that when we see them next week, we can say, why did you not put it in writing and communicate it? So if you don't know, it's okay. You can say you don't know who took the decision.
I do not know who took the decision. From that board discussion, I don't know if there was a decision. I just know about the discussion that happened there, but I don't know if there was a formal decision made.
You want to say something, Ms. Khumalo?
Honourable Member, I mean, just to prove your point, to say we don't know, we don't take time to read about these issues if we come across them as management, that it's not a correct reflection. And that's what I was saying to Honourable Kubeka, that we talked about the direct claims and what you're talking about. I mean, I came to RAF August 2022. Direct claims apparently started in 2008. And there was then a direct management claims and policy and SOPs that were done by the RAF in 2015 to support this direct claim process. On 17th of January 2020, then the board approved the decision to say that they'll be slowing down on issues around direct claims because of the challenges that they had received, of saying they cannot finalize direct claims because they can't find the claimants, there's claims that have been prescribing under the watch of RAF because there's not been summonses issued, because you can't exactly issue summonses against yourself. We can't, as RAF staff, then go to the lawyers and say, lawyers, come and sue us as RAF because we have not finalized your claim. We will not finalize this claimant's claim within 120. So those are the challenges that are there. And unfortunately, there are challenges that are in the Act. And as a result, on the 18th of December 2020, then the EXCO then said, these direct claims will stop. It's in their minutes. And then on the 21st of December 2020, that's when the Project Shanyela started to say, let's wind down direct claims and finalize them. So that's how the timelines of direct claims has happened. And of course, it's easier. We also prefer that claimants must come directly to us. The Act unfortunately says something, and that's why we had then in the RAF Amendment Act to say we were promoting the issue of claimants coming directly to the RAF. We agree. It's much easier for claimants to come directly. Unfortunately, the Act has its own rules, and we had said in the RAF Amendment Act bill that we had proposed to say we want to put processes in place to make it easier for the claimants to come directly to us, so that then we can also deal with the issues of prescription, what happens if we are not doing anything, what will happen with the issues around summonses and all. Thank you.
So, Honorable, let me stop your clock. You know, I noticed something. You said let's wind down direct claims. I can remember not so long ago, you didn't want to go with winding down. So earlier when you said a decision was taken to wind down direct claims, you said that's not true. You've just used that term now. You yourself have just used that term. You said wind down direct claims. Yeah, you said wind down.
Yes, Chairperson. Yes. I don't remember if I didn't agree with the wind down, but I was saying, in terms of what Project Shanyela was saying,
yeah,
the Project Shanyela that was implemented 21 December 2020, it was saying the purpose of it was that they wanted to wind down on direct claims.
Yes, okay, I don't want to, we have to nitpick. You know, when you wind something down, for example, somebody passes away and their estate is being wound down, it's going to get shut. You know that, ne? It's going to get closed. So when you say to wind down direct claims, and this is the term that we've heard time and again, which is we don't want to do this direct claims thing anymore. Shanyela is going to clean those that are in the system. Once they're done, we don't do it anymore. You've just used the term. That's why I interrupted, Honorable.
I don't understand what's the...
So when you're winding something down, you basically bringing it to a close. That's what winding down is. So when you say to wind down direct claims, we're going to get to a point where we don't do it anymore. And this is why I intervened, because we've been told Shanyela, which Mr. Mkwali was sitting here, was responsible for, I don't know if he still is, right? Was to say, we've got all of these direct claims that are in the system that have got the problems that you're talking about. People are on their 8th cell phone number, can't find them anymore, right? As soon as we clean that out, we're not going to do them anymore. We've even withdrawn the people out there in the Khamadulas, so that we don't have new people coming into the system. That's what winding down. And I just wanted to point that out, that you've just used the term yourself, and it jumped at me because not 20 minutes ago you were like, no, slow down. You corrected us, but now you're saying wind down. It's a comment. It happened. Carry on, Honorable Madla.
Thank you, Chair. And I think we should really be careful about the choice of words we use. Yeah, we can say English we use, because deciding not to promote is something else. Saying we are not going to promote, we'll accept when it comes. But winding down is an effort, it's an action item. Saying we want to reduce it to a point that the Chair is saying we bring it to a close. So we take note of that, but I'm not going to dwell on it. I just want to understand, maybe, Ms. Manyasha, if you're involved in the process of not the secondment now, but the appointment of Mr. Msiza into a position of a specialist, security specialist. Were you involved in that process in any way?
Yes, I was in the interview panel.
All right. The post was advertised with an NQF level above NQF level 6. It was then withdrawn and re-advertised with a lower NQF level, which is NQF level 6, that Mr. Msiza happened to be having in human capital or human resources, which then made him meet the requirement of the second advert. Do you want to maybe take us through what was the cause for the withdrawal of the first advert and the adjustment of the requirement, and which does not actually speak to the management level of the post?
Yes, the post was advertised with requirement of NQF level 6. And I got to find out about that when I received a call from Mr. Msiza himself, saying that this position has been advertised, and it has been advertised with a wrong specification. Job profile, meaning qualification. And at the time, I saw the advert, and I thought everything was in order with that advert, the way it was advertised. Because I know that at the Road Accident Fund, senior management positions require NQF level 7. So for me, there was nothing abnormal with the advert. But then he phoned me and informed me that it was advertised wrongly. I went back and I looked at the job profile that was signed, and I think before I even got there, Mr. Msiza wrote an email to Mr. Ian Barriel complaining about the change of the job specifications. So there was an exchange between Mr. Msiza, Mr. Barriel, and the organizational development, which are responsible for the structure. Chair, I can request that those emails be sent so that the committee can have a view of the conversations between Mr. Msiza and the HR department at the time. So the response from Mr. Ian Barrel, if I remember very well, I was copied in all conversations. I was not in HR. The response from Mr. Ian Barrel was that after the job profiles were approved, and it's true, the job profile was approved with NQF level 6. But after the job profile was approved, the organizational development team looked at that and saw an anomaly. and they thought it was a mistake, so they corrected it. Rightfully so. They corrected the job profile and they advertised it as will be with all senior managers at the Road Accident Fund. However, Mr. Msiza contended and lodged a complaint about that change of job profile without consulting. Organizational development then wrote, I think they wrote to the CEO, I know they wrote to the CEO, explaining the situation that this cannot happen, that one person in senior management's requirement is lowered. It will be the only senior manager with NQF level 6. And they admitted, HR, that they made a mistake of not coming back to get the new job profile signed. Because the job profile that was signed originally was at NQF level 6. However, when they looked at it, they thought it was a mistake, and then they just changed it without going back to get a new job profile signed. They just thought, it's a mistake, let's correct it and let's move along with it. So they wrote to the CEO explaining that they made a mistake and they advertised this. However, this is in line with the approved PwC job leveling as it would be. And the CEO then agreed that the job profile, because it was not changed, it should be re-advertised then at a lower level. I hope I've given a full story.
Yes, you have. You have given a full story. So in summary, you are saying that the CEO, you said the CEO agreed that despite the framework of job profiles, simply because it was not resubmitted for consultation or for signature, it should then go on advert, wrong as it is. That's what you are saying. You can say it on record.
Yes, Honorable Madlala.
Thank you.
As we enter injury time, but you can ask. You can ask.
Well, unfortunately, I needed to ask Ms. Khumalo. So.
No, please go. Oh, she's not.
Yeah, so
okay, let's park it when she comes back.
Yeah,
so
then I can
after,
get right on to that. That will be my last question.
Okay, no, that's fine. Let me just ask Ms. Manyasha. You know what I find interesting? Mr. Lehum, who had actually been the head of security, was an NQF level.
He's got an NQF level 9.
Right, so in other words, he would qualify for the role. Mr. Msiza, who was Mr. Letsoalo's business partner, we've established by his own admission, did not qualify actually for the job. But on the face of it, it appears that the job requirements, you've got a colleague who's on suspension at home, NQF level 9, qualifies for the role. In terms of previous performance, there really had been nothing to say that they were underperforming. The job gets re-advertised at a lower NQF. Just one question. Were there any other roles at a senior management level which were NQF level 6? Was that the only one?
To my knowledge, it is the only one.
Okay, no, thank you. Honorable Isaac. I don't know, you might have questions for Ms. Khumalo, and she's asked to go to the bathroom quickly. I never want to deny a bathroom break to someone.
No.
So have you got questions for Ms. Manyasha only, or you want us to wait for Ms. Khumalo as well?
That's fine, Chair. I'll just continue then with Mr. Letsoalo.
Okay, that's fine.
Right?
Okay.
And,
No, thank you.
And then perhaps if Ms. Khumalo is back, I just have one.
Okay, awesome.
All
Thank
right.
you.
So, yeah, thanks. Mr. Letsoalo, just to refresh. How were you appointed? Just explain how were you appointed as a senior ER manager at RAF? So it's just very short, concise.
There was an agency, I think at the time it was Kelly, that gave me a call and informed me about a position available at the RAF and asked whether I would be interested. They requested me to send them my CV, which I did. From there, I was called by the RAF for interviews. The first interview was around the table. The second one, I had to make a presentation. After that, I went to, what is that, EOI or something for this assessment, psychometric assessments. Then I got a call that I am the successful candidate, which was followed up by a letter. That's how I was appointed at the Road Accident Fund.
No, thanks. I'm just trying to figure out. So, because my understanding is that both you and Mr. Collins Letsoalo, the CEO, you both come from Sishiru, am I correct?
Commissioner, actually, he comes from a village called Ramolepo, which is around Polokwane. And I come from a place called Gasekororo, further down. Could be 120 or 50 apart.
Yeah, now you see, I know the area well because I come from Mpumalanga. So I know Polokwane, I know Sishiru. You're talking about two different villages here, basically. But you come from the same area, same part.
From the same province.
Same province. Maybe the Khoshi is different.
Very different.
Yeah, that's about it.
Yeah.
So I just find it difficult to comprehend, and again, with due respect, that you say you said earlier this morning that you never knew each other, you don't know each other, your paths never crossed, although you might share the same surnames, but be that as it may. But you both come from Polokwane, from Sishiru. So Angati, I'm just trying to put this thing together in my mind, you know.
I actually knew about him when there were issues at Prasa. I was reading, I was watching TV, but at the time we never met until I joined the RAF and he came later. That's when I started knowing him face to face. But prior to that, we never met.
Thank you, sir. I'm just trying to keep the answers concise because I get into injury time quick. So, tell me, Mr. Letsoalo, there was this, let's just move to another thing. Your predecessor, do you know who your predecessor was? Or you have no idea? Just short and sweet.
I used to know, and he passed away before I joined the RAF. I can't remember his name. Yeah, we never met, yes.
That's fine, that's good enough, sir. If I might ask you, and I ask you just to be pretty transparent about this, I need you to tell us, as the committee and fellow South Africans that might be listening, there's this issue that I made a note here about the Road Accident Fund paying for the General Secretary of NUMSA's birthday party. A certain Mr. Irvin Jim or something, there was a birthday party that was held. And that might have been paid for and funded for by RAF. Are you aware of this, sir?
Honorable Member, I'm hearing about this for the very, very, very first time. When did it happen? I don't know.
You're not aware of this? You have no idea?
No idea. Okay. I don't know.
All right. We'll check with the other colleagues. Maybe they might know. Yeah. Okay. And then I must ask you this as in charge of ER. What happened or what transpired the night that the Road Accident Fund got an interdict to the planned staff action that was to commence the following day? You recall that incident? Tell us what happened.
I wasn't at the RAF at the time. I wasn't there.
But you know of it? You've heard of it?
No.
So you know nothing of it?
Nothing.
So who's going to tell us about this?
I don't know. Maybe the current ER staff or somebody that is, I have been told, reliably so, that there is somebody acting in the role of senior manager employee relations.
So shall we inquire there? Is that your suggestion?
Yes.
Okay. Can I ask you this? Both you and Mr. Barrio, would you say that both you and Mr. Barrio were the CEO's yes men?
It's a difficult question, not necessarily yes men. If him and I were the CEO's yes men, it means almost every manager in the RAF was.
Okay, but specifically, you see why I'm going back there is based on our discussion this morning, and you know the comments that you made, and the words that came from the two ladies across also, is that you guys were very fearful of this man. He was like, you know, Mr. Untouchable, I don't know. So this is my question to you. I mean, if he told you to jump, you would ask how high. If he told Mr. Barrel to jump, you would say how high. Is that the point? Were you the yes man? Were you the rubber stamps of everything?
I want to respond to that question by telling the committee what happened the other day when I was at the CCMA Johannesburg with senior counsel, and evidence came before us from the other party that the RAF was not going to succeed in that matter. I just forgot the merit, but I know the fact that there was an issue about an email that, as the RAF, we didn't have sight of before going to the CCMA. And I was with Nazir Kasim, SC. The instructing attorney, I think, was Muhulazi. Then I had to call him, the CEO. He shouted at me. He told him he's busy working and I'm playing, and I'm at the CCMA. I need to inform him about developments at the CCMA. Then I had told counsel that, and he could hear because he was standing close to me. And he said, hey, just leave that man. He will fire you. He will fire you. I know him from Prasa. I did matters at Prasa. He will fire you. And then I said, okay. And he committed to talking to him himself.
I'm just trying to, you know, get a more better picture on behalf of myself and my fellow colleagues. And then this issue, obviously, you basically carried out every other instruction that you were given without fail. I mean, whatever he said went. That's what I make of what you're summarizing. That 189 process, you went ahead full steam. Now, you were in charge there. I mean, what prompted this? I mean, surely, I mean, did it make sense to you, this process, to go ahead being the specialist, the ER specialist? I mean, surely, you know, there's an element of common sense and business decisions that must prevail. And obviously, a huge element of consciousness for the position that you occupy. How did you just throw caution to the wind, just go ahead full steam? I need to understand this, because it's affected a lot of people's lives here. You know.
Yeah, it was a very emotional process. It pained me, because I was also affected. Ms. Manyasha has just given evidence regarding the appointment of the specialist or senior manager in security at level 6. I hold an NQF7 senior manager, but my job was affected. So for that and for other people as well in the same boat with me, the process wasn't fair. To a point where we then sourced facilitation by the CCMA, which was granted, and there were a lot of lashings from the CCMA with regard to how the process was unfolding. So parallel to that was the process of Section 189 for those that were at general manager level. Hence, they took us to the labor court. I came back and I advised the CEO after losing that case. In fact, we did not lose the case because the court said the RAF appoint an independent chairperson. Let the independent chairperson facilitate so that we can finalize this. But I went to the CEO as usual, and he refused. He told me the court can't tell him what to do. We proceed as instructed.
So by the sound of things, the relationship just deteriorated, okay, because you were bumping heads, and as you were saying that it worried you consciously. So obviously you came to a point after CCMA, etc., and you spoke about it this morning also, and then the charges that were leveled against you, you mentioned that you remembered 2, you couldn't remember the other 3 or something to that effect, right? Okay, go ahead,
Yes.
then I want to conclude on this question.
Okay, thanks, Honorable Member. I think that's something I need to correct. The sexual harassment charge was not there because they could not find any evidence in the investigation. There was no sexual harassment charge. It was an allegation, it was tested, and there was no recommendation on to proceed with the charge.
Okay, so then you came to a settlement, that is my understanding. Am I correct? So what was that settlement? How much did they offer you to walk away?
Not much, Honorable. It was 4 months. 4 months salary.
How much is that equivalent to?
Oh, I forgot the figures. The figures. Now.
I promise you, the last time I got a salary, I remember it like yesterday. I find it difficult to comprehend. You cannot recall the settlement.
Honorable, member was not stressed or under stress. I was under stress. It was not even enough. It's gone now.
You're not prepared to say what the settlement was, right?
I want to.
But you can't recall.
But I can't recall. Okay. I can check, but.
Okay, let it be.
Mr. Letsoalo,
sorry, Chair.
No, Mr. Letsoalo, you know how much we're getting paid per month. I mean, do you get pay slips at the Road Accident Fund? You don't remember? You don't have to tell us the cents or the couple of 100 rand. You really don't remember?
But it was 4 months. Salary.
No, just 1 month. I mean, it was your salary. It's 1 month times 4.
We'll multiply it for you. So less than
Hey, Chief.
I mean, this is just so not a big deal. I mean,
it is, Chair.
You can't remember.
Honestly.
I would love to forget how much I'm getting paid. Okay, no ballpark figures, nothing.
I'm calculating.
Okay, does anything turn on it, Honorable Isaac? I just can't believe that Mr. Letsoalo still has not produced.
Sure, I think this is about.
It is 626, around that. 626,000.
Okay, all right. Okay, thank you. Okay, Honorable Isaac, you've got a few, like 1.5 minutes left.
Well done, Mr. Letsoalo. You see my injury time.
I had stopped the clock, by the way, when I was asking.
Okay, quickly, let's. I still wanted a question with the pretty lady across there. Quickly. I must ask you this on a serious note now, really. Why did you go ahead and charge employees without investigation reports. Without investigation reports. I mean, when managers did not agree with you that these employees have committed any misconduct, and they pointed out to you on various occasions that various people have not created any misconduct or are not responsible for any misconduct or guilty of any misconduct. And I mean, you know, you just went ahead and just went and fired these people. We heard the story this morning. We heard about the 20 employees that were just told one morning they needed to be fired, etc. And then there was the issue, while you're answering that, because I don't want to run out of time, can you just touch on Mr. Barriel's case with the CCMA? What do you know about it? Thank you, Chair.
Thanks, Honourable Member. Let me start with the employees that were dismissed or that were disciplined. Let me rather use the word disciplined without their manager's agreement. I have explained earlier that I went to my boss and I informed him. But then he told me that that was an instruction, so it was not negotiable. It was not negotiable. On instances, I would be told that if I don't do this, then I must go. I have made an example of the case of Mr. William Maputa. I think he was the spokesperson, where I was told those words in front of Ms. Manyasha in her office, that okay, I was advising, and I was told that if he doesn't do it, then he must go, meaning me. So that is the response to the first question. The second part.
What do you know a little about Mr. Barriel's case with the CCMA?
Oh, okay. Mr. Barriel was one of the general managers that were consulted on Section 189. And the CEO kept on renewing his contract for 3 months, 6 months, and so forth. What I remember was that, was it the second but last extension? Because I think the last extension I wasn't there. There was this agreement between the parties that because he was supposed to have been retrenched, but instead of being retrenched, he was retained. At the time when he exited the RAF, he would still get his retrenchment package. I learned on the 1st of October last year, 2024, when he sent me a text. I'm going to read the text. I think I still have it. WhatsApp text.
Sorry, who is this text from?
From Mr. Ian Barriel. Mm. And it looks like somebody wrote this WhatsApp message for him because it came to me as a forwarded message. I must state that for the record. That was on the 2nd of October. I left the 30th of September. Now, in this WhatsApp message, he says, "Morning, Mutloading. I am sad to hear that your relationship with the RAF has reached its course. I wanted to ask you if you would do an affidavit or testify at my CCMA arbitration. They are refusing to pay me my severance package, or pay as agreed, as per the letter signed by Patu. Patu is Patutsezo Lukwarini, the acting CEO after the departure of Mr. Letsoalo. I also don't have the minutes of the meetings with Benny's. So the reason why he's talking about this, he's mentioning the names of these two people is because they are executives and they were instructed by the CEO to chair and facilitate the retrenchment process of the general managers. Then I was part of that, and also for the employees in the bargaining council, bargaining forum or bargaining unit, and other employees that did not belong to the union.
So, Honorable Isaac, you are at an end. Yeah, no, we are now in extra time. Thank you. Honorable.
Thank you, Chair.
Yes, yeah, there was an outstanding question when Ms. Khumalo had stepped out, yes.
Yeah, thank you, Chair. I suspected you would likely forget.
On the home straight.
All right. Well, I'll just try and sum the question up. Actually, it's quite a lot of questions, but I don't want to take the time of committee. It's in relation to the post of the head legal services. You've made an assertion that there was an acting person who later on said that they are not willing to continue acting. That person was remunerated. You'll correct me if I'm wrong. My understanding is that then there would have been an advert to invite people to come and act to the post. If there was not advert, still, the person would have met the full requirements of the post if they were receiving the full or equivalent remuneration for it, which means they take full responsibility, full accountability of those duties. Now, amongst your senior advocates currently now, is there no one who's willing to act on the post? And I'm asking this in relation to the fact that you said you now do the duties of the head legal. And it means that you do 100% of those duties as well as the duties of your office. And practically and scientifically, that is not possible. It means you either falter on both or you run short on one of them. Because you can't have a full job description that you perform for two duties at the same time. And this may have created then the gap in terms of the quality control of the process management in relation to the claims that we were speaking about earlier. So I just need to understand, I just need your comment around that, because now you're doing two full job descriptions of two positions. And I'm telling you that scientifically I don't think it's possible. What interim mechanisms are you looking into pending the structure that you're speaking about? I'm saying I'm going to just bulk it all together to give you a framework, but you can then make a comment on it. Thank you, Chair.
Thank you, through you, Chair, Honourable Member. When we appoint people to act, there's no advert that is taken out for acting. You look at the person's capabilities and skills at that moment and what they have on their table. And then you, as a manager, then decide whether, then you say this one is the appropriate person to act. Then you will call them in to say, I've identified you as a possible person to be able to act in this position based on these reasons. Are you willing? If they are willing, then there's a memo that has been done. HR is informed. So that then the acting allowance can also be effected. So that's the process. There's no ad because they're internal people. The other question was around whether amongst the two advocates then, is there no one that will be able to act? Currently, the two advocates, the two senior managers' plates are full. One, Brett, deals with state attorneys. And we had then said we wanted to be on steroids in terms of capacitating that unit with state attorneys. We had a project plan in terms of how we're going to be doing it. So his plate is full around state attorneys, issues around having your litigation management system, acquiring it, etc. With regards to Nico, he's also here. Nico's unit, that's the one I said, it's a new unit on legal administration. His plate is also full because we are currently looking together with HR and operations in terms of movement of people that were doing things that now needs to come to legal administrations that were in operations, so that it's just not a haphazard movement, and then we then cripple operations, because that's not going to be effective and help us. So Nico is busy with that. Secondly, Nico is also busy with the issue or the process that has been started by the Gauteng High Court of court annex mediation that we are busy with, where they took out matters on the court roll to say that let them go through a formal process of mediation before they go back to the court roll. So currently their plates are full. As at before the end of this month, we had already shortlisted candidates for the position of head legal. So what was outstanding was for us then for HR then to call the people for interviews.
All right, thank you very much. Honorable Atkinson.
Thank you very much, Chair. Just a question for Mr. Letsoalo, one that just came through here now. Did you make any confession at the CCMA about colluding with the Commissioner to change or manipulate records?
Please elaborate.
All right. Did you make any confession at the CCMA about colluding with the Commissioner to change any records? Working with the Commissioner to change the record or whatever on...
No.
No, not you.
No.
And you don't have any knowledge whether Mr. Collins Letsoalo did the same or not? Was there any story about that, where he could have colluded with the Commissioner to change the record? No.
I don't have any knowledge
All
of
right,
that.
no, that's fine. Thank you. Okay.
Thanks.
All right, and then a further question, just around the whole issue of specialists and everything. You know, we spoke about how Mr. Letsoalo wanted to have a specialist in security to protect himself, and he looked for specialists in finance because of all the money that was going to come in that had to be looked after, you know, because of, well, particularly the CIO who came from Johannesburg, who's now suspended. What's very strange to me is that the Road Accident Fund, by its very nature, is a litigious organisation. Okay, is that you dealing the whole time in the law courts. Okay, dealing with judges, dealing with lawyers. You got people bringing actions against you. You got to protect yourself and everything. Why was it that he didn't see it important to have a proper person as head of legal, a real specialist? Because I mean, what we're saying now is that you've got yourself, who doesn't actually have a legal degree, but you've been advised by people who are lawyers and advocates. Why couldn't you have just put in a person in that position who is a specialist? Because I mean, this to me is one thing that doesn't make sense, is because it's by the very nature of your organisation, it is a litigious organisation. So why is there that gap there, basically?
Honorable Atkinson, the position of specialist legal was later also identified. I think it was in, when did you arrive? 2022. It was advertised in 2022 and failed. There's a lady that was hired as the specialist for legal support in the office of the CEO.
And what was her name?
Her name is Raksha Samnarayan, I think.
Is she still there?
No, she has
Right.
left.
How long did she stay in that position for?
She left, I think, around September last year.
Okay. So what? That would be about 2 years, I guess. Yeah. Okay. And what sort of legal qualifications did she have? Do you know off the top of your head?
I cannot remember her qualifications at the top of my head, but I know that she met the requirements of the job profile that was approved for that position.
All right. I see Mr. Phillips nodded. You don't have any knowledge of the legal qualifications of the lady who was advising the CEO?
Sorry, Honourable Atkinson, no, I don't.
Don't. Okay, no, that's fine. Thank you. Right. And then another issue was with regards to testimony we heard here a little while ago from Mr. Charakupa, who testified that one of the steps introduced as operational changes was to keep claims in transit, as he called them, keep them in the court process for as long as possible. Basically, so that payments didn't have to be made, was to kind of was to lengthen the whole process of the operation of getting claims and basically delaying the payment of claims, and that's also kind of partially what's resulted in the increase in default judgments. So I was just going to ask Mrs. Khumalo whether she'd been involved in that, whether that was whether you were the individual responsible for executing that policy of basically broadening or lengthening out the time that it took to pay out claims?
Honourable Member, which policy is that?
Was basically to do, well, Mr. Chair Cooper said to us that there was a move basically to what he called, I'll find the exact word,
Can I who's
to
Mr.
keep
Chair
claims in
Cooper again?
transit. Sorry?
Mr. Oh.
Chair Cooper, yeah.
Itai.
Yeah.
Oh, okay.
Yeah. And he said that there were operational changes, and the idea was to keep claims, what he called in transit. So in other words, to take for claims to be in the whole court process for much longer than they were. So obviously not to speed up the payment of claims, it's to slow down the payment of claims, to help with the liquidity of the road accident fund, in essence. But that's also one of the reasons apparently why you've had an increase in default judgments. But I was wondering whether you've been involved in that process to slow down the payment of claims at all.
I don't know if he was referring to the 180-day payment moratorium that we had requested the courts for.
Okay.
And from my understanding with that, the issue was we've got so many claims that will be due. For example, if you have a court order, it will then say you need to pay within 14 days of the court order. With so many claims or court orders that the RAF will receive, the RAF will not be able to pay all the claims with the amount of money it has monthly. So as a result, what do we do? Then let's get a strategy to then stratify the debt. So we're aging it, so that then we are also fair in terms of who are we paying. So we'll pay the oldest claim first and not just have a picky of saying who do we pay or who not to pay.
Right.
But it was definitely not around not wanting to pay. Because remember, Honourable Member, RAF is not a for-profit organization. Our mandate is to pay claimants.
Yeah.
But it's also a mandate to pay valid claims.
But what did seem to happen, though, and we kind of picked this up, was that through the illegal board notice, changing the accounting policy, the introduction of the RAF 1 form, there was definitely a move to, well, we can see it, going from 328,000 claims paid out to 78,000 claims paid out. There was definitely a move to change the nature of the road accident fund under Mr. Collins Letsoalo. And part of this, obviously slowing down the payment of claims, was part of that. He was actually there was an attempt to change the nature to build up large cash reserves, and potentially to run it as a sort of almost like a lending institution as well. So to pay out claims, but to run a separate business alongside it. That's, in essence, what we've been told. But anyway, let's not go too far into that. The other question I wanted to ask you was, as part of your governance responsibility, did you have sight over bank accounts?
No.
No. Okay. So who was responsible for ensuring that all bank accounts were run in proper order, basically?
Financial officer.
All right. Okay. That's fine. All right. I'm fine. Thank you very much.
Right. Thank you very much, Honourable Atkinson. Honourable Blossom.
Thank you, Chair. Graveyard shift. We'll try and move with speed. No, look.
It also relates to the length of the answers. I note you guys, and I sit here and I'm like, I think you've answered the question, but you're offering more.
Yeah.
So,
all right, Ms. Khumalo. Maybe before I come to you, Chair. You know, when we grew up, we knew there was the ANC Youth League that would somehow produce quality leaders. Now, I'm worried because we are sitting here, Chair, and dealing with an entity that pays about in excess of about 4 billion rand a month. And Honorable Maduna, I'm worried, is asking about chairs of 144 rand. For me, Chair, I think we are diverting and not dealing with serious issues. So when we're going to question a chair for 144 rand, Chair. That's why I'm saying sometimes we are going to be preoccupied by diversions in terms of what we need to deal with. There are serious issues that we need to deal, systematic issues here.
to go and look at it. So I needed to call him out because he's my brother. To say, no, he must focus.
We'll share the transcript with him.
Oh, yeah. Oh, he's not here.
No, he's not.
It's unfortunate. I thought he was
I'm
still
taking the bullets on his behalf.
Yeah, and he's not serious. We'll advise the chief whip of the ANC to relook into these matters. Yeah, but now look, yeah, because I'm seriously worried. We are dealing about billions. People are telling us about shares of 144 rand. Aye. Okay, no, look, I want us to dispel some myths. For me, I'm very interested in. I worry about perception, because we live here and there's a perception that is created which is wrong. Now, Ms. Khumalo, you are the Chief Governance Officer, and beneath you there are 4 divisions. And part of it which has been coming across, which you have been questioned for your legal qualifications, because you preside over legal services. Now, I'll give you an example, and again, I want you to give me a comment. Now, you know, the South African government has got 3 arms of state. As Parliament, we are one of them. Then there's the executive, and there's the judiciary. And the head of state is the president. So he presides over the judiciary. But he's got no legal background. So is that the same sort of governance structure that you preside over?
Thank you, Honourable Member. Precisely, Honourable Member, and I think that's why when we started, I went a little bit at length around my qualifications when the chairperson said we must introduce ourselves. It was on purpose to go through my qualifications to show, one, I've never ever claimed that I've got an LLB. So there seems to be noises and the public out there to say, oh, legal services is under her, but yet she doesn't have an LLB. I'm an executive. My role as an executive is to lead, to guide, to provide direction, to ensure that the operations within my units are towards the achievement of RAF's objectives. That's my job. Then you hire specialists. And that's why I've been at pain the whole day to say, I've got 3 advocates admitted by the bars that are very competent, that provide guidance. And on top of those 3 advocates, we've got a panel of corporate attorneys that also provide us with legal opinion and legal advice and help us in representations. To say that there seems to be this thinking that if we've got a head legal, then it's going to be a panacea to all challenges that we have within our units. I've accepted that we have challenges and around the state attorney model, but having a head legal would not be a panacea to all the challenges that we are having. So, as my previous colleague had also said, that in the same vein, then we would say, if you want a CEO of RAF, you want a CEO of RAF that will be an actuary, an accountant, a doctor, a lawyer, etc., and a doctor, because those are all the elements that the CEO of RAF looks at. Thank you.
No, thank you, Ms. Khumalo, because I wanted that clarity, because I can see that you are being attacked for not having an LLB as if you claimed to have one. But precisely it's because the role that you're playing doesn't require one. But now we're harboring this point because we must give this perception that RAF is in a problem even with their lawyers and their litigation, because the person who's head of legal services doesn't have an LLB. That's the perception you're driving. And we need to dispel that myth. That's why I'm saying, I'm not saying that it's all lovely-dovely at RAF. But I'm saying that the perception we are creating a storm that doesn't exist, so that we elevate issues that don't exist at RAF. Now, let's also deal with the issue of direct claim, the RAF 1 form. So previously, before the RAF 1 form, it was the RAF claims form, right? Now, if a direct claim were to come previously with the previous RAF claims form, and it doesn't have the necessary documentation, but the person puts in the direct claim, will that person be paid without the required documentation that is needed?
No, Honourable Member, they wouldn't, because the claims officers need to assess Firstly, verify the validity of the claim, then assess. And how do you do that? You need all the required documentation of the product that the person is claiming for. So there's no way. Otherwise, our claims officers will be thumb-sucking settlement offers.
So basically, you'll be sitting with a bunch of direct claims that are accepted by RAF and are in your system, but don't have the necessary documentation to be paid.
So, Honorable Member, and that's currently the situation. As I said when you talked about the project Shanyela, to say, we currently, as we sit now, there are claims that have not been paid for years because there are no documentation. We can't get hold of those claimants because then we can't make offers because they're missing documents.
So my understanding then with the RAF 1 form, and you'll correct me because I'm trying to clear another perception, is to say that we can cry foul to say that RAF seems to want to take an approach that they do not want to admit direct claims. But my understanding is to say that it's of no use to be sitting with direct claims that cannot be actioned because of lack of documentation. We rather have the entire document at an application phase. So that's when the claim comes in. We are able to process it. And by the way, indirectly, then that will reduce the direct claims because those who don't have the correct documentation will then won't be able to process their claims. Is that analogy of or that I'm doing correct?
Honorable Member, it's correct. Really, the main point of RAF 1 form is that as the RAF, for you to say, I have put in a claim, you need to have all the required documents as per your claim to the RAF. And that's why I've been making examples of saying, our learned friends, the lawyers always say this is an earnest form and whatnot. It's not. Because the things that are required and the things that we are short at the RAF, it's not things that are Einstein. We require a certified ID copy of the claimant. We require your proof of salary, your salary advices. We require your accident report form. How are we going to really verify the claim without having those documents? That's why we've got such a lot of backlog. And that's why I was saying on our RNYP, there are matters that have aged, that are long due for payment, but it can't because documents are missing.
Okay, now let me get to the meat of this issue. Now there seems to be a fight against this RAF 1 form. Now give me a picture of how then does direct claims that are sitting with you that you cannot process because of lack of documentation benefit the lawyers?
Chair, because our act says if we don't do anything with the claim within 60 days, is valid in all respects in law. So previously, before this RAF, the introduction of RAF 1 form to say we need all the documents in, lawyers will bring half-filled forms with missing documentation. And because there's a huge number of forms that are submitted daily in all our offices, they know that RAF do not have the capacity to process all these claims within 60 days. As a result, they tend to be valid in all aspects in law. And what does it mean? It means then we are liable for that claim. But in the meantime, we've got a challenge to say we cannot finalize the claim because we are missing documents. What then happens to the RAF staff? The RAF staffs then end up being a call center, calling all the plaintiff attorneys, emailing them to say, we are missing these documents, can you please provide us those documents so that then we can settle the claim. The plaintiff attorneys, they have no interest in that, really. They will say, we'll give you the documents. And part of the issues is that for them, they know their legal costs will keep on increasing. Because they will have to talk to the claimant like, no, RAF, we're waiting for RAF, it has not given us an offer. Let's check. The claimant calls the lawyer. It's a charge. The claimants, they then say, let's go and do more medical reports. It's a charge. Transportation cost, etc. And we had also learned that in that meantime, while the RAF then is not finalizing the claim, some law firms then also offer the claimant money to say, let us give you a loan. So that then when you get back your claim, you will pay us back so that then you can leave. I mean, there were examples of others saying, one of the claimant was saying, we were whistleblower to say he wanted to increase their house, do alterations. And the lawyer was like, give me the code so that then I can be able to see whether I can loan you the money or not. So those are the challenges. For a claim to be delayed, the law firms, then their charges go up and up. But for RAF, it's not advantageous for us because we are not profit driven. We want to pay claims.
So you are bombarded with claims that are legal but have got no documentation, and you've become liable for them. And that's why you are being fought for introducing this RAF form. And a particular perception is created about it, whereas the seeks to transform RAF and make it more efficient. No, I get it. At least even if I'm the only one in the room, you must know that I get it. It's not a problem. Let's speak to, did you say that the enterprise risk management was taken away from you in terms of reporting? Let's speak to that.
The Forensic Investigations Department.
Oh, forensic.
Yes.
So why was it taken away again?
Chair, I have no idea. What I know was in the process, there were allegations that I was busy with against the head of the FID under my unit. I was busy processing them, and that was as a result of the report from the SIU, from her previous employer. I was busy with those, and all of a sudden then I got a letter from the chairperson saying with immediate effect from today, the 22nd of September, FID will no longer report to you.
Are you comfortable to share your thoughts in terms of what do you think is happening?
Honorable Member, not really, but you know, it makes me wonder that on that Wednesday, the chairperson unilaterally took that decision to say with immediate effect. And apparently on a Sunday afternoon, then the board met to have this, just for this, to pass this special resolution of FID to move away from me. And I mean, I've also been a company secretary in my previous life. I've never seen such a long resolution. It was nearly 3 pages long around what I should not do.
Honorable members, this is on Gwaza. Honorable Blossoms on Gwaza. So for your own safety, please keep it down.
These people have never been chased out of Parliament. Can you call bodyguards?
Please, Honorable Blossom, we need to go home, please.
Okay, were you done?
Yeah, no. So I was saying, so it left me wondering because there's never been any case or any complaints from the head of FID. Actually, I thought we are working very well. We were discussing this case as well in terms of her maybe having to do an Audi, etc., etc. So I was taken aback then to say FID is taken away from me so that it can do its work without fear or favor.
Yeah, we might need a lot of time to canvass that, but it's fine. Okay, look, I would like to, because I want to move to Mr. Letsoalo as well. I'd like to offer you 2 minutes of my time.
And you're about to enter injury time, by the way.
Chair?
Yes,
already?
I'm telling you.
Okay, let me just end with you, Ms. Khumalo. Well, you took all my time. You're the lucky one. No, look, you've been watching the proceedings. You've been here the whole day. Is there anything that you think us as a committee were missing, we've not covered, maybe that you would wanted us to look at, that you'd want to share, that you feel that, or anything, just, so I'm giving you the last of my time just for you to express yourself and tell us anything that you think we've not covered, and then that could help us going forward, or that you think that we need to be aware of. Thank you.
Thanks, Chair. Chair, for me, this committee has got all the rights to have this inquiry, and we are available to answer any questions. But I think, in earnest, it must be done in good faith. And what do I mean by that? There seems to be a movement towards to say that there's governance failures at the RAF. And one would then need to reflect, when did this governance failures start? As a result of what? How can an organization that is performing at over 80%, then we say there's governance failure? And that performance, by the way, is been reviewed and audited by the AG herself. How do we then say then there's governance failure in that? So therefore, I urge the committee to really look at what the real issues are to assist us as the RAF to be sustainable. The issue around RAF not being sustainable, it's been a long issue, Chairperson. Financial sustainability, we know about it. And that's why part of our proposals was on the RAF amendment. And now there's a RAPS bill. But we said, in the meantime, then we can pass regulations in terms of payment in annuity, in terms of assisting our claimants to be able to come to us directly to claim. So those are the issues that I'm appealing that the committee should look at and sift out the noises of people wanting to create chaos that is not there at the RAF.
Thank you very much. Ms. Khumalo, I'd like to start there. I'll come to you, Honorable Member, and I want to give you an opportunity to clarify yourself because you said, I am just anxious that you are also saying we're doing this in bad faith. And I just want to be certain that that's not what you are saying, right? And I need to understand whether your proposition is that if your own assessment says that on the objectives that you've set, you've achieved 80-something%, and therefore if the committee interrogates that performance, it's acting in bad faith. Is that what you're saying?
Chairperson, I'm not saying that. And that's why when I started, I said, we welcome this inquiry. And that's why I said we will then, well, that's why we come to the committee, to the inquiry when we are requested to come.
I heard all of that. I just want to fix the good faith part. That's all I'm interested in for now, before I hand over to Honorable. Because, Ms. Khumalo, when we interrogate with the Standing Committee on Public Accounts, when we interrogate legal cost per claim, I don't think that's a bad faith question to ask, notwithstanding what the AG says. Our job is not to take what the AG says and walk away and not look any further. Would you agree that if this committee is concerned with whether legal costs per claim are escalating, is a kind of question it should be asking, or you feel that we should not? Because that's one of the things that we've canvassed. Other members have canvassed the cost of a function, etc. So we've canvassed issues of whether invoices get checked, if the RAF is not getting ripped off, whether suppliers need to be investigated. Those are the issues that we've canvassed here. So I'm needing to understand your anxiety around good faith. Because when, by the admission of the officials, there is no process to check whether suppliers are ripping off the RAF, we do need to be concerned from a governance perspective, surely, I think. Would I be wrong? No, I'm asking, would I be wrong? Would I be asking a bad faith question if we ask those kind of questions? I said at the beginning, I'm giving you a chance to clarify your comments with regard to good faith and failures of governance, because we have to ask these questions in order to satisfy ourselves that the outcomes we see are the best possible outcomes. And by your own admission, I think I was talking to Ms. Manyasha here about invoicing of R1 billion, R1 billion. And the systems that are in place to make sure suppliers don't engage in nepotism on 1 billion. And you've got concerns about good faith. I do need to understand this. That's why I said I am giving you an opportunity to clarify your comments, because I do not want a situation where we are expected to accept anything the AG says and not dig further. Because the same Auditor General, by the way, says in the same report that part of the problem is that the performance criteria do not directly relate to the most important aspects of the Road Accident Fund's mandate. So, do need us to clarify this good faith, bad faith thing right now. It can't wait. Should we not be asking questions where the Auditor General has reached a conclusion?
Chairperson, my issue of saying can the committee then look at issues in good faith? It's based on when we are at these committees, sometimes it looks like personal attacks.
No, we are in this committee. And one of the things that I am always careful to repeat here, and I think I said so earlier, is that we are looking at systemic problems here. I said so.
Chairperson.
So when you say these committees, let's talk about this one. This one, you were asked a question about this inquiry. And you raised a question of good faith in this inquiry, in this process. And I listened very carefully. So we need to resolve it. What is your anxiety specifically? Have you been personally attacked? You, today?
Chairperson, please allow me to answer, because then when you interject me, then my thought process goes away.
I will not, but when you say these committees, I'm like...
This committee.
Okay, good. So this committee today, because you were asked by Honorable Blosse here that you've been sitting here all day today. That's what he said. I remember very well.
You are interrupting me again. Please
No, I'm explaining why it's important that you stick to the question asked. I'm saying Honorable Blosse said, you have been here today, you've been observing today. You raise an issue of good faith on today's proceedings. I don't want you to say these committees. I want you to say today, because that's what the question was. You raised a question of good faith. So I just want to know today, what specifically gave you the impression that we are not acting in good faith?
Chairperson, I don't know if Honorable Blosse was asking me around today or my impression of the inquiry as a whole.
Okay, I'll allow you to talk about the inquiry as a whole, but you were not here. And one of the things I try and I insisted at the beginning, if a monkey is not yours, don't fetch it. You are here today. You are here today.
Yeah.
He asked you a question about today. And your specific answer was, when the Auditor General says we've performed at 80-something%, where is this governance failure? And I could tell you were going to get yourself into trouble the moment you started answering that question. So I just want us to clear this up. What about the Auditor General's outcomes says this committee should not ask further questions? If it does, it's engaging in bad faith.
Chairperson, I feel that you want me to answer in a specific way, because when I try to answer, you interrupt. So
okay, please answer, Ms. Kumar. Yes, please do. No, it's not fine.
Because I tried 3 times to say, please don't interrupt me. Can I? Because then my thought process and my flow gets disturbed. But then you go to specific things to say I must then talk about them, while I was doing it holistically. So, Chairperson, with all due respect, can I just not?
No, you have to answer questions here. So let's start again. I said to you, I have an anxiety that when you say that the Auditor General has rated you 86% on your objectives, where are these governance failures that we are talking about here? And you said that in the context of good faith and bad faith. I am then saying to you, and I gave you examples of some of the things we've discussed here, about legal costs per claim, about invoicing, externalizing R1 billion, etc., etc. You are having an anxiety about good faith. I need to understand what has occurred today that gives you that anxiety. Alternately, is it your belief that if the Auditor General has given and plus 80% rating, then this committee must not ask further questions because the Auditor General has already concluded. I will sit and listen.
Chairperson, around my issue around good faith is because today there seems to have been a narrative that wants to be taken that as executives we don't know what's happening at the RAF. There was a narrative around my qualifications, and I think for the whole of today I've been answering issues around the head legal and my qualifications, and whether if there was no head legal, then that's why there's this mess. There were comments made by members to say this exco seems like it does not know anything. Why is it here? Because everything they said they were not there. But yet we were answering questions. And that's why I'm saying, can we then engage in good faith to try and resolve the issues of RAF? And I had also said that I know there are issues at RAF that needs to be taken care of. And this committee has all the rights to have this inquiry, which we welcome, so that it can help us as the RAF towards sustainability.
Okay, so basically what you're saying is that those members who were asking you those questions, in your opinion, engaging in bad faith questions. Okay, let's leave it. But I just want to advise that we must watch our words when we speak, because we do ask then the follow-up questions in this way. Honorable Member.
No, thank you, Chair. I just want to start here, Chair. I think I cautioned about this the other day, and I was going to say the benefit of my colleague, Honorable Blossa, is that he's sitting at transport. He can ask at length because he's got both background and information. And many of the things that we are asking are not necessarily for us, but for clarity and for everything. But at the same time, if we are going to witch hunt, character assassinate, and be bold about that on people that we want to appear before us, we're going to create a problem. I wonder about how we manage our own language in this inquiry. And I'm not going to say if ever Ms. Khumalo feels the way she feels, she's wrong. There was a day I even said myself, if I were to be one of the officials to come here, I would think twice, having heard in the during this inquiry, during question time and during our deliberations, the language, we ask them of predetermined results of certain things, yet we ourselves have predetermined the results of this same inquiry, and that's wrong. It shouldn't be. I just wanted to say that, because today, again, it comes here and then we get shocked. We shouldn't be. Now, what I wanted to ask, firstly, to Mr. Letsoalo. Mr. Letsoalo, on the categories I asked earlier on, did you also have a category where you considered how many people have died waiting for their money and not being loaded? And in that, did you have such cases of people who passed on waiting for their monies to be loaded, but their monies were not even loaded?
I don't have a specific response to that, but I know that people pass on, and I think it could have happened. I am not sure. I think it could have happened.
Oh, thank you. We'll wait for the full report on that. I think Mr. Niko's name came once in this committee, especially where people are charged and who assist in terms of looking into that. However, I will not draw you in because my time is very limited. However, please also prepare a report if you can in these categories because it's very interesting. Last thing, as much as you say on the finalization of these cases, you were no longer there. Maybe Mr. Manyasha or Miss Khumalo, Miss Manyasha, sorry, darling, or Miss Khumalo would assist us. Was there a replacement of the people that were dismissed for failing to load claims?
Thank you, Honorable Mente. The regional managers did make plans to replace some, not all. So they did hire some people on contract basis, but they have not really fully capacitated and replaced those people. So there is a struggle in the region for capacity.
Is there a plan in place to make sure that we operate maximally and in full capacity?
Yes, the last time we engaged with the Chief Claims Officer, the current Chief Claims Officer, even before the previous board was dismissed, we had requested the claims divisions to go and look at the capacity that they require and make presentation to EXCO so that we can approve the capacitation of the claims division. So there is a plan. Currently, I'm not sure if the current board has already approved it.
We're coming together nicely. So that plan is to reconcile the pre-existing conditions and the existing conditions around the backlog and the claims of people not being processed. Is that the case?
It is both, to deal with the backlog and to deal with the new claims as they come in.
When the management was here, they said they had started an operation, you gave it a name, where they are calling people now to establish their whereabouts for everything that is a claim there, whether more than the prescription timeline or whatsoever, to establish if they are sitting with valid or not valid claims. Do you know about that, and how far are we?
Yes, Honorable Mente, that is the backlog campaign that we are running through our contact center that was established. So the contact center agents are looking at the database that we have at the Road Accident Fund, and they are calling the last numbers that were registered on the system. They are calling those claimants to request them to forward the outstanding documents. So they inform them of what document is outstanding, not only individual direct claimants, but they're also calling law firms, because there is a lot of law firms also that have claims on the system, but with missing documents. So I don't have the details, but I think over 60% of that database, they've already called them, and the response is not that good in that aspect also. We're not really getting the documents that we require.
Now, what is the turnaround time where you get people and they respond to you in terms of finalization? Let me also give you an example. After that particular information being shared with us, we ran also a campaign to say, if you have a claim at RAF and you are not assisted, please come forward. I think we have now sent 3 batches to RAF. But on those 3 batches, over a month, we have only received one feedback. One person was responded to. And we have sent 3 batches of more than 30 people. I'm asking now, what becomes a turnaround time frame for you to investigate and respond to people?
Honorable Mente, unfortunately, I do not have that detail of the turnaround time, but I can check with the team if I'm allowed to request that information for you.
But maybe Member through Chair, in terms of the Act, we're supposed to look at that claim within 60 days. That's why if we don't, then it will be valid in all respects. But I guess yours, it's a different one to say there are claims already. You want, it's a query.
It's claims that have been there, and 70% of them, they are before 2016. 70% of them, what I identify, they were before your time. But we can't get responses. We're not getting responses. So my difficulty then becomes, let's not say things that we don't do. We come here, we say we're looking for people. Then people respond. They reach out to you. We reach out to you with every detail, link numbers where possible, ID numbers, everything. But there's no response. Now, what becomes a difficulty? Exactly. Let's not be cosmetic about helping. Let's help. That's why I'm asking, what then becomes your turnaround when a person says, here I am. I'm Veronica Mende. Here's my ID number. Here's my link number. I submitted my claim 2016. I had lawyers and everything. There was a determination of my payout and everything. But since then, nothing happened. So that's what I'm asking.
I think that's, yeah. Chair, we would then have to respond back with Rodney Mkabela is the project manager for the call center. I know there are business processes in terms of when people call, what happens to the call, and after how long should you then respond to them. We'll be able to take it up. Well, we can't, I guess the committee will be able to take it up with them.
You can share the details of whoever we can speak with. Because at this point, I am confused. We say this, but in practice, it's not what we tell the people. And that is part of the things that are wrong at RAF. The second thing is that I'm glad that you acknowledge there's a problem, and there's a big problem. And it's not of your own making, you found it there. Now, as a special project person that have found these problems in the system, and you got rid of many activities that were taking place, and some of the activities were just taking money, people billing, and then had mastered their way around the system to make sure they stay and they milk and then they get money as much as possible. Some of them, my colleague listed them: lawyers, medical aid, hospitals, everything. You got rid of that. Great, well done. Now, in doing that, there is always this fallback of an argument. The law dictates the following: that lawyers must be here, this must be there, this must be there. If the lawyers must be insourced or outsourced is another argument. As a special project, which I think your first project was to look into this law, because the enabler of this environment is this law, which was designed to make sure that the environment benefits the few, but unfortunately we all went to school and then now we're all benefiting, and then it becomes a problem. I want to understand what became your special project in changing the legislation, and if you can identify the areas that you targeted and make sure that you change them so that the legislation now is suitable for an environment which will be friendly for the claimants and friendly for government.
The legislative changes were discussed between the executive and the board, and that falls under Ms. Khumalo's purview. So I know that there are specific areas that were targeted. If I can just give over to her to explain the specific areas.
Thanks, Honourable Member. I think I'm sort of caught between a rock and a hard place, because what I will be talking about will be the proposals that you had done with regards to the RAF amendment bill. But as you would know, that the minister has withdrawn it, and they are now introducing RAPs. So with regard to RAPs, I'm not too au fait with that. They've just recently had workshops with the RAF management in terms of saying what they want to introduce on the RAPs bill. So I can't therefore then talk about the RAF Amendment Act proposals, because it has been withdrawn. Thank you.
That's where I was going. That you are aware of the contents of RAPs, because RAPs and what was there before, which was withdrawn, are two different things. So in your workshop, what is it which is in alignment with the mission you were driving in RAF, in terms of making sure that it's a friendly RAF for everyone? Is there any of the things you propose that are in line with what is in RAPs?
Honourable Member, unfortunately I was not at the workshop, but I don't know if I'm putting Nico on the spot to be able to respond to it. If not, then we can be able to put that in writing.
Oh, by all means, Nico, come in.
Honorable Chair, maybe before Nico comes through, because I was at the workshop, I attended the workshop at the Department of Transport, I think about 2-3 weeks ago. One of the things that the Deputy Minister said was that we need to identify things in the RAF Amendment Bill that should be incorporated into the RAPs bill. And that is not a problem. I think the legal team is looking into that, and the legal team of the Department of Transport, to say if there's something in the RAF Amendment Bill that we feel should be, for example, I think the payment in annuities and other things, but maybe Nico can add into that.
Yes, please, Nico, come in.
Good evening, Chair. So I think that's still a work in progress. I mean, I already started looking at it in terms of a task team that had been requested by the Deputy Minister to say that the Department of Transport and us from the Road Accident Fund should form a task team and look at that. We're still in that process. So I don't think it's anything I can speak to currently.
We're in injury time, but ask a few.
So that's where our problem is. And unfortunately, again, Tinaga scope hasn't getting down. But the transport people will have to assist us, because our main problem in RAPs is the legislation that enables an environment which gives people access to the purse through the law. And then that's why you sit here and painfully say it's a very highly litigious place and whatnot, because people want to fall back onto, I am allowed to be here. Allow me to be here because I have experience here, I know what's happening here, even if the person takes more money than necessary, but they know they have the muscle and everything financially to go to court, and then you have to wrestle all of these things at court. If we can fast track, and I know your status, but we just need to fast track that. That will take all of our pain away. The last thing I wanted to check, there's a lady, I forgot her name, who said here, as learned as she was, she wouldn't be able to complete RAF 1. It's very complicated. It doesn't serve the purpose. It's very difficult. She feels for the person in Mutu, that how on earth will they ever be able to complete that form? Give us a picture of this thing, because what we understand is that it asks people to bring information. so that once it's logged into the system, it goes to the determination of the cost, then it goes to the loading of the payment if we all agree, and we don't need anyone else to be here. What's difficult in this form? Take us through, and what is it that it addresses, and that a person ongafundanga, ongazinto, ongazanga esikolweni will not be able to even go past the first 2 lines. Take us through, please.
I would have to go and open the RAF 1 form, but I think the point is currently how one is supposed to lodge a claim in RAF requires a lawyer. I might be able to fill in the form, but I know that there'll be delays and I would need to issue summons. That requires a lawyer. Then there are issues around getting all those medical reports that has to be undertaken. But as it is, the RAF form itself, it's pretty straightforward in terms of what is required. I guess the challenges will be around then having actuarial reports, having medical legal reports, etc., that even myself, I would need assistance with.
Now, this is where the chairperson was going. Because we can't design an environment which is going to require ndizilimalela ndingapha eQwaqwa and then get into an accident, and when I have to go to the nearest RAF office, I need a lawyer that I don't even know where I'm going to find. That he must go here and there and there and there. Why are we designing an environment that is difficult for our people? Because the mandate is to make sure our people are comfortable. But now we're designing an environment that makes the mandate much more difficult for you and for the person who's supposed to benefit. How do we ease this burden?
Sorry, through you, Chair. Is there a change in legislation? As I said earlier, that we had proposed numerous changes to the RAF Act. And I think those are the ones that, as my other colleagues have said, that there's a task team between RAF and DOT. They will then need to convince DOT that we really need to put in the elements that were not there, that are not there in RAPs, that are there in RAF, and be able to substantiate why. We totally agree with you, because we are also saying it should be easy for a walk-in to come and we assist them with filling the form. But unfortunately, we've got the law, and the lawyers, by the way, are the first ones that are going to come after us to say, you are not doing what the RAF Act says you must do. Because as I've stated earlier, to say that we had 30,000 comments around the RAF Amendment Bill. Then comes the RAPS Bill. There's court cases against the RAF Bill by the very same law firms. And when you ask why, they say, no, what would you prefer? They say, no, we want the current RAF Act as it is, because they know it's to their advantage.
Honorable Member, here in extra time. Okay, so can we, just on this, because where Honorable Member left off. So for me, the form is not so much the issue, okay? It's the requirements, the documents that you need to attach, and how much they cost, and the probability of being able to access those medical experts in order to provide. Can you explain to the committee what I think it's called MMI, maximum medical something? Help me there.
Improvement, Chair.
Maximum medical improvement, right? Ms. Khumalo, can you explain to us what that is?
Chairperson, I'm not in the medical space. That's why I didn't even want to finish the MMI, what it stands for.
Okay, that's fine.
I'm treading into a space.
So this is how it was explained to us, that you might get injured, break a leg in 3 places, but we don't actually know how much of usage of that leg you will retain, right? You will regain at some point. So you have to wait until such time that the doctors are like, this is full recovery, it's never gonna get better, right? And it was explained to us by Tsepo that what that means is that now we can move on to the next stage of loss of future earnings and these kind of things, because we now know that you can't go and play for Kaizer Chiefs again, right? Although it might not make a difference given how we are playing right now. But the point is, and I won't belabor the point any further, and I'll just come to the judgments, because I think it's also important that we talk about that, which is an ordinary person has got to work out all of this on their own so that they can lodge the documents. And I end as a comment. I think that's placing an unnecessary obstacle and creating a market for lawyers, in my view. And it's just a comment. Yeah, it's creating a market for, especially the well-to-do lawyers who can afford to pay for these things. They've got deep pockets, right? So that's the thing. I just want us to clarify something. So there are 2 judgments. There are lots on this new way of lodging. Let me put it like that, because there is the rough one. There's the board notice, and then there is also the minister's regulations, right? So there was LPIIF 1, and that is when it was set aside. So then there was the second, the application for leave to appeal. And I just want you to explain to the members here the difference, right? So the court says in paragraphs, I'll read it because I don't think you have it to hand, so I will read it for you. In the course of hearing the application for leave to appeal, it was drawn to our attention that the applicants for leave had been making use of their application for leave to appeal, right, to avoid giving effect to the interim remedial regime ordered by us. Can we first talk about the remedial regime? What did the Gauteng High Court say must be remediated in terms of the rough one form? How did they instruct you? Can you remember at a high level?
And that's why I wanted my senior manager of corporate litigation to come here, because when you get into the merits of the case, I would not be able to engage with you or go step by step with you, as you say, on those.
I also did commercial law 1 and labor relations 1. That's it. Okay, so this is really just from your and I honestly, I'm not gonna get into that conversation. I think we had it last time. That was enough. I'm not gonna get into that conversation. I am accepting that you are not a lawyer. Nonetheless, you have the statutory responsibility of the role, right? Because you are chief governance officer, and one of the areas underneath you is the legal function. I therefore expect you to understand the essence of a judgment, particularly the order itself in terms of what the organization needs to do, right? That's all. I'm at that level. So I'm not getting into the nitty-gritties. I'm just asking, what did the court instruct the RAF to do? Can you recall? I would hope you do.
I don't know if you are... Sorry, Chair.
No, if you don't recall, it's okay. I mean, I won't hang you.
I guess the judgment is there. Do you have the? I guess you have.
Yeah, so let me summarize it. Yeah. So basically, the court said, "Look, this is a complex situation. You've got people who had lodged in terms of the old form. Basically, the people who have lodged successfully in terms of the new form. So their forms are in the system. We've now set it aside, right? So you need to tell us how you're going to deal with these folks. 1, 2. There are the people who were rejected." Because the claim doesn't even register, as we were told, if not all the documentation is there. So then the court said, you need to find those people and tell them to, they must lodge in terms of this order. That's what the court said at the high level. Okay, now we are on the same page. So here's the thing. So the RAF continues, and this goes to continued litigation on whether it is properly founded, given the expense of doing so. And I just want your opinion, your understanding of what the judgment says. So then the RAF applies for leave to appeal, and the leave to appeal is granted. However, the court in paragraph 16, so I'm going to read it because you don't have it, and I'll try and be slow so that I don't slur. In the course of hearing the application for leave to appeal, it was drawn to our attention that the applicants, i.e. the RAF, for leave had been making use of the application to avoid giving effect to the interim remedial regime ordered by us, what you and I have just spoken about. We expressed considerable concern as to this course of conduct. While the applicants for leave are entitled to seek leave to appeal in respect of those orders made by us that they contested in the main application, it is not clear how they can frame an application for leave to encompass the exercise by the minister of her powers to issue the RAF 1 form and use such application to rely upon suspension to avoid the remedial regime ordered by us as it relates to RAF 1 form and its consequence for the administration of claims that fall within the authority of the RAF. While we make no findings at all on this matter, we have nevertheless ordered the CEO of the RAF to file an affidavit explaining the fund's failure to implement the interim regime ordered by this court. Council undertook to prevail on the RAF to file this affidavit on or before the 16th of August 2024. So what the court is saying, and in the Banyane judgment, the court in Bloemfontein also repeated the same point, and I've got it in front of me and I can read it. Basically, it says you are using the grounds of appeal do not impugn the order that we've given. So you are using an excuse which does not apply. So even if you're not challenging the aspect of the court's order that remediates for the claimants, right? That's what the court is saying here. And that's why Elia said we need to slow walk this, because that's how I understand this judgment. Do you have a different reading of it? To say that the court for leave to appeal and the Bloemfontein High Court were both mistaken in their reading of the original order in LPWIF 1. I'm asking because, sorry, and I'm sorry to interrupt, I'm asking because you said earlier that because you've appealed, you therefore staying everything, right? But this judgment suggests differently. So I just need us to reconcile that between us.
Chairperson, from our attorney on record on this matter, when we discussed the issue and we went for appeal, is that in terms of the rules of court 18.1, when we appeal, then the judgment would then be held in abeyance pending appeal.
I get you. I agree. The court is simply saying what you are appealing is not the same as what the court has ordered. You understand? That's what the court is saying. So I would assume, the judges know what you're saying, so that's not an issue.
So, Chair, are you then referring to the issue around the questioning of the your admin decision?
Yes.
Because then in terms of the advice that we had then received, it talked about the Odekral principle, that then an admin decision stands until reviewed and set aside by the appeal that has suspended the review. So the 271 still stands until SCA.
Okay. Was that opinion in that? Because I'm not sure we're going to resolve this, because I honestly hear you. All the court is saying is that the appeal is appealing remember, the minister did not give an opportunity for public comment. You remember? Did not give an opportunity for public comment. The court took issue with that. And one of the substantive matters was that